Well, the time was fixed at 12:30. It is no longer appearing as 12:30. This is that matter where, my lord, my examination in chief was over. They did not avail of the opportunity twice to cross-examine my witness. They did not avail of the opportunity to bring their witness. They went to the appeal court. They were dismissed. So I was humbly requesting your lordship, my lord, to fix this matter on any day, my lord, at a particular time, as it was done last Friday.
Yeah. How much time it take?
Well, we were supposed to start arguments, but I should tell your lordship.
They contested?
Yes, it is contested. They have taken out an application for recalling your lordship's last two orders, by which your lordship, my lord, closed their cross-examination, as also closed their right to lead evidence. That application is also tagged with the suit. I do not know. It is appearing also. So any day, my lord, if the suit appears, if they want to move their application, they will move. Otherwise, I will start my arguments.
Come back. 3:45. 9 September 3:45.
Very well. Let us at least try to make a beginning. I'm mentioning upon notice to the other side.
Item number 99. It is submitted by the learned counsel appearing for the plaintiff that the matter was fixed on
29th August at
2025 at 12:30 p.m. But due to non-availability of this court, the matter could not be taken up for hearing. Accordingly, pressed for fixing another date and time for hearing of the matter. In view of the submission made by the counsel for the plaintiff, let the matter appear on 9th of September 2025 at 3:45 p.m. The plaintiff is directed to, advocate on record of the plaintiff is directed to inform the date to the other side in court of
yes. But I served them notice, but still I shall inform.
Please inform the date.
My lord's kind leave to mention two matters, lordship. One is I'm praying for drawing up and completing the decree passed by my lord on 18th August, lordship. And the second matter, lordship, it is a commercial division matter filed on 18th of July. Till date, it has not come on board for presentation of plaint.
Presentation of plaint, it has not come.
No, lordship.
File aaya.
Lordship, may I be permitted to mention serial number 62 of your lordship's list today? It is an execution matter, lordship, where the judgment, lordship, will remember in respect to a suit of 1997, lordship, where the works contract, lordship, will remember. Now, lordship, the execution I have filed last month, I'm only praying that it may be upgraded and may be scheduled at a particular time. I'll only take 5 minutes. I'll be seeking attachment of the amount lying in the account of the state of West Bengal, lordship, because it's been a long time, lordship, because I have served notice upon the debtor, the decreed holder.
Okay.
Judgment debtor.
You see the list, and the next within a couple of the days, the execution case will come up.
Lordship will only may it be scheduled. I'll only take 5 minutes, lordship. It's just in the direction.
Okay. Execution case pura hai na?
I have served upon the judgment.
What do you want?
Lordship, may it be scheduled at any time, lordship. I'll only take 5 minutes for appropriate directions for attachment of the amount, lordship. This is a suit of 1997, lordship, will remember.
Who is the authority? Executive engineer?
Yes,
The
lordship, the
pretending
department.
engineer?
Lordship, the department is.
Okay, great.
Or may it appear as to be mentioned, lordship, in tomorrow.
Let's just काम करो. 9 तारीख 8 तारीख को to be mentioned. Monday to be mentioned.
I'm grateful.
Yes.
May I be permitted to mention a new chamber application praying for inclusion in the list. Matter was supposed to appear yesterday, it has not come. Only inclusion.
I'm
Yes.
independent.
May I be permitted to mention a matter? There's some difficulty. This matter has been mentioned yesterday. These are three originating summons matters. Mr. Rupak Ghosh, I think, has mentioned
Yes,
them.
he mentioned the matter.
I must point this out. This was before another court where it was released, where I had opposed. Now, I had given them letters, saying that give us a copy. They have refused. But I was only submitting, I have a leader also in the matter. This your lordship has fixed for Thursday. Both of us, both Mr. Banerjee and me, we are not there. But if it could be on Monday, I was just seeking your lordship's kind indulgence. Thursday, my lord. It was Thursday.
कितना बजे? Which was the other? You are.
I've given a note.
Which was the other?
I've given a notice, my lord. If your lordship wants, I can bring him at 1:15. If your lordship wants, my lord, I can do that. Notice has been given, my lord, by mail, my lord.
Let Mr. Ghosh or is any of
Once
the
I will inform him, my lord, if I can get him, my lord. I'm sorry, my lord, I wouldn't have, but
no.
my lord,
Let
we had
them
already
come,
given
then
the,
we'll say in presence of both the parties. Then
because my lord, they had mentioned without notice. That's
yes,
why,
they
my
have
lord,
mentioned. That's why he kept it.
my lord, obviously, my lord, I'm not, my lord, no aspersions, my lord. But no 5 minutes here, my lord. My lord, Miss Addo gave me a lordship, my lord, 5 undertakings of 5 minutes each. My lord, very good.
Okay. My lord, kindly leave my lord to mention, my lord. TC number 102 of 2025. This is a contempt application, my lord, from your lordship's order dated 29th of August 2024 in an originating summons suit, as your lordship was then taking at that given point of time, my lord. Now, my lord, I was humbly seeking your lordship, my lord, if the matter could be included in the list, my lord, because it's been a while that we have filed, but it has not come up in the list. Non-commercial matter, my lord.
But my to Wednesday रखो. And Friday.
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 I would be out of luck this Friday also, my lord. I would be out of luck this Friday.
Why?
Because, my lord, it's a holiday.
Acha.
Your Lordship, may I be permitted to mention a matter? This is an execution matter. On the last occasion, Your Lordship had issued warrant against the judgment debtor, Your Lordship. It's my mistake. I should have indicated that the judgment debtor is a company, Your Lordship. I'm praying for a slight modification of the order, Your Lordship. Kindly keep it on the to be mentioned.
Commercial matter.
Yes, Your Lordship, commercial matter.
To be mentioned, my God.
May I be permitted to mention, my lord, item number 233 of your lordship's list, my lord, by an order.
43.
Yes, my lord. It was, my lord, fixed on, my lord, 26th of August for witness action, my lord. Since, my lord, the bench was not available, my lord, it was not taken up. I was praying, my lord, if your lordship kindly fix any other day, my lord. This is the last order, my lord.
Which was the other side?
My lord, it is ex parte.
Ex parte. What is the what? Witness action?
Yes, my lord.
How many witnesses you are having?
I have one witness only.
What is the suit? Recovery?
It's, my lord, recovery of money.
Okay. 28th October. What time? 233, yeah? Serial number 233. Counsel for the plaintiff submit that the matter was fixed on 26th of August 2025 at 2 p.m. for witness action, but due to non-availability of this court, the matter could not be taken up for hearing. Accordingly, prayed for fixing another date and time so that the plaintiff can bring the witness for examination. In view of the submission made by the counsel for the plaintiff, let the matter appear on 28th of October 2025 at 3 p.m. for witness.
May I seek your lordship's kind leave to mention
Yes.
an execution application, your lordship, at the cost of being severely reprimanded. I must indicate, your lordship, on the last occasion where I had mentioned, I'm for the judgment letter number 4. Your lordship, had, by an order dated 18th of August 2025, had issued the warrant of arrest because the affidavit of assets were not filed. What has been showcased as a rather callow approach from our end, your lordship, if I may just indicate, your lordship had directed the judgment letter to be present in person today, and your lordship, subsequently, I must also indicate that the service that has been effected upon me, that address, your lordship, I am no longer residing in that address. I have only come to know from other judgment letters who have been arrayed, your lordship, from them that the warrant has been issued. Your lordship, may I just pray that the warrant against me, your lordship, may not be effected. I am present today. 9th is the returnable date for filing of the affidavit of assets. Lordship, the person concerned is a septuagenarian. Your lordship, he's just been released from the hospital on account of certain mental health issues.
So what you want now?
Your lordship, just the warrant, your lordship, because
Okay,
I'll be
come on, 9. Come
because
on.
in the meantime, your lordship, the police will come and take me into task. So that is the predicament
What can
that
be done when the warrant is either he has to surrender,
your lordship, he's here
or
today.
you have to file an application
Lordship,
for
he's here.
recall.
The client is here today. Your lordship, he's been suffering from some illness, your lordship. For
File is not here.
Your Lordship, if I may just come back at 1:15.
I wouldn't like to cast any aspersion, but my lord, your lordship will follow that there's a very strategic chain of events which is flowing. Yesterday there were two of the judgment letters who had come up, now the rest, and citing that
that one.
that
It's
matter.
a set.
And they have chosen not to appear, my lord, despite the writ of summons having been served and the written statement filed. Thereafter, they have discontinued their presence in the
That's
suit.
one.
We've never appeared in the suit. As per judgment letter number
Bangladesh.
4, we've never appeared in the suit, Your Lordship. I had mentioned 1.5 weeks back, so I should not be subsumed in the so-called strategy that is being portrayed to Your Lordship. Lordship, just I'll come back at 1:15, should it please Your
But
Lordship?
how
Or
can
4:30, Your Lordship. Just to
what
the
is your submission?
I would first, my lord, the something has to be on board. Nothing has come up as of now.
the affidavit of assets, Your Lordship, will undertake to file it in a few days,
When?
Your Lordship. The returnable date is 9th, Your Lordship. Your Lordship, on this I'm saying with some sense of temerity. Person concerned is not in a position right now, Your Lordship,
काम
to
करो उसका to be mention में करके ये supplementary list कर दो कि ये 12:30 मैटर है 1 बजे भी है 2 बजे today there is no 3:30.
I would assume, my lord, today there is none, but there can be perhaps on Thursday.
क्या करेंगे 4 बजे 3:45 है क्या है can he come tomorrow?
Your Lordship, he's staying in Bardhaman. I'll just indicate to Your Lordship for reasons of propriety, let me not mentioned aloud.
That is the problem. The clients are not coming. Once
Your
the court
Lordship,
has issued
no,
the
Your
warrant
Lordship,
and all
I
these things,
absolutely
all
bow
are
down, Your
coming.
Lordship. Just and this, Your Lordship, I'm taking it upon me, Your Lordship, to submit. Lordship, he's not in the right mental frame, Your Lordship, because Your Lordship, he was released. He's
So you all will pray to for changing of the
no,
determination.
I'm just praying for Your Lordship's charity, just in this case, nothing else, Your Lordship, nothing else. If it's Your Lordship's wish, of course, he'll be here.
1:15 में करो come at 1:15.
150.
Grateful to you.
Lordship, may I permit to mention a matter? Your Lordship, I'm praying for drawn up and complete the order and judgment dated of 25th of June
What?
2025. I am praying for drawn up and complete the order dated 25th of June 2025.
Give. Yes. Order is set aside, remanded the matter back to the authority for reconsideration with the direction to dispose of the matter within 6 months. And it is also directed Deputy Controller who has passed the order, he should not be assigned the matter.
Grateful, my lord.
Application dismissed. In view of the above, the defendant is allowed to amend the written statement as proposed in the amended written statement by disclosing the document as relied by the defendant, except the paragraph 2 of the proposed amendment.
Except paragraph 2 of the
Paragraph suppression of fact. They have taken the plea of
only one indulgence. Your Lordship would kindly mention specifically that the proposed amended written statement annexed to the supplementary affidavit.
Okay.
Because, my lord, there was some error where your a coordinate bench, my lord, predecessor of your Lordship, my lord, indicated that we should be filing a supplementary affidavit. So, in the application, there was a proposed amended written statement, but in the supplementary, we had corrected that mistake. So, as per the proposed amended, that is already mentioned.
That's why, in view of the above, allow the amended written statement as proposed in the amendment.
As proposed in the proposed amended written statement annexed to the supplementary affidavit, not the application. That is the only thing.
Supplementary affidavit.
Yes, there was a supplementary affidavit because there was some mistake in the list of documents. There was some typographical errors, so that is why, my lord, we were granted leave.
By disclosing the document is
I'm grateful. I'm so grateful.
But I have not allowed this
That
paragraph to be
I
subsection of
understand.
fact.
I understand.
For your lordship, this is my application under Order 12 Rule Section for the plaintiffs.
You are for the plaintiff. What do you want?
Your lordship, this was fixed for judgment.
It is to be dismissed.
No, your lordship.
In view of the plaintiff is entitled to get a decree of rupees 20,69,249 along with the interest at the rate of 12% per annum from 2nd February 2021 till the realization.
I'm very grateful to
Your Lordship, I'm appearing on behalf of the petitioner. Cross examination is chief has been concluded. Cross examination is going on. 26th August is to submit. Kindly give us some more time so that we can proceed with the
For what?
for two.
My lord, we are for the defendant, my lord. We are on the part of cross-examination of the plaintiff's witness. My lord, twice, my lord, we have done it, my lord, on 2 dates, my lord. However, the plaintiff's witness was unwell. My lord.
It is going before
So,
the
my lord,
commission.
yes, my lord, it's going for the commission, my lord.
So the plaintiff witness is going on.
Yes, my lord.
Plaintiff witness is going on.
Yes, my lord.
We are for the plaintiff.
No,
How many witnesses?
defendant.
We are for the defendant. We are for the plaintiff, my lord.
One.
This is only last.
Yes.
And you will adduce.
Yes, Your Lordship.
You will adduce the further evidence. You will defend number.
We will.
I do not have instructions, Your Lordship. I need to take instructions from my client regarding the same.
So how much time will take, Mr. Malik, for
My
cross-examination?
lord, we.
Matter is, as per the order dated 6th May 2025, the commissioner was directed to file a report by 26th of August 2025. Counsel for the party submitted. Still the cross-examination, the plaintiff witness is going on, and the parties required further time to complete the cross-examination of the plaintiff witness. In view of the submission made by the counsel for the parties, time to file report by the commissioner is extended for a further period of.
My lord, till January, I would request, my lord.
Oh, no.
But it will be.
Till 28th of November 2025.
Grateful.
My lord,
The matter appear on 20.
can it be, my lord, can it be in December? The reason is that, my lord, there is a holiday in between. There'll be a 1 month holiday in between.
Taking it a holiday, then I have given further one year 4 weeks. This year 4 weeks.
My lord, kindly, my lord. Kindly, my lord, holidays are there, my lord knows, my
Till
lord.
December.
Grateful, my lord. Grateful.
If I appear on behalf of the plaintiff, the London Commissioner was supposed to file the report.
Eh?
The London Commissioner was supposed to file the report, Your Lordship. Evidence has been concluded.
But finally, both matters done. My lord, first is, my lord, the report. Then there is, my lord, a compilation of depositions. And, my lord, I have also prepared a compilation of correspondence exchanged. The reason being, your lordship has been pleased to close the evidence. Now, there have been several instances where several adjournments have been taken. So I think it would be right on my part, my lord, to include that. May I hand up a copy to my learned friend appearing for the
Who is for
plaintiff?
the defendant?
They are not appearing. I have kept, my lord, should I keep a copy in the records? Or,
Yes.
my lord,
But Your Lordship, the last
give it
order,
here.
the paragraph 5,
it-
5, Your
defendant
Lordship,
is not a copy.
since August 23, the defendant is not appearing in this matter, 20th June matter. So, someone appeared, sought leave to file a wakalatnama, not yet filed.
Yes. So no further evidence.
Your Lordship, it will be fit for argument.
Learned Commissioner has filed the report consisting of
Data these are it.
consisting of
The informal letter.
আমার কাছে আর নেই কেউ।
compilation of deposition of the plaintiff witness number 1 and 2, and compilation of the correspondences exchanged between the commissioner and the parties. Let the same be kept with the record. Counsel for the plaintiff submit that he will not adduce any further evidence. Accordingly, evidence on the side of the plaintiff is closed. Full stop. It is found that the defendants are not appearing in the matter. Let the matter appear for argument.
But only two humble submissions. Would it be your lordship's pleasure to record that I have kept a copy for the defendants in the records? That is one.
As regard the copy of the defendant and the learned commissioner has also filed the copy of the report of the defendants. Let the same be kept.
And also the depositions, compilation of the depositions.
The same set of the report.
Same set of the report. Not the correspondence. Correspondence I've only brought for your lordship's notice.
Learned advocate commissioner has filed the compilation of the deposition of plaintiff witness number 1 and 2 as well as the report for the learned counsel for the defendant. Let the same be kept with the report. Please कब रखेगा argument?
The commission discharge.
As the commissioner has completed his work by filing report, remuneration paid.
Yes.
Accordingly, the commissioner is discharged from the instant case. 29th October.
Only one thing, remuneration is paid by the plaintiff.
Defendant has
does not pay. They had appeared in a few of the sitting, but so that has not been.
So it is to half, then you have to pay. As the defendant has not appeared and not paid the remuneration of the commissioner, accordingly the plaintiff is directed to pay the remuneration of the commissioner. It is made clear that in future the defendant will appear in the matter. The share of the defendant and the payment made by the remuneration made by the plaintiff shall be recovered from the defendant. 29th October at 3 p.m. for argument.
I'm ready.
Next.
Item number 7, Your Lordship. I'm appearing on behalf of the plaintiff in this matter.
The defendant.
And I'm instructed to withdraw this matter. And there's my written communication by my client.
Yes, record and order. Learned counsel for the plaintiff submit that the plaintiff has sent a communication dated 25th of August 2025 to the advocate on record, informing that the plaintiff is not interested to proceed with the matter and requested to withdraw the suit from this court. In view of the communication dated 25th of August 2025, learned counsel for the plaintiff prays for withdrawal of the suit. Consider the submission made by the counsel for the plaintiff and peruse the communication dated 25th of August 2025, CS Form 807 of 2024, within, what is the new one? Of 2024 is dismissed for default, is dismissed as withdrawn. Full stop. The communication dated 25th August 2025 be kept with the record. Accordingly, our interlocutory application, if any, is pending, is also been treated as disposed of.
I'm grateful, Your Lordship.
For the plaintiff,
what report? Advocate signature is missing. Decretal amount should be written in the word. Author. There are nine.
I thought it was some other reason.
There are 9 defects.
Well, we'll remove it. But gives you 2 weeks time, we'll remove it.
The matter is listed as to be mentioned on receipt of a report from the office of the London Master. It is fine from the record. At the time of a scrutiny of the plaint, the department has found altogether 9 defects in the plaint. Accordingly, counsel for the plaintiff prays for 2 weeks' time to cure the defects as pointed out by the department. In view of the submission made by the counsel for the plaintiff, leave is granted to the plaintiff to rectify the defects within a period of 2 weeks, and the plaintiff is also given liberty to re-verify and reaffirm the affidavit.
And we'll do it by the 10th, my lord, because 10th the application is coming, so we'll do it by the 10th, my lord. 9th, by the 9th.
10th of September.
By the 9th of September, my lord.
We will do.
Because, my lord, 10th, my lord, the applications are coming up. My lord, I do not know, my learned friends might take a technical point again.
Not 2 weeks, by
9th.
By 9th of September, 2025, and the plaintiff is also given liberty to re-verify and reaffirm the affidavit of the plaint in the
Very grateful. Sorry, my lord, I asked for 2 weeks. Grateful.
I did tap you for the plaintiff, my lord. And upon scrutiny, my lord, may some different action raised by the department, my lord. Leave be required for correction of the defects.
Yes.
My lord, there are certain.
How much time?
2 weeks, my lord.
Yes, record. The matter is listed as to be mentioned on the report, on receipt of the report from the office of the London Master. It is found from the report that on scrutiny of the plaint, altogether 6 defects have been found. Counsel for the plaintiff prays for 2 weeks' time to rectify the defects. In view of the submission made by the counsel for the plaintiff, the plaintiff is granted 2 weeks' time to rectify the defects as pointed out by the department. The plaintiff is also given liberty to re-verify and reaffirmation of the affidavit of the plaint in the meantime.
One direction, if my lord is clarified that regarding that issuance of lodge of summons, my lord, that is now need to be done within 14 days, my lord, unless my lord, it is clarified by the department.
It is made clear that immediately after the ratification of the defects and re-verify and reaffirmation of the affidavit, the plaintiff will take appropriate steps for issuance of writ of summons. Yes.
My suit, my lord, praying for leave under clause 12.
Again, Shamsil.
I don't know any other suit. But this is after mediation, suit for recovery of money on accounts of goods sold and delivered. Plaintiff is within, the defendant is outside. But the contract was concluded within, and the money is payable to the at the office of the plaintiff, which is within.
When the last payment was made?
The last payment. Sorry. But I'll tell my lord now.
21st of August,
21st August
2022.
Yes. No, no, thereafter, my lord, I had supplied materials from 27 November 2022. And thereafter, my lord, they have stopped payment.
Cause of action?
My lord shall take my lord paragraph 18 of my plaint. This is the clause 12, and one of my cause of action is pleaded in paragraph 12 and then paragraph.
What you prayed for?
19. Lord, I'm praying for leave under clause 12 of the latest plaint.
Why? Outside. Defendant outside.
Defendant is outside. Although the contract was concluded at the office of the plaintiff.
The plaintiff has filed the present suit praying for a decree for a sum of rupees 29,00,825 along with interest at the rate of 15% per annum. Full stop. The plaintiff has also initiated the pre-mediation process, but the defendant has not come forward, and according non-starter report has been filed on 10th of July 2025. Counsel for the plaintiff submitted the plaintiff is within the jurisdiction of this court and the defendant is outside the jurisdiction of this court, and part cause of action arose within the jurisdiction and part cause of action arose outside the jurisdiction of the court. Accordingly, prays for leave under clause 12 of the latest patent 1865. Had the learned counsel for the plaintiff peruse the materials on record. This court finds that the part cause of action, the plaintiff is within the jurisdiction and the defendant is outside the jurisdiction, and part cause of action arose within the jurisdiction of this court and part cause of action arose outside the jurisdiction of this court. Accordingly, leave under clause 12 of the latest patent is granted. Plaint is admitted, subject to scrutiny by the
Great.
11, my lord. I am for the plaintiff, my lord. This is my suit, my lord. Suit for recovery of money, my lord. The plaintiff is involved in the business of manufacturing TMT bars, my lord. The defendant had proposed to the plaintiff that after installation of the automation system by them, the burning fuel consumption will be reduced. Installation of the automation system produced by the defendant. They will install the same in the factory of the plaintiff, and the same will reduce the burning fuel consumption of the plaintiff factory. But it had opposite reactions, and thereafter, my lord, that is why the suit has been filed. Purchase order was issued by the plaintiff from the office of the plaintiff located within the jurisdiction, and the defendant is outside the jurisdiction. But it has come up.
When you supply the materials?
Not materials. I have obtained the automation system.
Yes, when you have
purchase order was of 2023.
2023.
Yes. Proposal was given by them on 8th April 2022, and it was accepted on 30th June 2023. That is at para 4 of my plaint.
Remediation?
Mediation is at page 113. Non-start.
The plaintiff has filed the present suit for recovery of amount of rupees 3,43,40,704 along with interest at the rate of 18% per annum. For the plaintiff submit that the plaintiff is within the jurisdiction of this court and the defendant is outside the jurisdiction of this court, and part cause of action arose within the jurisdiction of this court and part cause of action arose outside the jurisdiction of this court. The plaintiff has also initiated remediation process, but it was ended as non-starter report. Accordingly, the plaintiff has filed the present suit with the prayer for leave under clause 12 of the latest patent 1865. Had the learned counsel for the plaintiff peruse the materials on record, this court find that the plaintiff is within the jurisdiction of this court and defendant is outside jurisdiction of this court, and part cause of action arose within and part cause of action arose outside the jurisdiction of this court. Accordingly, leave under clause 12 of the latest patent is granted. Plaint is admitted, subject to scrutiny by the department. Next.
May I have my lord's kind leave to present a plaint, but I am praying for leave under section 12A.
Well, why?
12A. My lord, the urgency is that, my lord, the defendant was given, my lord, a leave and license for 11 months. They are running a restaurant from there. Out of the 11 months, they have paid rent for only 2 months. Rent holiday.
Agreement for 11 months.
For 11 months, they have paid rent for only 2 months.
Yeah.
Now that period has expired by efflux of time.
Correct.
So they anyways have no right to be in the property.
Correct.
But now we have come to learn that because they don't have a defense, they really are wanting to induct third parties and give it out for franchisee. So that is the urgency, and the application is also in my lord's board, my lord, today, GA1, where I am as of now, where I shall only be pressing for an order of injunction restraining from alienation. The other press I can come back, my lord, we can all come back and thrash it out later on. But the injunction is necessary so that any third party interest is not created. That is the whole urgency.
GA1, my lord, I am on caveat. My lord, I have been served only on, my lord, yesterday 3 o'clock in this matter. My lord, there is already a prior suit which I have filed in the city civil court. The injunction matter is being heard in the city civil court. All those facts have been suppressed.
No, I have annexed.
My lord, he may have annexed,
I have
but he has
annexed.
not said that the injunction hearing is going on before.
No, I have annexed. I have said that there is no
orders are not there.
I have annexed.
You have filed?
My lord, I have filed a suit. My lord, what has happened is, after giving out the property, my lord, for basically commercial purpose, what they did is, my lord, after a while, they cut the electricity, the water connection.
Not only one humble submission, your lordship would hear my learned senior friend, while the injunction, in the plain presentation, he possibly will not have a right of
He
ordinance.
said he wanted to move that.
Presentation, if there is a prior suit.
I'll show. I've annexed that. I shall show from that.
So
I shall.
why 12A?
Yes, I shall show that. I'll show why, my lord, we have come. If your lordship kindly takes a look at the plain file in the previous suit.
What is the injunction paid in that?
Yes, I have annexed that. I have also annexed that, my lord. Kindly see page 77.
Page 77
of the injunction application, my lord. I have my. G8
77.
My marking is from the G8 to them. G8 if your lordship kindly takes a look at from the application, annexures are same.
This
Page
is
numbers
actually 86, I think, of the.
It starts from 77.
77.
Yes. Kindly see page 86.
Yes.
Kindly see prayer 1 at page 86. This is the due process of law. I'm filing the suit.
Injunction receiving defendant party, they must necessary hosting the plaintiff petition.
Without, so I filed a suit due process of law. And in any ways, my lord, the agreement has expired by a flux of time.
Correct.
Now, my lord, 2, kindly see prayer 2. That, my lord, running smoothly without water supply that was stopped for 1 day due to some disturbance that is restored. Kindly see prayer 3. But this is only a suit to preempt non-payment of 3.5 lakh rupees of monthly rent, which they are liable to pay plus GST per month.
Okay.
They have defaulted. That is why they have done so.
Okay.
So, my lord,
you go to the civil court, you file an application.
but I cannot go to the civil court.
Why?
Because my lord, this is a commercial division. My lord, and my lord, there is now, my lord, your lordship would see that, my lord, here, my lord, I have filed this suit. My lord, the actual claims would be much in excess because, my lord, 3.5 lakh rupees per month. Plus, after the expiry, the agreement provides double that amount as a penalty.
Correct.
So, my lord, I need not file a separate suit. My lord, for I can file a separate suit. I need not file a counter claim for eviction. But just because they have chosen that forum, but I can file a suit before this court, because the agreement has expired by a flux of time. He is claiming the right under the agreement. Now the cause of action is separate as a trespasser. So my suit is any which ways otherwise also maintainable.
Okay, let me see. But Y12 is
yes, Y12.
Yes, file the suit. Then you go to the
yes, Y12.
Yes.
Your lordship would see. But I have mentioned from out of the 11 months, they have paid for rent for only 2 months.
Correct.
There has been a default for all other months.
Correct.
Checks have been dishonored for either insufficiency of funds or payment stopped by drawer. Kindly see now if this conduct is there.
No,
but
you kindly come to your suit.
Yes.
Paragraph 20.
Paragraph 27, I have mentioned that.
27, that is a commercial dispute.
And 28, kindly see page 141. This is my urgency.
It's urgency, but he has already filed a suit.
But he has filed a suit. Your lordship has seen the prayers. Not to evict without due process of law.
Correct.
Not to stop the water supply. I have not stopping the water supply.
Correct.
They are running the restaurant full swing. But they are enjoying a rent holiday throughout. But with that type of a litigant, and on top of the fact that the agreement has now expired by a flux of time, he does not have a right. He is a trespasser.
That is matter. But with regard to how the 12A will.
But 12A so that they do not alienate now.
Because they will alienate come to the.
But if they alienate in the meantime.
If they will alienate, you have right toward the city civil court.
But then it would result in multiplicity. But yes, we are apprehensive because of their conduct. When we give the notice. But when we give the notice, then and there, people have started to come.
Because they have filed the suit.
Yes.
The question of subletting does not arise because he is the plaintiff, he is the tenant. He's treating him as a tenant in the premises in question. How he can sublet that?
He can sublet illegally. I'm not saying he has a right. He can sublet illegally. The contract specifically bars subletting. He can sublet illegally because he does not have a right anymore in law. After the expiry of by a flux of time.
The matter.
Yes, but your lordship would see that this agreement.
Well, how the urgency?
Your lordship would kindly also take my injunction application once. 2-3 paragraphs I shall trouble your lordship with, and then I'll leave it to your lordship. Kindly takes a look at paragraph 26 to 29 of my injunction application. Well, this defendant is unscrupulous, my lord, in his conduct.
That is your interim application.
But kindly see paragraph 26 at page 6.
But in the suit only 28 on 28.
Only but that is my apprehension that he would create a third party interest, my lord. That is my whole apprehension. Otherwise, that facade of a city court suit, they are wanting.
If the city suit,
but city court suit, then it's a commercial property. Then how could that suit have been filed? It's a commercial property, 3.5 lakh rupees rent. That is filed without any 12A. So they can enjoy one way, my lord. They are enjoying one way. But when it comes to me, then the objection comes that why without 12A? Now, City Court, if their submission is that there's a commercial division, then they ought to have taken the 12A leave. There's not even a prayer for 12A. That suit either way is non-est because it concerns a contract for non-residential purpose. Kindly seize their prayer. Plaint in the City Civil Court suit. My lord will find that. In the body, my lord, kindly seize page 78. They have, my lord, prayed for a declaration. Page 78, the prayers have been set out. And this concerns a commercial property. Suit exclusively used for non-residential purpose. Then how could that have been filed, my lord? If I may humbly ask this question to myself, my lord, how could that suit have been filed before the City Civil Court without a 12A? But admitted position, this agreement is for running a restaurant. So it's exclusively used for commercial purpose. The, my lord, rent is 3.5 lakh rupees plus GST, which is close to, my lord, 4 lakhs. Now they can file a suit in the City Civil Court without any 12A leave. And when I am saying that, my lord, this is the urgency, because they are, my lord, wanting to, my lord, create third-party interest. So that is why, my lord, your lordship would kindly consider, my lord, granting that. My lord, because of the conduct also, kindly seize their conduct. They have not been paying. They have filed a preemptive suit.
Please to appreciate.
Yes, my lord.
Okay. It is correct. The agreement is over due to effects of time. Correct. He has not paid. Okay. But simultaneously, they have filed a suit.
Before the expiry of the agreement.
Whatever it may be.
At that point of time, their right ought to have.
Is treating as a tenant to the premises in question.
Yes.
Correct. And they ask for some relief before the rightly or wrongly, whatever it is. Now, you have filed this suit praying for a leave under section 12A on the ground that they may let out to the some 30. Once they have filed the suit,
I bow down. What is falling from your lordship? Kindly
the court can think that yes, they will.
I understand. I understand what your lordship is. Kindly permits me to come back. I shall place a judgment on the specific point that when there is a prior suit between the same parties, 12A is not attracted. A coordinate bench judgment of this honorable court I shall place when there is a prior suit.
No, I am not on the prior suit. I am on that the urgency which you seek.
Urgency is the difficult.
I am not that the prior suit is there, leave it cannot be granted. That is not the thing. My question is that this is with regard to the premises in question. You are asking the urgent relief and 12A dispensation of section 12A because they may induct or alienate the property to third party. Once the other party is already initiated a suit praying for a permanent injunction, whatever it may be, where is the apprehension that they will alienate the property?
Yes. But to that minute, may I answer one thing? Their suit, the reliefs claimed is completely different. That I should not be disturbing him. That pendency of the suit or any injunction in that suit would not affect his deeds of transferring it to somebody else.
Come tomorrow.
I'll come. Great.
Not today.
This has been
As
filed
per-
only escaped.
As per the prayer made by the counsel for the plaintiff, case adjourned, let the matter appear tomorrow under the same heading.
I'm grateful.
Next.
14, I am appearing for the HDFC Bank respondent number 11 in the virtual mode.
The lordships have been hearing the main matter. There's the GA number 7 which can be disposed of. The written statement of defendant number 18, which is the CDSL. That was filed on the 119th day. With your lordship's leave, it has been filed, but it's subject to, of course, the delay being condoned. This application is seeking condonation of such delay.
GA7?
GA7.
Have you received copy? Defendant number 18?
Yes, 18.
Yes, madam. What is the contention on that?
My lord, we don't have any objection. I haven't seen the application, but
So I am disposing of this today. I don't think you will continue because only 15 minutes is there.
Okay.
my lord has a matter fixed to that.
Fixed matter है? नहीं है?
नहीं है, मतलब fixed matter is that
Matter नहीं है? Then
It's
okay.
it's a 12:30. Fixed matter is at 12:30.
Lordship, I have a similar application for respondent number 5 and 6 being GA 5 and 6, Lordship.
You
My written statement was also filed on the 118th
यहाँ
day,
रख दो।
Lordship.
और एक काम करो, जो भी रिटर्न स्टेटमेंट फाइल हुआ है डिपार्टमेंट से मंगा लो, फाइल हुआ कि नहीं इन द मीन टाइम। यस
My lord will kindly come back to the list of dates, my lord, pertaining to the respondent number 11.
11.
Yes, my lord.
Yes.
I'm for the 11.
This, my lord, is the most comprehensive one because, my lord, the majority chunk I have shown was lying with HDFC Bank. That's the respondent number 11. And this, my lord, here I had placed, my lord, till serial number 46, my lord.
Yes,
I'll start
46 you completed.
Yes, I'll start with 47. Before I start with 47, my lord,
Yes.
if petitioner's the affidavit in reply to our 13th affidavit in opposition, my lord, that can be handled. Affidavit in reply affirmed by Madhav Prakash Mohta, April 25. Date ta nahi hai matlab se. To R13 है लेते हैं. Reply to affidavit of R13. नहीं, এটা R12 है, R13 है. My lord, kindly takes up page 29 from this affidavit, my lord, and we'll read it along with the list of dates. Item number 47, my lord. My lord will note, I have made an application, a separate application here in this proceeding also for disclosure of the forensic audit report. There are no affidavits there too. But in this particular application, wherever I had referred to the forensic audit report and the need for it to be produced before this court, the consistent stand of all the respondents has been that I do not need to know the contents of the report. It does not concern me. It is there's a private things that are relating to the respondent numbers 11 and the respondent numbers 1 to 8 and others. My lord kindly sees item number 47. On 7th of April 2022, respondent number 13, this is the National Stock Exchange, my lord, disclosed the forensic audit report before the Bombay High Court in commercial suit number 136 of 2021 and sought interim orders against the related parties of respondent number 1, which were allowed, my lord. So, my lord, this is a suit filed by NSE itself in the Bombay High Court against BRH and its related parties, where more and more related parties, my lord, as and when they were found to have been involved, they have been brought in and orders were passed against them. And based on this forensic audit report, my lord, I'll draw my lord's attention to page 29 of this affidavit in reply that was just now handed over. My lord, kindly see, this is an order passed in interim application number such and such in commercial suit number 136 of 2021, National Stock Exchange of India Limited versus BRH Wealth Creators Limited and others. My lord, I'll just place a bit of this order to show how the forensic audit report is actually very important in our case also. NSE itself, however, has denied to disclose it. This application is taken out by the plaintiff applicant for interim relief qua defendant numbers 5 to 7 who came to be impleaded as party defendants by order dated 13 January 2022.
By an order dated 21st December 2020, this court was persuaded to grant order in terms of prayer clause 1, 2, and 6 of the paragraph 71 of the interim application, the different numbers 1 to 4. They read as under, my lord, will not place the release basically by disclosure of all assets and properties, including movables, immovables, or all securities, investments, and everything else by BRH, other sister companies of BRH, and the directors of BRH. My lord kindly comes over to para number 3 at page 31.
Yes.
The court was persuaded to grant the relief as it was considered that the interest of justice would be served better if orders of protection were formally passed by the court, reserving the right to SEBI as well as the exchanges, including the plaintiff herein, to take steps in the matter. The observations made in paragraphs 3 to 5 of the order dated 31st December 2020 encapsulate the mischief and the necessity of the interim measures ordered by the court. They read as under. In pursuance of these directions and their bylaws, including bylaw number 11, 23, and 28 of Chapter 12, the plaintiff exchange, my lord NSE, has filed the present suit against the defendant number 1 member and defendant numbers 2, 3, and 4 as the latter's closely related entities involved in instances of misconduct referred to above. In view of these facts, and particularly in the face of important admissions on the part of defendant number 1 referred to below, the plaintiff has moved the present application for attachment before judgment. So, my lord, there's an attachment before judgment order passed in the suit. The defendant number 1 has admitted that securities belonging to third parties have been sold and dealt with inter alia by way of pledge. Exhibit M to the plaint. No doubt, defendant number 1 has also claimed that when the securities were either disposed of or dealt with by way of pledge, it had the requisite authority of the respective third parties. That, my lord, is one limb of the argument that has been advanced here. The other one being SEBI circulars at that point of time permitted this act to be done. That, however, is a matter of trial and cannot be decided at this stage. Defendant number 1 has also admitted that data submitted by it to the plaintiff in response to inquiry proceedings, particularly concerning its access and their sufficiency to deal with various third-party claims, contains mismatch with actual facts of the case. Defendant number 1 no doubt speaks of some explanation in this behalf, but that is also a matter of trial and need not detain us at this stage. In the light of the foregoing narration, a case for ad interim release has been made out by the plaintiff. The defendants have at this stage no defense to offer save and except to claim that their assets have been duly protected under orders passed by SEBI, which are briefly referred to above. Even if there is some protection so far as assets are concerned by various orders of SEBI referred to above, it is clearly in the interest of justice that the plaintiff must be permitted to resort to and seeks remedy before this court in the facts of the present case. Interest of justice would be served better if orders for protection are formally passed by this court, reserving rights unto SEBI as well as the exchanges, including the plaintiff herein, to take steps in the matter. Now, my lord, para 4, the applicant NSE moved an application for amendment on the premise that defendant numbers 5 to 7 were related parties. The basis of the application, my lord kindly notes, to proceed against the defendant numbers 5 to 7 is the forensic report prepared by Ernst & Young dated 26th February 2020, entitled The Project Fiscus Report BRH Wealth Creators Private Limited. The learned counsel for the plaintiff invited the attention of the court to the entities listed in the said report, which are potentially related parties. The defendant numbers 5 to 7 have been shown as potentially listed parties along with reasons which would justify such prima facie inference. The report inter alia records that upon an analysis, it appears that pledging of the securities done by defendant number 1 BRH Wealth Creators Limited may not have been in compliance with the SEBI rules and regulations governing pledging of securities. Further, it appears that defendant number 1 has also pledged securities through potentially related parties. Next by page, my lord, para 5. Prima facie, the forensic audit report indicates that the linkages between defendant numbers 1 and 5 to 7 and also sheds light on the modus operandi are adopted to make the payments. The defendant numbers 5 and 7 have not appeared. The plaintiff has filed affidavit service, which indicates that the notice sent by courier has been served on the defendant numbers 5 to 7, whereas notice sent by courier to defendant number 6 is returned unserved with the remark address C has changed the address. The learned counsel for the plaintiff submits that defendant numbers 5 to 7 have been served by mail. In the circumstances circumstances, the reasons which weighed in with this court in passing the interim order on 21st December 2020 apply with equal force qua defendant numbers 5 to 7. In fact, to give meaning and content to the order passed against the defendant numbers 1 to 4, it is necessary to pass orders against defendant numbers 5 to 7. For the present, it will suffice to pass ad interim order in terms of prayer clause 1 and 2. So, my lord, in para 7, my lord, ad interim order is passed, directing these 5 to 7 related parties again to disclose all their assets and properties, both immovable and movable, all income tax return, all encumbrances, investments, securities, shareholdings, everything. So, my lord, the basis of this submission, my lord, is this forensic audit report is actually a very important, vital ingredient in connecting the loopholes and the dots between the parties. However, from the orders passed by other courts as well as the SEBI, my lord, the loops in my humble submission have been formally tightened up.
Yes.
Now, my lord, kindly comes back to the list of dates. My lord, I've placed 47. We come to 48. My lord, I had placed that order, my lord, by which Securities Appellate Tribunal held that the pledge once created has been validly invoked, and hence HDFC could not have been saddled with liability by SEBI, my lord.
Yes.
Now, that order has been challenged by SEBI before the Supreme Court in Civil Appeal number 2986, my lord, that is pending. Item number 49, that same order, my lord, has been challenged by NSE also, my lord, in Civil Appeal number 3889 of 2022. Both of them are pending before the Honorable Supreme Court. My lord, this at 50, my lord, is an order of the Gujarat High Court. My lord, this I had already placed when I was dealing with respondent number 5 and 6. This is a proceeding initiated by some investors of BRH, aggrieved by the fact that SEBI had let 5 and 6 go scot-free. An argument, in affidavit, the defense taken was in Gujarat High Court, this issue was already raised and the court decided not to pass any orders. But my lord, I had placed this order to show it was disposed of merely because the petitioners therein had decided to file a writ petition and not a suit. And the court said that we cannot go into dispute it. Yes. So there was no decision as to the liability of 5 and 6. My lord, then this is at 51 is the order dated 11th of January 2023. My lord, this is a final order passed by SEBI, which we had placed in great details, my lord, so I'll not go into that. Now, my lord, item number 52. This, my lord, I had shown previously that NSE had admitted about 92% of the claims of the petitioners, and BSE, my lord, admitted 96%. Since the BSE's amount was small, entire amount has been paid off from the Investor Protection Fund. In NSE, my lord, though around 9 crores odd had been admitted, only 1 CR was paid to all 4 petitioners out of the Investor Protection Fund, 25 lakhs each. That's the maximum that could have paid. My lord, then item number 53, my lord, this is a GA filed by us in the suit which is filed by BRH against HDFC, which is pending, my lord, before this court. My application for addition of party, my lord, is pending there.
That is still pending?
That is pending, my lord.
Yes.
My lord, that I still haven't been able to ascertain, my lord, because the number shows as a CS, not a commercial suit. I do not know how. But the last orders I have found, they're all before Justice Mojumdar. It's not before this court. So, now, my lord, kindly comes to 54. My lord, this is a bit on the side, but CDSL, my lord, in an arbitration concerning this particular BRH Wealth Creators, where CDSL was a respondent, because the money could not have, the money was not yet recovered by NSE from BRH, an arbitral tribunal, my lord, has made the entire award against CDSL, saying that it had failed to act as a regulatory body and failed in its duties because my lord has seen under the SEBI circulars, there are supposed to be weekly checks, monthly checks, half-yearly checks. Nothing has been done. All the clearing corporations, the CDSL, NSDL, the exchanges, my lord, all of them, that is my submission in my petition also, all of them have contributed. There's a contributory negligence factor that has crept in from their side also. This particular arbitration award, my lord, has been passed against CDSL in another arbitration proceeding. Now, my lord, the rest, my lord, won't be relevant. But today, in item number 56, has stated that today the entire value of my investments would stand at rupees 30 crores odd, my lord, taking into account the way the shares have risen and everything. So, and then the present suit was filed, and then have indicated the interim orders that were passed from time to time.
Yeah.
So, my lord, from the affidavit of the respondent number 11, respondent number 1, read together, my lord, we get a few interesting things. That, my lord, when this loan against securities was given by respondent number HDFC to BRH and to respondent number 8, my lord, at that point of time, both respondent number 5 and respondent number 6, who say that we were never participating in the affairs of the company, were both directors. The respondent number 5 had actually signed the loan sanction agreement. HDFC, in favor of HDFC, the last pledge was created. I'll put all these dates, my lord, separately because there's a few important dates in our written notes which are given bullet points. The last creation of pledge in favor of HDFC by BRH took place on 27th of September 2019. September 2019, when in June 2019, SEBI had already by circular stated that all shares have to be unpledged within a given date. They're still going on creating pledges, and those pledges are being accepted by the banks. Respondent number 1, BRH, indicated to, there's a letter. Respondent number 8, BRH is indicating to the respondent number 11 that the securities that have been pledged with you actually belong to my clients. Do not invoke those pledges. I'm giving you other collaterals.
Yes.
Yet, respondent number 11 goes ahead, recalls all this. So it was done knowing for a fact that BRH is not the owner of the securities pledged with it. Then, my lord, this invocation of pledge, my lord, was took place on 14th of October 2019. This was after the SEBI's interim order of 7th of October 2019.
Invocation of pledge dated?
On 14th of October 2019.
October.
14th October 2019 by HDFC.
Yes.
SEBI's interim order, my lord, is on 7th of October 2019.
After 7 days.
After 7 days, they started invoking, and the securities were all sold between 15th October and 20th October.
Yes.
My lord, there was this chart I had shown, all the dates, my lord, all the security sale dates were there. Then, my lord, in SEBI itself, my lord, by a letter of 13th December 2019, directly written to the respondent number 11, indicated that it was not acting in conformity with the interim order. It was a direct communication from SEBI to respondent number 11. If this is on 13th of December 2019, the sale of shares, my lord, took place, my lord has already noted, up to 20th of December 2019. After SEBI, the market regulator, writes to them.
No, the 13th December, SEBI sent a letter to whom?
To HDFC,
okay,
saying that it is not acting in accordance with the interim order.
Yes.
And my lord has noted the sale continued thereafter also, up to 20th of December 2019. And my lord, yes, and in yes, I think that is the rest, my lord, are already covered in this list of dates. So these are the few important dates from here that I needed to show. Now, my lord, there are two other financial bodies with whom shares were pledged. 9 and 10, my lord. If those two list of dates can be taken up, I'll not place the entire list of dates, just the dates in which the agreements were entered into between them and the invocations. My lord will kindly take up the list of dates pertaining to the respondent number 9.
Yes.
9, my lord, is JM Financial Products Limited. So we say that there are four entities, at least four entities with whom this pledges were made. 9, 10, 11 and 20. 20, my lord, is Axis Bank. It has not come and filed anything. So 9, 10 and 11 are the only entities for whom we have this data. Now, my lord will kindly straight come over. I'm not placing the circulars and what happened. Kindly directly come over to page number 2, item number 4. My lord kindly says this is 1st of May 2010. Respondent number 6 resigned from respondent numbers 1 and 8. So far as JM Financial is concerned, respondent number 6 was no more a director at that point of time, but 5 was.
Yes. But respondent number 6 also acted after the resignation?
No, 5 acted, my lord.
5 acted.
After the resignation, my lord has seen the letter
Yes,
from
that's what
BSE,
I'm telling,
where,
that was 5.
yes, that was 5. His name was appearing as an authorized signatory.
Okay.
And also 1st of May 2010, respondent number 6 resigned from respondent numbers 1 and 8.
Correct.
The next entry, my lord, item number 5, 5th of April 2016. Respondent number 1, PRH, entered into a loan against securities agreement. All the agreements, my lord, see a loan against securities. My securities given loan for rupees 100 crores with respondent number 9. This is JM Financial. On the representation that the securities pledged belonged absolutely to the respondent number 1. Same representation here also. And this I say from the affidavit of R9. The application contains, this application, my lord, is annexed. It contains the signatures of respondent numbers 2 and 3. 2 and 3, my lord, Shiv Kumar Damani and Anubhav Bhattar, who are the present directors of the respondent number 1. And the PAN and passport copies of respondent numbers 2, 3 and 5. 5 had not signed this one, but his documents are also put in. But 5 was a director at this point of time. Now, my lord, so I have placed from here, my lord, item numbers 4 and 5. Then, my lord, the rest, some would be common, so I'd skip them over. My lord kindly turns to page number 5, item number 8.
Yes.
Page number 5, item number 8. So, after the LAS is entered into in 2018, so LAS is of 2016. In 2018, respondent number 5 resigned from the board of the respondent number 1.
Correct.
This is 17th of September 2018. After his resignation, my lord, comes to item number 9. 27th of November 2018.
Yes.
In item number 9, my lord, 27th of November 2018, respondent number 1 approached JM Financial Capital. This is another company, my lord, a related entity of respondent number 9, for unsecured loan of rupees 10 crores. Respondent number 1 requested, my lord, kindly see the respondent number 1 requested respondent number 9 to pay any amount claimed by such related entity in respect of such unsecured loan by adjusting or appropriating the amount realized from the sale of collateral, security, pledge or lien provided by the respondent number 1 to the respondent number 9 in such manner as deemed fit by the respondent number 9 as at its sole discretion. So, my lord, first respondent number 1 takes a loan against securities from JM Financial.
Correct.
JM Financial
Who
product.
is related to the respondent number 9 and unsecured loan of 10 crore respondent number.
Yes.
Okay.
First from JM Financial Products, 100 crores. Then JM Financial Capital, unsecured loan of 10 crores. Respondent number 1 requests respondent number 9 that if your sister concern asks you for any amount payable on account of BRH, you adjust it from the shares, securities that have been pledged. Hello, kindly see. So my securities are going to this company, their related entities, everywhere. This, my lord, will find at pages 76 and 78 of the affidavit in opposition of respondent number 9, my lord. This is from there. So now, my lord, will kindly turn to page number 7. At the bottom, item number 18. Respondent number 1 informed respondent number 13 that respondent number 9 has been requested to release all pledge on shares of clients in favor of other collaterals, as the same ought to be transferred to the client's respective account. The way it was done for HDFC, my lord. Respondent number 1's ledger statement with related entity of respondent number 9 had an outstanding debt of debit balance of rupees 10.07 crores. This is the other JM Financial Company. Respondent number 13 reported that in violation of SEBI circular dated 20th of June 2019, respondent number 9, JM Financial, held pledges valuing at rupees 13.19 crores pertaining to the clients of respondent number 1.
Yes.
My lord then turns over the page to page number 9, serial number 20.
Yes.
3rd of October 2019, my lord, respondent number 9 invokes the client shares pledged by respondent number 1 and it sold the shares. This is at para 4G of the affidavit in opposition of the respondent number 9. Then, my lord, only notes on in item number 22. This is the interim order, 7th of October 2019. On that same day, 7th of October 2019, my lord now turns over the page. While that interim order is being passed, my lord will kindly see a second paragraph to the. The sale proceeds from the client shares pledged by the respondent number 1, BRH, were credited to by the respondent number 11 in the ledger of respondent number 1 for rupees 11 crores, and the surplus credit of rupees 10.09 crores was transferred to the loan account of respondent number 1 with the related entity of respondent number 9 towards its outstanding balance. So it sold off my shares, got its own money back, transferred the surplus to the other sister concern, got the debit balance of the respondent number 1 adjusted to such extent. All of this is done while the interim order is being passed by HDFC on 7th of October 2019. This, my lord, will also find at para 4G of the affidavit in opposition of the respondent number 9. Now, my lord will kindly turn over the page. In item number 24 to 29, these are pertaining to respondent number 9. On 18th, so interim order is passed. After that, they have sold it off on 18th of November 2019. Respondent number 12, SEBI, informed the respondent number 9 of the interim order. So, my lord, it passes it in October, more than a month thereafter, after having come to know that these are the entities who are dealing with them. These are the banks who are holding the shares and dealing with them. SEBI writes to them more than a month and a week thereafter.
Yeah.
And requested for loan account statements of respondent number 1. On 29th of November 2019, next item number, my lord, respondent number 9 made over the loan ledger of respondent number 1 with cash margin and interest ledger from April 2016 to respondent number 12. Even thereafter, my lord, after the interim order is informed by SEBI itself, item number 26, my lord, sees on 10th of December 2019, respondent number 9 sold 9050 client shares pledged by the respondent number 1 under the master loan agreement to IDBI. Further sales are being made and no clampdown by any of the bodies. In everybody's knowledge, my lord, this thing is happening. Item number 27, on 12th of December 2019, the respondent number 9 credited the sale proceeds of rupees 3,10,000 realized from the sale of shares to IDBI to the loan account of the respondent number 1 with the related entity of respondent number 9. So that is gone. On 23rd of December 2019, respondent number 12, SEBI, requested for additional information pertaining to respondent number 1 from respondent number 9 And next, on 30th of December 2019, such additional information allegedly has been provided by JM Financial. But after that, what happened was steps SEBI took, knowing that this has been done in violation of the interim order. My lord, nothing is on record. Some steps were taken by SEBI against HDFC, but so far as JM Financial, my lord,
action has been taken.
nothing.
Yes.
So, my lord, from here, my lord, two things. One, loan against agreement dated 5th of April 2016, where respondent number 5 was a director.
Dated? Loan agreement
5th
dated?
of April 2016, my lord.
Yes. Different
Respondent number 5 was a director at that point of time.
Yes.
Despite the SEBI circular to release client securities, my lord, by 30th of September 2019, on that day, pledge amounting to rupees 13.19 crore was being held by respondent number 9 in violation of the SEBI circular. And, my lord, the invocation of pledge and the sale of client shares took place, my lord, on 3rd of October 2019.
Yes.
An appropriation of sale proceeds in favor of that related entity of J9 of JM Financial, my lord, that took place on 7th of October 2019. So both of these are done after BRH is suspended. Interim order has been passed by SEBI. They have been notified about the interim order passed by SEBI. So, my lord, now the last one, my lord, respondent number 10. My lord kindly takes up the list of this pertaining to respondent number 10, my lord, is Bajaj Finance Limited.
Yes.
Interestingly, my lord, Bajaj Finance has not disclosed when the LAS was entered into. It has not disclosed any agreement, the sanction letter, nothing has been disclosed by them. So all we have from here, my lord, is at page 7, my lord, item number 16.
Yes.
The information from BRH to NSE that Bajaj has been requested to release the pledge because all of the shares belong to the clients, and this request has been made to release the pledge in favor of other collaterals. 30th of September 2019. Then, my lord, the next one, 1st of October 2019. My lord will kindly come to the third entry. 1st of October 2019 is also the date when the broking account of respondent number 1 was frozen. And respondent number 1 had already been suspended by NSE and by that time. Even after the suspension and the freezing of broking account, my lord, third entry, respondent number 10, Bajaj, recalled the loan against securities granted by it in favor of the respondent number 1 for a sum of rupees 20 crores and invoked the client shares pledged by the respondent number 1 to recover the outstanding amount. At the time of creation of the pledge, the respondent number 1 had represented that the securities are its absolute property, and the pledge was accompanied by regular pledge report from the respondent number 19, which, according to the respondent number 10, is the sole documentary evidence required regarding proof of ownership of securities. So, my lord, Bajaj interestingly says that at the time of creation of the pledge, a pledge report by CDSL was made over to us. That CDSL pledge report was indicated that respondent number 1 is the owner of the securities.
Correct.
And they say that we do not have to take any other due diligence measures because CDSL report is with us. My lord, it is based on this CDSL report, that's irregular and false CDSL report, that arbitration award, my lord, which I was talking about, that was passed. That CDSL had actually contributed to this entire fiasco by publishing a report saying all the securities, in fact, are held.
Who are the party in the arbitration?
My lord, this is a different investor with BRH. and CDSL. The BRH and CDSL are the two respondents. So CDSL's contributory action in all this, well, that was recognized. CDSL itself gave this regular pledge report, which according to Bajaj was the sole documentary evidence they required to create the pledge, my lord. Then, my lord, will kindly turn over and come to item number 20 at page 19.
Yes.
On 11th of October 2019, my lord, the respondent number 10, Bajaj, sold the client securities lying with it, and after recovery of the outstanding amount, returned the balance to the respondent number 1. Respondent number 1 closed the loan against securities account with the respondent number 1. So Bajaj gains out of it, respondent number 1 gets his money back, my securities are gone. This, my lord, will find at paragraph 12 of the affidavit of Bajaj, my lord. They said they have returned the entire money, so the accounts are closed. My lord, that completes Bajaj's thing. So, my lord, here we do not know who were the directors at the point of time the LS was entered into, because the date of creation of the pledge has not been disclosed either by Bajaj or by the respondent numbers 1 or 8 or any of the directors.
Yes.
My lord, because our specific case was that this was done at the point of time when 5 and 6 were directors, my lord would be pleased to draw adverse inference from the fact that this important vital documents, my lord, they have not been disclosed. Even 5 and 6 have not disclosed this, to show that they were not involved in at the time of creation of LIS. So, my lord, the takeaways from this one would be that after suspension of BRH by NSE on 30th of September 2019, and this BRH's specific request to release the client securities on 30th of September 2019 itself, this loan against securities was recalled on 1st of October 2019. So, being fully aware of the fact that the invocation of pledge is being done.
Loan was recalled on?
My lord, loan was recalled on 1st of October 2019.
Yes.
So, they're well and fully aware that the securities do not belong to respondent number 1. And respondent number 1 had also offered to put in other collaterals. Nothing is said on that. Then, my lord, interim order passed on 7th of October 2019. On 11th of October 2019, after interim order is passed, they sell the client securities. They take back what they had to. They return the balance to the respondent number 1, BRH. Knowing that at that point of time, everybody was in the know that all these proceedings are going on and so many investors have been defrauded by BRH. They take what they had to and they return the rest.
Yes.
And my lord, also in violation of SEBI circular, on 30th of September 2019, which is the cutoff date for return of the pledge, they continued to hold these pledges. So, my lord, that completes the affidavits of the financial corporations, my lord. So, my lord, so far as BRH commodities, my lord, 1 and 8, and the present directors are concerned, my lord, their involvement and their liabilities, my lord, have already been spelled out by SEBI, the violations under the SEBI Act. So, I would also submit that apart from violations under the SEBI Act, my lord, there are violations under the general law relating to pledges under the Indian Contract Act. Apart from that, my lord, so far as the respondent numbers 5 and 6 are concerned, my lord, past directors, my lord, we have shown how they were there at the point of time when this creation was done. This practice has been admittedly continuing from 2005 when both of them were directors. And my lord, SEBI Act clearly says that they would be responsible for any illegal act done during the period of their tenure as a director. But I'll also want to show the general law on the subject. And apart from that, my lord, the acts of the banks, HDFC, BRH, and JM Financial, my lord, that, my lord, I have shown how they have created pledges over other entities, my lord, and my lord, so as my submission on that point would be that the pledge could not have been created at all. So the appellate tribunal's finding that the pledge has been validly invoked, that does not really bar any finding reached by this court, because the question here is whether the creation of the pledge was wrong or not, my lord. And the other parties, that is the other related entities of the respondent number 1, my lord, are already seen from the SEBI order, my lord, how they have been found to be involved in this.
Yes.
Now, my lord, I would only request for another day for the law part, my lord, that we can show.
No, since all the facts have come in, my lord, just a very brief, a few questions would immediately come to mind. What would be the effect of the SEBI Appellate Tribunal's order on the jurisdiction of this Honorable Court at the stage at least of grant of interim relief? Do those findings, they can't operate as res judicata because they are pending in appeal before the Supreme Court, but then do those findings by the law of committee prevent your lordship from going into that issue? The limited issue covered there. The answer would be no, but I'll give your lordship reasons why. Second is the general law of pledges. And third is the jurisdiction of the civil court when seized with a case of egregious fraud, where my lords will find that the civil court is the ultimate receptacle of entire jurisdiction, including the powers to make any orders under section 94 of the Code of Civil Procedure for the purpose of preservation, detention of the property in question. In our case, my lords will find everyone is playing the truant and running away with the money and saying that no one ultimately in the affidavit says how the money would be secured. So one of our prayers over and above injunction was the question of securing that money before this honorable court, so that ultimately
who will secure?
Everyone, according to me, everyone. I'll show you lordship the law, and then I leave it to your lordship to decide who. 9 related entities, 5, 6. NSDL, CDSL, SEBI. I'll show you lordship the law. I'll try and we are actually trying to collate it in the form of a note column wise. The law says everyone. Everyone must secure, because in an act of fraud of this nature, the persons who allow this to happen by culpable negligence are equally bound to the consequences. Those who are active participants in the fraud are bound.
What would be the effect of the Supreme Court order?
Supreme Court order over there would be only restricted to what the appellate tribunal's findings were regarding 5 and 6 having a clean sheet regarding that issue. Sorry, HDFC having a clean sheet regarding that issue. HDFC said, as far as I am concerned, I am not required to look further than the register. The register said it was owned by them, therefore I need not do due diligence. That is a limited. That is the limited action. That is the limited finding of the appellate tribunal qua invocation. They have not gone to the question of creation, because they are not required to go into the question of creation in that limited jurisdiction. I say creation per se is bad. It falls foul, my lord, of regulations as well as the general law. If the creation is bad, the invocation is automatically bad. And you as a statutory authority, you are supposed to be a sentinel on the qui vive, trying to see that everything happens in accordance with the rules and regulations. Today, when you are faced with a register showing certain entries, I'll show your lordship the law. You can't take that to be sacrosanct when you are making financial transactions. You are not giving a certificate, my lord, to a student saying that he has a good character and he has a bright life ahead. You are making financial transactions pertaining to monies belonging to investors like us. So you are definitely required to do more than your level of expression.
So with regard to the 4 and 5 and 6.
Yes.
5 and 6.
Yes.
So how far this court can go into the
Yes. Now, I'll show you, lordship, not the fact that the findings made by SEBI in that limited jurisdiction in which SEBI was only considered with the second part of the transaction would not prevent your lordship from a plenary examination of the previous and subsequent facts in order to see prima facie whether there has been an element of fraud. If there is a prima facie element of fraud, that's good enough to sustain an interim order. Here, the interim orders are diverse, which have been sought. One or two of them have been rendered infructuous by the fact that sales have already taken place in the meantime. So what is pivotally important, Milord, in our system is to find, Milord, where the rabbit has gone. This is a magic trick going on from here and there. Everyone lifts the hat and the rabbit is absent.
But you have not taken the tortoise.
I should have taken the tortoise, Milord. Milord, this rabbit has to be put in a cage until we decide who this rabbit belongs to. Everyone is showing the hat, lifting it and saying, voila, it's not there. So under such circumstances, Milord, that prayer, that the amount be secured and kept aside in custodial legis for the simple purpose of ensuring that tomorrow I don't have a paper decree and we don't have 500 interpreter suits amongst each other where the actual rabbit dies. So that's the only, that's a limited purpose. I'll take around 45 minutes, but we'll collate the law so that I am not repetitive and come back any day.
Counsel for the plaintiff has argued the matter at length and prays for time too. But due to paucity of time, hearing could not be completed. Accordingly, case is adjourned. Let the matter appear on न्यू मोशन का ही adjourn मोशन में ना, कल तो न्यू मोशन होगा. Nine.
This morning, your lordship allowed GS7 malot.
9th of September. Under the heading adjourn motion at the top. Huh? Yes.
The interim order is still the 8th, malot.
8th of September?
Yes, yes.
8th September. The interim order shall continue till 9th of September or until further.
Maybe 2 or 3 days more. 2 or 3 days more, just
order is extended till 17th of September.
Obliged. Obliged.
This GS7, you have no objection. GS7?
Extension of time.
Extension of time to file return statement.
No, let them come. Let them come.
I have read. 5 and 6. 5 and 6 है?
मतलब GS7 is for मतलब respondent number 18, defendant number 18 मतलब.
GS7.
120 दिन नीचे तो.
GCOM 7 of 22. The respondent number 18.
Yes, ma'am.
Has filed the present application with GCOM 7 of 2025. Praying for praying for extension of time to file return statement. Counsel for the defendant number 18 submits that the writ of summons was served upon the defendant. When you receive the writ of summons?
28th of April, malot.
On 28th of April 2025. 2025 after receipt of the writ of
on 190 days, malot, I have affirmative, malot.
After the writ of after receipt of the writ of summons, the defendant number 18 has contacted the advocate on record of contacted the advocate, and accordingly an advocate has informed the defendant number 18 for providing instruction all relevant document so as to enable the defendant number 18 to file return statement. Full stop. He submitted the case contains several documents, and as such the defendant number 18 took some time to collect all the documents and to place before the advocate for preparing the document, due to which the defendant could not file the return statement within a period of 30 days, but has filed on 119th day, that is 119th day, that is within the period of 120th day. He prays for extension, he prays for acceptance, and fully he further submit that on 119th day the return statement आया. He submitted. Fine.
Lordship, am I audible? Lordship, I was at the bank, I was only making a prayer, Lordship, instead of 9th, can it be on 10th?
Can it be on 8th?
Yes, 8th is 8 is fine. Either 8th or 10th, my lord, instead of 9th.
अपन का है स्टैम्प्स का है अफर्मेशन स्टैम्प्स कैसे ये कोई स्टैम्प्स नहीं होता अफर्मेशन में वेयर इज दैट क्या बोलना On 119th day, he has taken leave from this court to submit the written statement in the department, and accordingly, this court has granted leave to submit the written statement in the department. Full stop. The learned counsel for the defendant, counsel for the plaintiff submitted though the defendant has not filed the written statement within the period of 30 days, but has filed the written statement within the auto period of 120 days, and as such, he prays for acceptance of the written statement subject to payment of cost. Had the learned counsel for the respective parties peruse the materials on record, this court find that though the defendant number 18 has not filed the written statement within the period of 130 days, but has affirmed the written statement and filed in the department with the leave of this court on 19th day, that is within the auto period of 120 days. Considering the above, this court also find that the plaintiff has, the defendant number 18 has signed sufficient cause for non-filing of the written statement within the period of 30th days, within the period of 30 days. Considering the above, this court find that one opportunity should be given to the defendant for filing written statement subject to payment of cost of ₹5,000 into the High Court Legal Service Authority. Full stop. The department is directed to accept the written statement subject to scrutiny by the department, subject to payment of cost of ₹5,000 by the defendant number 18 to the High Court Legal Service Authority within a week from date. GA number 7 option is displayed.
Lordship, I was making a prayer instead of 9th, can be 8th or 10th.
5, 6.
সব WS রেকর্ডে আসে
When you are received
16th April 2025.
16th April. Okay. उसमें कब रिसीव हुआ था रिटर्न स्टेटमेंट वो
That was 28th April, Lordship.
Okay. And when you file the written statement?
12th August 2025, Lordship. 118th day.
118th day. And the dependent number?
5.
5 has filed the present application being GA com
6 is also there, Lordship. Same dates.
5 and 6.
Yes.
So, 5 and 6 filed an application being GA com 5 of 2025 and GA com 6 of 2025, praying for acceptance of the written statement. Police counsel for the defendants submit that the defendant number 5 and 6 have received the writ of summons on
16th April 2025.
April 2025. 5 and immediately received the writ of summons, the defendant number 5 and 6 have consulted their advocates, and the learned advocates have informed the defendants to provide the instructions and the documents in connection with the said case. For the counsel for the defendant submitted as the defendants took time to collect the documents for preparing written statement, and as such, the defendant could not file the written statement within the period of 30 days, but have prepared the written statement within the auto period of 120th days and affirmed the affidavit on 12th of August 2025, that is 118th days. And with your file the written statement in the court.
In the department
with the
118th.
leave of this court, the defendants have filed the written statement in the department on 118th day, subject to acceptance by this court. Police counsel for the defendant submitted that though the defendants have not filed the written statement within the period of 30 days, but have filed the written statement within the outer period of 120 days, and as such, they pray for acceptance of the written statement. Learned counsel for the plaintiff submitted, though the defendants have not filed the written statement within 120 days, but have filed the written 30 days, but have filed the written statement within the period of 120 days, and as such, he prays for Acceptance of return statement subject to payment of cost. Had the learned counsel for the respective parties, this court find that the defendants have shown sufficient cause for non-filing of the return statement within the period of 30 days, but it is found that the defendants have filed the return statement within the outer period of 120th days. Accordingly, this court find that one opportunity should be given to the defendants to file the return statement subject to payment of cost of rupees 5,000 each to the High Court Legal Service Authority within a week from date. The department is directed to accept the return statement filed by the defendants number 5 and 6, subject to scrutiny by the department. Have you served the copies?
Yes, Lordship.
To the print?
I have served the copies, Lordship.
GN number 5 and GN number 6 are disposed of.
Grateful, my lord.
Lordship, I was making a prayer, my lord.
To whom, Lordship?
High Court Legal Service Authority.
Grateful,
Yes.
Lord.
Lordship, I was for the bank, HDFC Bank. My lord, instead of 9th, can it be on any other date other than 9th? My lord, I would like to be present to hear Mr. Banerjee's legal arguments, my lord, physically.
9th, instead of 9th to 17th, I am in some difficulty.
9th?
9 to 17, 1 week.
Can it be the 8th, my lord?
एक काम करो 18th Thursday है ना 18th कर दो उनको
I'm obliged.
18th adjourn motion at the top. Interim order is extended till 19th September or until
Few more days just in case. The few more days.
24th September.
24th. Obliged.
Great. Extremely grateful.
और किसके? Nobody is moving. Who is the defendant number 10? Who is appearing for the defendant number 10? Bajaj Finance, nobody is there.
Lord, my schedule shows now that I'm slightly tied up, might be tied up on the 18th and 19th. Could it be the 22nd? I mean, those 2 days, 18th and 19th, I find, my lord, that there are other matters fixed, my lord. I would wanting to address you.
And 23rd?
23rd.
23rd September.
23rd.
23rd
Grateful. Great.
The interim order, my lord, was
interim order 25th. 25th कर दो
25th एक दिन
नहीं आएंगे जो आएगा डिस्पोज ऑफ
I appear for the petitioner, my lord, in this matter.
Item number 15.
15, my lord. This is my order 13A application. The plaintiff, my lord, is engaged. Definitely. The plaintiff is, my lord, engaged in providing, my lord, services, consultancy and marketing services. Defendant had a property, my lord, on BB Ganguly Street, 14,500 square feet and odd. They wanted to let it out. My lord, I provided my services as an agent and I got hold of a, my lord, tenant or a lessee. My lord, a reputed jewelry company, my lord, Kalyan Jewelers, for them. There's a letter of intent which was executed between, my lord, the defendant and the lessee, and there is a lease which has been executed thereafter. In terms of that agreement, I am entitled to 2 months, my lord, lease rental charges towards my fees plus GST, which makes my claim approximately little above, my lord, 54 lakhs. My lord, I start demanding my payments. My lord, they initially, my lord, though receive
payments of what?
Payments of those fees, because the LOI was there, the lease was there. So I said, give me my payment. I raise an invoice. My lord, we issued emails. They responded. They, in their response, my lord, there are 2 emails. I'll shortly, my lord, draw my lord's attention to those. They admit their claim, their liability towards my claim of 2 months rent as fees. Did not pay. My lord, I issue a notice under Form B and then proceed before the, my lord, NCLT under the, my lord, Insolvency and Bankruptcy Code. They contest the proceeding, the Section 9 proceeding, files their affidavit, and thereafter an order of admission was passed. Once, my lord, the order of admission is passed, they come up and say, no, we want to settle. Thereafter, a settlement agreement was entered into. And one of the conditions was the consideration was reduced. One of the condition was that if they don't pay, I would be, my lord, if they breach, I will be entitled to pursue my entire claim. My lord, they paid only a part of the, my lord, agreed amount. Out of 31,28,000 settlement amount, they only paid 10 lakhs. My lord, we repeatedly, my lord, requested them to pay the balance in terms of the settlement amount. They don't pay. Hence, my lord, I institute the suit because I have that liberty reserved under the, my lord, settlement terms. I institute the suit and take out this application. Written statement not filed. Ultimately, they took out an application. Lordship rejected that application because it was beyond, my lord, the statutory period. They carried that order in a SLP. SLP, my lord, rejected. That's the, my lord, position. Now, let me take your lordship through the, my lord, documents. Kindly, my defendant is here.
Your appel.
My lord, kindly comes to, my lord, the letter of intent, which is at page 40. Now, least my lord, page 40 of the, my lord, application.
Yes.
My lord, this is the letter of intent of 18 December 2017. Between, my lord, kindly sees the names BP Suraj Business Combines Private Limited, which is defendant, and Messrs. Kalyan Jewellers India Limited.
Yes.
My lord, the recital at page 41, first recital. First party is the absolute owner of the land and building in the premises. Second party does not have any claim whatsoever to the title of the land or building. Second party is desirous of taking the premises on lease for a period of 15 years for business on the terms and conditions agreed upon between the parties. Second party intends to start their jewelry business in the premises, for which second party has to do certain interior work. My lord, the description of the land lordship will find in the table below. And the rental lordship will find clause 5, 23 lakhs in the table, my lord, clause 5 at page 41. 23 lakhs plus GST less rupees 5 lakhs against adjustable advance payable according to English calendar month. So far as my claim is concerned, I am only, my lord, concentrating on the figure of 23 lakhs plus GST on that amount, because that constitutes per month or every month's rent. And that's there in the lease deed itself.
So your claim is 23 lakh, that is a one month rent.
20, so it's 46 lakhs on account of rent because I was entitled to 2 months rent plus the GST on account, GST on that component. So that takes us to, my lord, little above 54 lakhs. I'll give your lordship the exact figure.
So where is there is an agreement between you and the defendant?
There's a, my lord, document. There's a document which entitles me to this amount executed between, my lord, the plaintiff and the defendant. That's at page 71, my lord, kindly comes to 31st of December 2017, issued by my client and accepted by their client. And there's no dispute with regard to this because they have, in fact, in the settlement agreement agreed to pay.
Okay.
But just for the sake of completion, lordship takes note of page 71. There's only one document prior to this I wish to, my lord, rely upon. 71, let me just complete this, my lord. This is JLL's letter, which is the plaintiff. Subject is FECON and revenue recognition confirmation. This letter serves as FECON and revenue recognition confirmation between Jones Lang LaSalle and BP Suraj. This is to confirm that JLL's services are satisfactorily completed upon signing of agreement for transaction of Kalyan Jewellers at Bowbajar, Kolkata on 26 December 2017.
Page?
My lord, I'm reading, my lord, from page 71.
Yes.
This is, my lord, plaintiff's letter addressed to, my lord, the promoter director Vikash Murarka of, my lord, the defendant. I was replacing, my lord, the second paragraph. This is to confirm that JLL services are satisfactorily completed upon signing of agreement for the transaction of Kalyan Jewellers at Bowbajar, Kolkata as on 26 December 2017. My lord, this date is significant because this is the date of execution of the lease deed, which is at page number 56. Page 56 is the lease deed that was executed between defendant and, my lord, Kalyan Jewellers. I read, my lord, continue reading this, my lord, page 71. JLL is eligible to raise the invoice for the amount mentioned below. Chargeable area 14,500 square feet. Monthly rent INR 23 lakhs. JLL transaction fees INR 46 lakhs plus applicable taxes. Total transaction fees of for the Kalyan Jewellers transaction at 198 BB Ganguly Street, Kolkata is 46 lakh plus applicable tax representing full and complete amount due to James Lang and is payable upon receipt of the invoice. kindly hereby confirm that the agreements are confidential documents, since you will not be able to share the copies of the agreement with us. However, you have provided us with the signed LOI copy for reference. So that is how I got, my lord, the LOI, because I was not privy to that document. My lord sees who has signed it at the right hand side foot of that page. Accepted, Mr. Vikash Murarka, BP Suraj Business Combines Private Limited. My lord, the invoice which is referred to in this letter is at the next page. My lord, this is an invoice. Kindly sees, my lord, the amount only. 46 lakhs plus the applicable tax is, my lord, for 2 months. It's 4,14,000. My lord, GST for 2 months, it's 8,28,000. So I add 8,28,000 to 46 and arrive at the figure of 5428. My lord, the final computation, lordship will find at page 73, the addition of the two components. So it's, my lord, really 54,28,000, which was my entitlement. My lord, these two invoices were sent to him under cover of the letter at page 74, which is dated February 28, 2018.
Yes.
Page 75. Follow up 31st of March.
Page 75 is the second, my lord, another letter by which again we, my lord, send it to them. There are reminders and demands, my lord, which starts from page 78 onwards. Lease we cluster bar kar jekhane 2 mas rent. Na lease na sorry hota to darkar. My lord, page 78 onwards is my reminders. Kindly sees, my lord, the address to, my lord, it's Vikash Murarka, the gentleman who had accepted the, my lord, FECON, my lord, document. Page 78.
Yes.
Subject is payment reminder. Dear customer, we are attaching payment reminder letter. Request you to kindly remit the payment as soon as possible. Should you have any query or require any clarification regarding the same, please contact us on such and such.
Yes.
My lord, I need not trouble your lordship with all the reminders. Kindly comes to page 80. There, page 81, their immediate response, my lord. My lord, page 81, if lordship sees, there are two emails. I am referring to the email which is at the foot of that page. Monday, 26 November 28. Now, my lord, kindly sees the mail just above that. This is on 11th of December. So first is on 26th of November, Murarka writes, and then again he writes on 11th of December. Dear Dilip, we want to inform you that I am already committed to you that I will release and settle your bill by December 2018. Thereafter, I again request you, please keep patience. Very soon we will call you regarding your payment. So this was their, my lord, contemporaneous stand. Now, my lord, kindly comes to page 83 once.
Yes.
My lord, this is also, my lord, again at the, my lord, at the top of the page, Vikash Murarka writing, due to heavy crisis of fund, we are unable to make your payment. We will try to settle your payment within December. So all, my lord, emails assuring us that by December we will get the payment. My lord, we don't get the payment. We, my lord, file a petition under, my lord, section 9 of the Insolvency and Bankruptcy Code. And to file that, my lord, it was preceded by a form B notice, my lord. Kindly takes, my lord, the notice, which is at page 98.
No, notice is at 90.
No, 98.
No, that's the petition. That's the section.
Oh, sorry. My lord, I'm sorry, I gave a wrong page number. It's at page 92, my lord, the form 4 notice. Page 92.
Yes.
My lord, this is from our client, James Long, and addressed to, my lord, defendant. Subject notice with regard to the services provided. My lord, at page 92, the last paragraph. By way of the present notice, the company is demanding the outstanding sum of 54,28,000 as due against you within 10 days of receipt of this notice, failing which company shall file an application before the adjudicating authority for initiating corporate insolvency resolution process under section 9 of the code. Now we do that, my lord. We file the application. Or corporate data.
Yes.
No, no.
My lord, we file the section 9 petition. They contest the proceeding, and thereafter an order of admission was passed. And my lord, the corporate insolvency resolution process had triggered. My lord, I straight away take your lordship to the order. Order ta dekha. My lord, comes to page 190. The order starts at page 190.
190.
Yes, my lord, that is volume 2, my lord. Only one paragraph I want to show, the operative part, the finding.
Yes. Petition go on. In petition 190.
Yes, my lord. Petition, my lord, volume 2, page 190.
Affidavit.
No.
Yes.
My lord, kindly, it starts at 190, kindly comes to, my lord, page 194, which is, my lord, the finding of the, my lord, NCLT, paragraph 11. Further, with respect to the issue of existence of default,
194.
Yes, my lord, I'm sorry, 194, my lord, paragraph 11.
Yes.
Because I have to, my lord, satisfy that there was a default which was existing when I had, my lord, issued that, when I had initiated the proceeding before the NCLT. With respect to the issue of existence of default, the emails dated 26 November 2018 and 11th December 2018 by the corporate debtor clearly resolves the issue wherein the corporate debtor has categorically acknowledged to settle the outstanding debt by the end of December 18 against the services rendered by the operational creditor. And just the next paragraph, the figure is also, my lord, recorded, 54,28,000.
Yes.
And there is no challenge to, my lord, any of the findings returned by the NCLT and as recorded in this order. Now, after this, my lord, when the, my lord, paragraph 15 at page 195, lordship sees the ordering portion, the CIRP was, my lord, directed to be triggered after the petition was admitted, para 15A at page 195.
Yes.
This prompted, my lord, the defendant to, my lord, enter into a settlement agreement, which is at page 197. I'll just trouble your lordship with the recital. It's important, my lord. 197. An application under section 9 of such and such was. And my lord, I'm only reading the recital part at the middle of the page. Clause A.
Yes.
An application under section 9 of the Insolvency and Bankruptcy Code 2016 was filed by JLL before the Honorable National Company Law Tribunal, Kolkata bench, claiming an amount aggregating to the sum of rupees 54,28,000. An order dated 10th May was passed by NCLT, thereby admitting BP Suraj into corporate insolvency resolution process. Then, my lord, kindly comes to C. IRP with a notice published in the Form A in Financial Express for inviting claims of creditors of BP Suraj in accordance with IBC and regulations framed thereunder. Subsequent thereto, my lord, at page 198, D. Subsequent thereto, first party through Mr. Vikash Murarka, being one of the director of BP Suraj, has approached JLL for payment of rupees 31,28,000 as full and final settlement of the claim amount. First party agreed to pay professional fees of IRP and other CIRP expenses from such and such. My lord, I need not bother your lordship with the other parts because they agreed instead of 54,28, 31,28 is the settlement amount. Then E. JLL on receipt of the consideration under this agreement. JLL on receipt of the consideration under this agreement has agreed to do all things necessary required by BP Suraj for withdrawal, closure of NCLT proceedings, setting aside the NCLT order and or filing of an application under section 12A of IBC such that CIRP shall stand closed on the execution date. My lord, the previous recital recorded that claims were being invited by the IRP. So, my lord, it is at this juncture they thought that now it's prudent for them to, my lord, enter into the settlement. And we also, my lord, agreed to, my lord, settle at a lesser figure. Then, my lord, terms of settlement, clause 1.1. Parties mutually agree that consideration payable under this agreement is the entire consideration that shall be payable for the purpose of and subject to the terms contained in this agreement in the manner set out below towards a one-time full and final settlement of any and all claims and differences in respect of the transaction being subject matter of the NCLT proceeding present or anticipated by the parties in relation 2 and with respect to withdrawal closure of the NCLT proceedings such and such. Parties have mutually agreed that the first party shall pay the consideration of 31,28,000 inclusive of applicable taxes in the following manner. 10 lakhs, my lord, payable by 18th of July 2022 on or before that date, and the remaining, my lord, 10 lakhs and 11,28,000 in 2 other tranches. My lord, the admitted position is this 10 lakh, first 10 lakh on or before, my lord, 18th of July 2022 has been paid. We have received it.
10 lakh you received?
10 lakh we have received.
Yes.
Now, my lord, kindly takes 1.3. First party being one of the director of BP Suraj agreed to fund and or has provided necessary fund equivalent to the consideration amount towards the settlement envisaged in 1.2 above. Then, my lord, 1.5. On the execution date, second party shall have no objection if CIRP stands closed and shall not require IRP to carry on the CIRP any further. So, in anticipation that I'll get the other, my lord, 2 tranches, I agree that, okay, you can close the CIRP process. My lord, clause 2.1. JLL in consideration of the settlement of the claim and withdrawal closure of the NCLT proceedings, setting aside NCLT order filing of an application under 12A of IBC such that CIRP shall stand closed on the execution date, hereby acknowledges to have received the consideration amount as per clause 1.2. My lord, then, my lord, kindly skip page 200, kindly comes to page 201, 5.3 at the top, clause 5.3. The parties agree, my lord, page 201.
Yes.
The parties agree that in the event BP Suraj breaches its payment obligations under this agreement, JLL shall be at liberty to pursue all legal remedies with respect to the instant subject matter, including but not limited to revival of this CIRP or similar fresh proceeding to be filed before NCLT Kolkata bench or any other competent court. So I chose to, my lord, institute a suit now, my lord, before the competent court. The governing law jurisdiction clause was also agreed upon in clause 6.
Not filed in the NCLT.
My lord, it's for today, my lord. I have received 10 lakhs. I have that. I had both options available. My lord, I have exercised this option. This was agreed between
NCLT.
My lord, the threshold limit, my lord, to, my lord, present a petition. That's no longer available to me. And this is, my lord, a recourse which is, even if it was not recorded in the settlement agreement, even then possibly I would have, my lord, and I would have been entitled to, my lord, institute a suit. My lord, one last clause I want to draw my lord's attention to, clause 7.1. This is important because in the affidavit in opposition, today they have taken a stand that this Mr. Vishal Murarka never had the authority either to issue those mails or to sign the affidavit or to sign the settlement agreement or to agree to any kind of a settlement. This is their stand. 7.1, my lord, just after the first paragraph, kindly sees the sentence starting with, in the case of notices to BP Suraj, addresses 198 BB Ganguly Street, the same property where, my lord, it was let out. Attention, Vikas Murarka, promoter director. And, my lord, promoter director. Then, my lord, kindly, after the settlement agreement, kindly takes note of the order. We act in terms of the settlement agreement, the plaintiff. 204 is the order.
They have paid the fees, but if
Yes.
Murarka has paid the fees of the IRP as far as
My lord, Roman 2. Learned Counsel has drawn attention to page 30 and 31, which are the minutes of the meeting of COC held on such and such, wherein a resolution has been passed by COC for withdrawal of the application under 12A of IBC with approval of 100% voting share of committee of creditors. So you avoid, my lord, other creditors lodging their claim by giving me an impression that I'm going to honor the, my lord, terms of the settlement and making the payment of 3128. I, my lord, act in terms of that. My lord, the committee of creditors takes a decision that, okay, in terms of 12A, my lord, will not proceed, and the IRP takes out this application, which was considered. Then 3, my lord, it is stated that resolution professional has been paid his dues and nothing remains pending. My lord, this was, my lord, in the settlement agreement agreed that Murarka will, on behalf of, my lord, BP Suraj, is going to pay. And this was paid, that's recorded in the order. Now, post settlement, my lord, this is my 205 is my first demand.
Yes.
In fact, this is my only demand because I had received 10 lakhs. The other, my lord, 2 tranches, my lord, I had demanded. My lord, kindly takes 1.2. Parties have mutually agreed that the 1.2, well, it's at the middle of the page. Accordingly, and as per agreement, you handed over 2 post-dated checks, details whereof are reproduced below. Parties herein have mutually agreed that first party shall pay the said consideration of 3128 inclusive of applicable taxes to JLL in the following manner. Sum of 10 lakhs by check RTGS on or before 18 July. Sum of rupees 10 lakhs payable under check dated 20th August 2022 drawn in favor of second party. Balance sum of 11,28,000 payable under check dated 10 September 2022 drawn in favor of second party. Subsequently, when we deposited the checks, as per their due date, the same were returned unpaid with a remark.
So that 10 lakh is
10 lakh I admit I have received. First 10 lakh I admit I have received. So that would have, my lord, reduced the settlement amount to 21 lakh 28,000. But they, my lord, instead of, my lord, honoring those checks, my lord, those checks were dishonored. And therefore my demand at 206, the last paragraph sees, my lord, kindly sees, I have arrived at the figure of 21 lakh 28,000 because I still wanted to act in terms of the settlement agreement. And I called upon him that please honor your obligations under the agreement.
Fix है क्या है hearing? Yes.
My lord, may I continue? Just facts, my lord, only 2 more minutes. I will complete facts. My lord, so page 206, last paragraph is, my lord, sees the figure of 21 lakh 28,000 is my last, my lord, demand.
Yes.
What देखिए दे 208. My lord, page 208 is the order by which, my lord, lordship was pleased to record that it would be tried as an undefended suit. So they in any event cannot have a defense. But because it's a order 13A, lordship felt that okay, I will permit you to file an affidavit. And I really did not oppose to that direction. Now in the affidavit, my lord, next day whenever lordship gives me time, I will only draw, my lord, 3 paragraphs from the affidavit to show their stand.
Counsel for the plaintiff has argued the matter in connection with GA Com 2 of 2025, but due to paucity of time, hearing could not be completed.
Well, maybe come back tomorrow if lordship wants to, well, come.
Let the matter appear tomorrow.
Great.
क्या मैटर है? प्रणव. Yes.
Reverse. But I appear for the petitioner, but the petitioner has again got that side.
कौन करता है यार ये? हाँ. राजेश उपाध्याय. Yes.
But, to summarize my submissions. In a suit for recovery of money, there can be only one defense. Or below, in fact, there can be one. It can be a dimension or limitation, this, that, but these are not issues. There can be one defense. A, no loan was advanced. B, I have repaid the money. And 3, that I have repaid the money to somebody because you asked me to do it. So therefore, accord and satisfaction. These are the 3 defenses possible. So far as the loan is concerned, it is admitted in this case. 2, so far as the question of repaying the money, he says, I have no liability to repay. That means he is admitting the loan, not admitting the liability to pay. His defense is that the liability to pay in this case is a tribal issue because this loan which I admit is part of a long transaction. And ultimately I can go and show that ultimately it has gone back to a person, may not be to you.
Connected with the person.
Not connected with, he's not even saying that security. So it may not be connected to you, but I have not held the money, I have passed it on. So basically that is saying that I have paid the money to somebody else. To establish that defense, my learned friend will have to show that that passing on was at my instance. He refers to two names in the affidavit. One is K.R. Pradeep and one other is Raju. He says that Raju at the instance was responsible for being Sagittarian and he is the one who has connected. He nowhere in his affidavit says, which I'll very briefly place, to show that Raju is anyway connected to me. Two directors of a company may be best of friends, but even if your lordship takes this to be correct, in a court of law, they will be all treated as separate legal entities. So their friendship will remain, but the companies will function as per their own law. So in that way, even if your lordship will not, I was trying to think yesterday, that if I accept everything to be correct, what more can he lead, what more evidence can he lead in these proceedings? He has led whatever documentary evidence he could have. Documents are showing that it is a loan. Documents are showing that it is a balance confirmation. Document is showing payment of TDS. Now, if these three documents are admitted and not denied, then it is a loan simpliciter. Now, our high courts have held that so far as a balance confirmation is concerned, a balance confirmation is a complete admission of a fact that there is a loan. Now, in this Millard, we have our balance confirmation at and this is not dispute. Oh, yes. Page 37 is undisputed document. Our judgment was okay. Good. Okay.
Yes.
Now, Millard, our courts have held, and Millard, your lordship in one of the judgments have also held, following that passage from 77 Supreme Court, that if you make an acknowledgement of a debt in an account, then the law presumes that being an honest man, you are taking the liability to pay the debt, and that's an admission on your part. I had cited that judgment, and your lordship had passed an order in my favor. But this is another judgment on that point of Millard only, 2020 SCC Online 2123.
HCC Online Calcutta.
Millard 2020 SC Online Calcutta 2123.
Lord, just one submission, Lord. In reply, Lord, the judgment has been shown, Lord. May we just be permitted to deal with it? I will not oppose to.
Very well, Millard. If my learned friend is Millard, here was a case where Millard, your lordship will find in a suit filed by the petitioner for recovery of unpaid price of goods sold and delivered, Millard, the petitioner has taken out two interlocutory first application filed on such and such for judgment on admission to the tune of such and such, along with prayer to restrain the respondent from dealing with the properties pending this one. Second application is one on nature of an application under Order 38 Rule 5 of the Code of Civil Procedure. Respondent also find an application on such and such praying for leave to enter appearance in the suit and for extension of time to file written statement and counterclaim. Millard, exactly the situation that is over here. The application which your lordship is hearing, Millard, is an application for judgment and admission as well as, Millard, for security. And the third is, Millard, our copy ta do, jeta kal niye gele. And third is, Millard, their application for extension of time to file written statement. Now, Millard, kindly, Millard, come to the relevant portion, my lord. Rohit, what is this? Where is my copy? As regards, my lord, I'm sorry, my lord, my learned junior has taken my marked copy. My lord, kindly come to paragraph 90.
19.
90. No, I'm sorry, my lord. I'm sorry, I'm missing that paragraph. Which paragraph was that? The kind of bold that. What did you take? Sir, paragraph 32.
Paragraph
Yes, I'm
22,
sorry, my lord, I said
22, 23.
32. The case that has been run by the respondent is not credible. There was no reason or occasion for the respondent to furnish security to the petitioner in the form of aforesaid checks, which is subsequently dishonored. The respondent has clearly concocted a story which cannot be accepted. This is unfortunate but nothing new. We have come across stories being churned out in a desperate attempt to raise a defense to an otherwise indefeasible claim. I have no doubt that the present is one of them. The defense ought to be raised in the present proceedings, in my opinion, is incongruous, vague, nebulous, and convoluted. The defense is moonshine. In my opinion, no triable issue has been raised by the respondent to the extent of the amount covered by the checks furnished by the respondent to the petitioner, which were dishonored. It will be travesty of justice to relegate such claim claim of the petitioner to trial. The object of Order 12, Rule 6 of the Civil Procedure Code is to enable a party to obtain speedy judgment at least to the extent of admission made by the other party. The admission may be in the pleading or otherwise. A pre-suit admission would also suffice in the present case. I have no reason to believe that the balance confirmations were procured by the petitioner dishonestly. Here it is admitted. The balance confirmation statements clearly amount to admission. The checks furnished by the respondent to the petitioner also amount to an admission of liability to the extent of aggregate amount of the checks. If frivolous defenses are allowed to stand in the way of the petitioner obtaining expeditious judgment to the extent of the admission made by the respondent, the purpose of Order 12, Rule 6 would be defeated. Recalcitrant and unscrupulous parties to a litigation often raise imaginary and meritless disputes and defenses only with the view to protracting the litigation and denying the grant of relief up to the other party. This cannot be encouraged. The petitioner has prayed for judgment and admission to the tune of 1 crore 11 lakhs. However, the amount covered by the 11 checks issued by the respondent in favor of the petitioner is 8746. By issuing the said checks, the respondent in unequivocal terms admitted its liability to the petitioner in the aforesaid sum. The explanation sought to be furnished by the respondent that the post-dated checks were meant for security only and not meant for discharging debt is not acceptable to me for reasons I have indicated above. However, no computation is shown. Therefore, I am inclined to pass a final judgment and decree for the sum of 87. Accordingly, there will be a judgment and decree in terms of the sum of 87. The rest of the petitioners, including claim on shall stand to trial, entitled to costs. Now, Miller, there was a balance confirmation and a check. So the court, Miller, put the two together and said that this is corroboration of each other. Here we have three documents. One is page Miller 37.
37 is balance confirmation.
Balance confirmation. 43 is tax deducted at source. Miller, it starts from page 38. 38. It starts, Miller. Your lordship will find Gyan Traders.
Yes.
This amount is there. And the head of payment is at page 41, which is interest other than interest on securities, 194A.
Yes. Yes.
2 and 43 for a subsequent year also. So there are two balance confirmations, one confirmation of account. Coupled with this, my lord, the statement before your lordship in the affidavit in opposition. My lord, kindly, my lord, come. to the affidavit in opposition. Yeah. Your lordship will get the admission in paragraph 5 and 6. The aforesaid, my lord, has your lordship got it? The aforesaid agreement will be corroborated in evidence by conduct of the fund of 3 crores, which is, my lord, I'm claiming, received from the petitioner company. So, money received admitted was transferred by the respondent company to Sagittarian on 28 and informed by Mr. Patni, which I believe to be true, and have transferred the sum of recruits by Sagittarian to Pronova Electronics. None of them are the plaintiffs. Now, so, no TDS certificate was ever issued to the petitioner, no interest was paid to the petitioner, nor did the petitioner demand interest. Then, kindly, only one balance confirmation was issued for 1 year. Balance confirmation is admitted. And TDS deposits were made for 2 years for giving a color of loan transaction.
Yes.
So, my lord, all the 3 ingredients on the basis of which, my lord,
Yes.
on the basis of which, my lord, I have come to court are admitted. So, my lord, now, my lord, comes the question of, my lord, judgments.
Now, what would be effect? What about the contention with regard to the Pronova Electric Private Limited? Electronics Private.
Pronova my lord, that statement in paragraph 5. My lord, give me one moment.
So, if it is your sister concern,
yes,
if it is a sister concern, and as per the document, as per the statement made by the defendant, that yes, whatever it may be, he has given to the Sagittarian given to the.
No, it's reverse. My lord, I'm sorry.
Yeah.
Sagittarian is first.
Yes, Sagittarian.
Sagittarian gives it to Pronova Electronics.
Correct.
Pronova Electronics gives it to KR Pradeep. KR Pradeep gives it to the plaintiff. Plaintiff gives it to the defendant. Defendant gives it to Sagittarian. Now, from Sagittarian, if it has to say that I have repaid the loan, then either from Sagittarian it will come to the plaintiff, or from Sagittarian to the defendant it will come. That would be repayment. I am out of pocket, it's a loan transaction. He is saying that I have paid it to Sagittarian. Except that if you have paid it to Sagittarian, and Sagittarian is your case that is not connected with Pronova, then where is the question of your repaying to Sagittarian is concerned, to the plaintiff is concerned?
No, that's why
Yes,
paragraph
my lord.
5.
My lord.
Paragraph 5.
My lord.
The funds of rupees 3 crore received from the petitioner admitted. No, there is no denial.
Funds of 3 crore the petitioner transferred the respondent. Yes,
was
no denial.
transferred by the respondent company to Sagittarian.
Correct.
Received and transferred.
And transferred to Sagittarian.
Correct.
Yes.
Sagittarian on 22nd of March. And as informed by the attorney, which I believe to be true, and had transferred the sum by Sagittarian to Pranava.
Pranava Electronics.
And that's why Pranava
Electronics.
Electronics Private Limited. A
So,
sister concern of the petitioner company.
Very well, Millard. I'll address this also. So, Millard.
That is on the rear crux.
Very well. Now take it by. But I had got this feeling yesterday that as a court, Millard, your lordship is thinking in these lines that if I pass a decree today and if I don't allow him to come with a defense, then I will not be able to, or I will not be giving my learned friend an opportunity to prove this statement, which I believe to be correct. He can prove it to be correct, he cannot prove it to be correct. So, Millard, now it comes to the question of, Millard, whether he should be given the liberty to adduce evidence conditionally or unconditionally. Because, my lord, if he admits everything and in spite of that, my lord, the court feels that no, evidence is required, it doesn't mean that my admission on judgment on admission will fail simpliciter.
Correct.
Your lordship can put him to terms that very well, I'm giving you this opportunity, but I'm not giving you this opportunity to drag the litigation.
Oh, yes.
You secure the claim and fight it. Now, my lord, that is the reason 4 situations can arise in this situation. Well, I was apprehending this, my lord, that's why I am developing this second line. Of course, my lord, my learned will get. I had apprehended this yesterday only, my lord, that probably this is what is troubling your lordship, that once I pass a degree and the thing goes out of my hand, I cannot retrieve it. I can appreciate that, my lord. My lord, kindly consider this. That's the reason, my lord, I am arguing this.
Yes.
My lord, kindly, my lord, come to paragraph 17.1 straight away. These are the 4 situations that can trouble your lordship.
Yes.
My lord, if the defendant satisfies the court that he has substantial defense, that is a defense that is likely to succeed, the plaintiff is not entitled to leave to sign judgment and the defendant is entitled to unconditional leave to defend the suit. This is one situation. If the defendant raises a triable issue indicating that he has a fair or reasonable defense, although not positively a good defense, the plaintiff is not entitled to sign judgment and the defendant is ordinarily entitled to unconditional leave to defend. If the defendant raises a triable issue, if a doubt is left with the trial judge about the defendant's good faith or the genuineness of the triable issues, the trial judge may impose conditions both as to the time or mode of trial as well as payment into court or furnishing security.
Correct.
Care must be taken to see that the object of the provision to assist expeditious disposal of commercial cases is not defeated. Care must also be taken to see that such triable issues are not shut out by unduly severe orders as to deposit or security. If the defendant raises a defense which is possible but improbable, the trial judge may impose conditions as to the time or mode of trial as well as payment into court or furnishing security. As such a defense does not raise triable issue, conditions as to the deposit of security or both can extend to the entire principal sum together with such interest as the court feels the justice of the case require. If the defendant has no substantial defense and or raises no genuine triable issue, and the court finds such defense to be frivolous or vexatious, the leave to defend the suit should be refused and the plaintiff is entitled to judgment forthwith. If any part of the amount claimed by the plaintiff is admitted by the defendant to be due from him, leave to defend the suit, even if triable issue or a substantial defense is raised, shall not be granted unless the amount so admitted to be due is deposited by the defendant. My contention is that if in this case loans balance confirmation and TDS is an admitted document, he and the court at the same time feels that this one line that at somebody's instance I have paid, although none of them are connected with me. Patni is not connected with me.
Correct.
Patni is not my director. Sagittarius is not my company. Pronavacity is not the plaintiff. Even then, my lord, seeing at the larger picture, if your lordship feels that he should get a leave to defend or an admission at this stage may not be the right or maybe little harsh, my lord, then, my lord, in my respectful submission, my lord, he should be put on conditions. What are the conditions, my lord? That I leave it to your lordship. Now, my lord, what I'm apprehending another argument is that in an application under Order 12, Rule 6, either there is an admission or there is no admission. This is the argument which I apprehend Mr. Thakkar will come and argue. That if there is an admission, the court will pass an order. Now, my lord, if he argues this, then I say that there is an admission in paragraph 5 itself. But if he wants to leave to defend the suit, then, my lord, he might come and argue this, that the court did not have jurisdiction. That's the reason, my lord, I am showing your lordship that there is also a prayer in my petition for furnishing of security in this very petition itself. And, my lord, he has shown the cause, which is, my lord, the affidavit. The cause shown, my lord, shows that loan, and I must not repeat myself, that loan is more or less admitted. Only thing is, he will have to show whether he can justify before a court of law that payment to Sagittarian and the oral assurance that it will be paid to Pranava, my lord, is can be justified or not. But, my lord, with respect, I was also thinking, and my junior was compelling me to, that suppose, my lord, Patni comes and says that no, this promise which you had, either he will deny, because Patni is not his. As I understand, Patni is not his witness. Patni is not my witness also.
That's why you wanted to be a party to the suit.
So that's the reason, and that has been rejected by the appeal
so
court.
that he come with a pleading.
So and that has been rejected by the appeal court also. My lord, that no, you cannot bring in a third party in a partition suit. But, my lord, even if Patni comes and says, you will have to show some document. You will have to show some transaction. How will my learned friend get hand on these bank transactions unless he knows that Patni is going to help him? So Patni will actually be his witness. If, my lord, ultimately it goes to trial, I will see who brings Patni, because it is he who brought Patni into the picture. I didn't.
He has to prove
He will have to bring Patni. He will have to get in a third party involved. I don't know, my lord, but this, I couldn't think beyond this, that Patni is somebody who is neither here nor there. All he had to show, my lord, was some instruction from me that payment to Sagittarian is good enough.
No,
That
that's
is not
correct.
there.
That
is not even his case. That you, the plaintiff, have asked me to pay to Sagittarian, therefore I have paid it to Sagittarian. That is not his case either. So, my lord, just honestly speaking, my lord, I don't see it's a bona fide defense. But, my lord, since I got this feeling, my lord, I thought, and, my lord, there are other judgments, single bench judgment. Honest man, bole diye. I think duto judgment dekhiye na. My lord, both are single bench judgments. My lord. No? প্রথমটা দেওয়া হচ্ছে প্রতীক ওয়ার্স না My lord, only 2 lines I'll bother. My lord, the first line, this is an application for judgment on admission. That's the first line. My lord, then, my lord, the second last, it is now well settled. I'm sorry.
Just a minute. Yes.
It is now well settled that to obtain judgment upon admission, the admission must be clear and unconditional. Moreover, before passing a judgment of this kind, which is summary, the court should be satisfied beyond reasonable doubt that the defendants have no defense to the claim of the plaintiff. And even if opportunity was given them to contest the trial of the suit, they would be unable to adduce any reasonable defense to counter the claim of the plaintiff. In normal courts, the court should lean in favor of trial on evidence and not summary judgment, unless the facts permit such a kind of judgment to be passed. Then, my lord, turn over the page. My lord, its paragraph starts, my lord. Here, my lord, the facts were not denied, but what I am on is, my lord, it is unfortunate that these allegations are not put on record. They find a place. Very well, that's not necessary. But nevertheless, considering the principle that even if a faint thread of defense is put forward by a defendant, an opportunity should be given to whom to prove it at the trial. I refrain from passing a judgment on admission, but nevertheless, I am inclined to put the defense on terms. Defendants will furnish security by way of bank guarantee, nationalized bank of 20, whatever, Millard. Here, Millard, it is entirely up to your lordship because the Supreme Court says that it's for the court to decide what should be the amount of security.
Yes.
And Millard, the other judgment, Millard, is Millard of our court. Again, Millard, the first line is a judgment upon admission application claiming such and such along with interest. There is also a prayer for attachment before judgment, which is also the same case over here. Kindly turn over the page, Millard. In case of McCulloch has been followed in Uptown, Millard, the one I cited. In case of McCulloch, reported in 77 Supreme Court 5, the Supreme Court pronounced that even where the court thinks that the defendant has no defense to the claim of the plaintiff, the court might of sympathy grant the defendant leave to defend that upon terms set by the court. In this case, I hold in a summary way that the plaintiff is more or less entitled to a sum of rupees 109 on admission of the defendant. Out of sympathy, I permit the defendant to defend the suit upon furnishing security. In the shape of here, Millard, it was a flat and an injunction restraining them from selling or passing. So that was the security offered there. So Millard, it is not unknown practice that even in an application for judgment on admission, the court has the power to put the defendant on terms before allowing him to defend. That depends on the merits. So those would be my suggestions. And Millard, the judgments which my learned friend has cited, they are all Supreme Court judgments on that admission should be clear and unequivocal. That is, I am not wasting time.
Mr. Thakkar is joined online now.
My lord, may I come back at 2 p.m. if your lordship permits me, my lord, to reply?
2 p.m.
Your lordship has fixed matter. Your lordship board is always packed. Any time, any date your lordship gives me, my lord, because now your lordship has heard the matter. It is in our interest, the litigants' interest, that we complete it, my lord. Kindly give us some precedence somewhere, my lord.
Except from 3rd to
8th. Tomorrow?
Not 4th to 8th. 3rd evening, my lord, I am leaving station.
Tomorrow, if your lordships give us, my lord, then that is also, my lord.
Tomorrow the pack.
Tomorrow it will be difficult.
Counsel for the plaintiff has concluded his argument in reply. Full stop. The plaintiff has relied upon 3 judgments accordingly. 3 judgments. Full stop. The defendants press for time to deal with the judgment relied by the plaintiff during the reply. According to case adjourned, let the matter appear on 11th September.
My lord, not 11th, my lord. I will not be coming to court in the morning. 11th, anytime in the second half, if your lordship gives me, my lord.
3:45.
Yes, please, my lord. 3:45.
11th September. 3:45.
Grateful, deeply obliged. My lord, kindly, if your lordships have heard this matter at length, my lord, would your lordship be pleased to mark it as part heard? With consent, if your lordship wants, my lord, record our consent. I don't think
Assigned.
Assigned. Oh, I'm so sorry. Grateful.
Already you persons have taken that benefit.
We have taken that step already.
Deeply obliged.
Deeply obliged.
Yes, sir.
Very obliged.
कौन सा?
May it please your lordship.
हैं? कौन सा? बुलाया कौन सा? ये नहीं है?
आगे दिन order take now. Copy now.
ये 12:30. Yes.
My lord, this is that matter. The probate.
Who is appearing for the BSNL? You are appearing. Have you submitted?
That's in order to
report and my
Huh? Who dependent? So this is the total document you have furnished. So on the last occasion, you are not here.
My lord.
all the persons have brought
Well, that was the resolution, my lord. I know, my lord, the warrant issue.
That's why I kept all the report here. And
May we have a copy of this?
Today the BSNL also filed on the BSNL file, but they have not disclosed the document. No, they have disclosed the document.
They have not disclosed.
On last
Okay,
occasion.
okay,
So today they have disclosed the total document.
Kindly see your lordship's order dated 15 January 2025, page 23, regarding the BSNL portion. Your lordship's direction was the chief general manager, Bharat Sanchar, or any other competent authority to direct the parties the agreement or any written documents entered between the landlady, landlord, BSNL is also situated at the first floor of the four-storied building. And actually, the ground floor as well as the first floor.
So you have given the details.
I have given my
Well, lordship has said the structure of a building.
Yes.
My lord, during the lifetime of the committee, my lord, 2-3 agreements was executed, and after his demise, 2 agreement with his daughter. And my lord, another direction was what was the total payment. My lord, that was I have also stated, my lord.
20,72,000.
15 lakhs 80. That is at page 9, my lord. Page 9, paragraph 9.
Yes.
My lord, that the concerned authority of the Kharagpur BA West Bengal Telecom Circle Bharat Sanchar Nigam has been paid total rent, ground floor, first floor of the said building, Nandikram telephone exchange, and for generator room. My lord, another said was there, generator room was said for the said Nandikram telephone exchange building for the period from November 13 to till July 2025, 15 lakhs 81,842 money. And my lord, I have also given the bank account of Sudipta Maiti and my lord, details of the bank account.
In which the amount was deposited. In which that amount were deposited.
And my lord, kindly come to the next paragraph 10. My lord, the BSNL directly, my lord, paying the electricity charges to the, my lord, the West Bengal State Electricity Distribution Company Limited.
Yes.
And my lord, I have also given the chart, prepared a chart, my lord, from November 2013 to till, my lord, the July 2015 one. And my lord, I have also given a chart, my lord. That chart is, my lord, regarding payment of rent from page 53 to page, my lord, 65. That is the regarding the payment of rent towards, my lord, the Sudipta Maiti. For every month, my lord.
No, page 53 not available. Page 53, Annexure E not available. 53 to 55, 56 not available. 2016 details are not available. No, this you have given the details on NA. So NA, how the department say it is not available? It is a fund transfer from the department.
That was subsequently paid. When payment was made, that was calculation is given. Actually, due to demise,
Lordship is correct. Calculation given, but 14, not 13. Lordship correctly pointed out.
My lord, that was paid. Thereafter, my lord, including the area from page 57.
কত টাকা করে ভাড়া দিতেন আমাদের প্রপার্টিতে দাদা? ও দাদা,
No, that
কত
is
টাকা করে
correct.
ভাড়া দিতেন আমাদের প্রপার্টিতে?
Page 57 onwards, you have given the details with regard to the transfer of amount from July 17. 10,284.
Yes,
correct?
Yes.
From July 2017.
Yes.
Prior to July 2017 and it starts from November 2013 from the date of death of the testatrix.
Yes, my lord. Kindly see the total, my lord. 66,930.
66,930.
Yes, ma'am.
So, yes, to 10,280 is with the monthly rent. Kindly come to the page 57.
Yes.
July 17 to December 2017 per month is 10,200.
Yes, my lord. No, thereafter, my lord, that was increased at the rate of
Correct. Increase. But this is 10,284. That is a monthly. So if it is a monthly, so okay, it is correct that 66,930. With regard to the prior to 2017, from 2013 to 2017, what has happened?
Testatrix died on 17/5/2013. Lordship has
That's what I'm
recorded.
telling,
My
13 November, that's it, after
My
the death, because
Yes.
number 2013,
My
they are stating that no, nil.
My
What was the actual payment, my lord? I have given that.
So what has happened to this 719? What is your, what you have stated in Exhibit E? Where is your statement? Which paragraph you have described the Exhibit E?
My lord, that was not stated, my lord.
Paragraph 9.
That was the total amount which was paid from.
So what has happened to the 13 to 7 July 7 June 17? What has happened to that amount? You are in possession, you are the government authority. Either you deposit or you are not paid. If you are not paid, then it has to be recovered from you.
Yes, definitely.
Or if it is you have paid, then to whom you have paid? In nil not available, how it can be? That's why this court has called for. That is the main crux of the point here.
That was also stated, my lord. That portion is, that record is not available.
What? Your accounts, BSNL accounts are not there. BSNL accountancy is not there. Or every year there will be an audit.
Yes.
How much amount has been paid to the rent? Then how you can say there is no? You are the BSNL. You are the authority.
So, my lord, I shall, my lord, again ask to them, my lord, to if there is.
Yes, please. That is the main crux. After the death of the testatrix, till the payment of Mathi, what was the amount where you have paid, in which account you have paid? If you are not paid, what is the due? Because at the time of distribution, in terms of the will, the court has to clear cut pass an order. He is entitled so and so, so and so, they are entitled so and so, so and so. If it is not here, how the court can pass an order?
And my lord, I have not, BSNL is not paying any other taxes or charges to anyone, seven except this
Electricity and rent, that is only concern.
66 regarding the payment of electricity.
That is only concern. So you take instruction from page 53 to page 57 from November 2023 till June 2017. What has happened to the rent of the premises in question?
My lord, I think BSNL has not come up with the correct picture. Please, excellent. My lord, the own report, their own affidavit says that 13, 14, 15, 16, 17 BSNL paid.
That's what I'm telling. They
Supplementary
paid.
affidavit filed by Sudipta Maiti on May 10, 2022.
That's why that also description.
Exactly.
There is a discrepancy in the statement made by Sudipta.
What I want to impress, my lord, they say possibly the payment was not made. Sudipta Maiti said payment was made.
Paid. That's why I'm done. They cannot say in the affidavit it nil or not available. So if it is not
Either
available
paid
in
or
your
outstanding.
office, if it
Kindly record that in between this period, total payment is, my lord, that 15 lakhs and odd money. That is the page paragraph 9.
Okay. And with regard to the who has died?
My lord, Sudipta Maiti.
Then what?
My lord, here, my lord, I have something to say. Pursuant to your lordship's, my lord, order passed on the last day, because we came to know that the ultimate, my lord, the lady, my lord, who made a hodgepodge and my lord took all the properties. He died.
The culprit of her death.
I do not know, my lord. I do not know. But my lord, I can only say, my lord, with the God forbids, my lord, everything has a return. I can only say, but I always pray, my lord, this rest everybody's soul, my lord, be set at peace. Now, we have communicated a letter to the advocate on record. He initially refused to accept. Then, my lord, my advocate on record personally called him. Say that kindly accept. This is the court directions that you have to intimate who are the legal heirs, who are the sound, who are the sui juris, so I have to implead them. Then he said that I have to talk to my counsel. Then he said, no, my counsel says that since our client has died, we will not give you any details, or we do not have any details. So as of now, my lord, my property, I am one of the co-sharer. I am the youngest daughter.
She is the administrator now.
She happened to be the administrator.
She was the administrator.
Now she died. Now the second daughter has not come.
She is not coming. You are the only three.
No, she has not come despite of repeated service. So I am the only left one. The property has to be managed by someone, my lord. So with your lordship's kind wisdom, upon my lord supervision, till the time whether the matter is disposed of, because my lord, otherwise where I am the beneficiary, my property is being wasted. No person will give any rent. The property could not be maintained, which is not being maintained at all. Now I put my level best. I try to intimate, my lord. I try to take out the informations. This is the affidavit of service. This is what I have, my lord, submitted, my lord, on affidavit. So some, my lord, befitting order and suitability, my lord, of this property, because she expired, nobody is there.
When she died?
My instruction is 14th August.
14th August.
August. And my lord, I have to pay discharge many statutory dues also, property tax, electricity bills.
Correct. For that, let us. Okay, what I propose to do, I will direct all the reports which have been received by this court.
My lord.
So you pay the cost of the Xerox and it will be provided to you.
My lord, my advocate will provide.
Because they have given one copy on IRS.
Yes. We do not want to do from government exchequer.
So you take, I will direct the office to make it Xerox, give it to you, whatever the cost be realized from you. First thing. Second thing, I will direct him to give the supplementary affidavit giving the details from November 2013 to June 2017 with regard to the rent.
Including whatever other details that being left out, because with the shortest time, it is not also possible for a lordship to go
And
through
with
the entire
regard to your affidavit, so let you go through this affidavits, what the reports the authorities have filed, you go through, if any discrepancies are there, you point out, then on the basis of that report, then I will appoint a special officer for the time being to collect all the rents and see the accounts and all these things.
But
and
till the time, it would also take some
I am
time.
fixing on the next week only, no problem. Next week.
By that time already, the rents of August become due.
That's why, because unless and until you will go through, because if if this court is appointed a special officer.
No, I do not say, my lord, this to appoint a special officer. I say appoint my client
that
as an
then
administrator.
It will be created because the other part, the other sister is not coming here.
No, that is his own wisdom, my lord, his own risk and peril.
Coming here. So she's not coming here.
Because, but since, my lord, admittedly, I am one of the equal beneficiaries. So, my lord,
or your advocate on record may be allowed to take care of this for the present.
Yes. Kindly engage my advocate.
First you go through this. First you go through the report.
Well, I say we would go through, but pending going through, my lord, kindly.
Because you see what.
Well, this is not the only solitary document. I have to see the other documents also.
Some persons are giving the cash. Some person is giving, some of the department telling that we are giving this cash.
In the meantime, what Interim, what we may do, I understand. I followed bow down. Lordship is fixing immediately on the next week or something of the shortest time. In the meantime, with my lord's kind wisdom, the permission, my lord, let my advocate on record issue letters to all the tenants that you give us the details and the rents and the quantum.
That's why details. That's why I'm telling that it's not required. All the things on record. You go through and give the total chart. You prepare the total chart so that.
No, I say, my lord, these are with regard to only the government authorities. There are the private persons.
The SHO was also filed in the station was of in.
No, the private persons are there.
Yes, private persons details is also there.
Okay, madam.
That officer in charge of the Nandigram police station has also filed the report. The private, who are the private persons and what is the rent and that is also there. That's I'm telling you. Go through this and make the chart. Come on the next day. I will pass the appropriate order directing your advocate on record to collect all the rent and to deposit in the one account.
Very well.
That will be better.
Very well.
May I hand over one copy of my report?
Yes, give the.
And my lord, kindly, my lord, one line clarification may be given. My lord, if that amount of since from November 2013 to my lord the June 2017 is not paid, then that amount paid upon whom, my lord?
No, that's why I'm telling you, give the total details. What has happened to this period, whether the amount is paid or not. If it is paid, to whom it is paid. If it is not paid, to give the.
And my lord, what is in my prayer is, my lord, kindly direct. If not paid, then the same will be paid upon whom. And my lord, from the.
No, that's why I am not telling. Give the report if it is not paid. Then I will appoint a special officer. He will collect.
And my lord, from the month of August 2025 and onwards, my lord, that will also.
That's why I'm telling. I am fixing a next week. So one special officer or advocate on record will be allowed to collect all the rent to maintain an account.
And my lord, kindly also direct the department to take my accept my
You file, yes, I will pass an order. The counsel for the BSNL has filed a report after serving the copy to the London counsel for the respondent number, counsel for the applicant / petitioner. Let the same be kept with the record.
Let's record my submissions that we made a effort.
It is fine from the report filed by the BSNL authority that from page number 53 to page number 57, that is from the month of November 2013 to the month from the month of to June 2017, it has been mentioned about the rent is nil or NA. Nil or NA. Full stop. The authorities have not indicated whether the rent was paid or not paid and what was the rent. And as such, to decide the case and to decide the instant case, the total rent paid or not paid by the BSNL authority is required to be brought before this court. Accordingly, the BSNL authority is directed to file supplementary affidavit with regard to the rent from the month of November 2013 till the month of June 2017 within a week from date. Police counsel for the BSNL authority prays for leave to file wakalatnama and affidavit of competency. Let the same be filed in the department by tomorrow. Police.
I have also some copy of this report too.
I already recorded. Police stop. As per the order passed by this court dated 22nd of August 2025, the counsel for the petitioner / applicant submit that the advocate on record of the petitioner has requested the advocate on record of the respondent number 1 within brackets since deceased. Respondent number 1 within brackets since deceased for giving the details of the legal heirs of the respondent number 1 and the date of death of the respondent number 1, but the advocate on record of the respondent number 1 has not provided the details. Counsel for the petitioner prays for submits that as the respondent number 1 passed away, and as such the petitioner may be appointed to receive the monthly rent of the premises in question and also to pay the property tax and other taxes to the concerned authorities for the interim period till the disposal of this application. Considering the submission made by the counsel for the petitioner, this court find that the respondent number 1 was appointed as the administrator. Now she passed away. As per the order passed by this court, all the authorities, including the officer in charge of the Nandigram police station, has submitted their report with regard to the persons who are in occupation of the premises in question, as well as the monthly rent of the persons who are in occupation of the premises. In view of the above, this court is of the view that the report submitted by the authorities is to be supplied to the advocate for the petitioner by the department, subject to payment of cost of the Xerox by the petitioner.
May I say this? My advocate would undertake, he would take the copy and bring it back, because otherwise doing from the department may take some time.
No, it will be done.
Very
payment of cost. Police. The department is directed to immediately get the Xerox of all the reports submitted by the authorities, including the BSNL, which is filed today.
By tomorrow, can you fix a date?
By tomorrow, by आज कितना तारीख है 2 तारीख by 4th of September 2025 and to supply the same to the learned counsel and learned advocate for the petitioner by 8th of September 2025. Full stop. And also to notify the cost of the Xerox to the learned counsel for the petitioner and the learned counsel for the petitioner to pay the cost of the Xerox at the time of delivery of the reports, copy of the report to the learned advocate on record of the petitioner. Full stop. As regard the appointment, as regard the authority to collect the rents and payment of the property tax after the death of the administrator appointed
including
by this
electricity
court,
bills and others.
the said matter will be taken off for hearing shall be decided on the next date of hearing. Let the matter appear on 11th of September 2025. 1 बजे खाली है क्या? 1 बजे खाली है? At 1 p.m.
And only the copy of the BSNL has already been handed.
Recorded, I recorded.
11th at 1 p.m. And we would get the copy by 8th. But it may be in this week itself, so that we can come up with.
But
maybe get the copy by 4th.
No, because Xerox and all these things.
Very well.
That's why I fix on 11th. You will get 8, 9, 10.
Very well. As your lordship. As your lordship.
Yes.
I'm grateful. Obliged.
And learned senior is also here.
Who is appearing?
Lordship, I appear on the
Judgment chapter number
4.
What is the name?
Ajay Chaudhary. 18th of August, your lordship was pleased to pass the order with respect to the issuance of warrant.
Ajay Chaudhary.
Ajay Chaudhary. I must indicate, to be fair, in the first occasion, your lordship had directed the filing of the affidavit of assets. Lordship,
Where is your judgment? When the warrant was issued?
On 18th of August 2000.
By an order dated 18th of August 2025. This court has issued warrant against the judgment debtors number 4 to 8. Judgment debtor numbers 4 to 8. Judgment debtor number 1, 2, and 3. And against the warrant issued against the warrant, comma, the judgment debtor numbers 1, 2, and 3. They have appeared. ये last order कहाँ है? कौन appear किया उस दिन? 6 and 7. क्या बोला? Against the warrant issued by this court, comma, the judgment debtor number 6 and 7 have surrendered before this court on 1st of September 2025. And have also filed their affidavit of assets. Accordingly, the warrant against the judgment debtor number 6 and 7 have been recalled with the direction to the judgment debtors to the said judgment debtors to appear before this court as and when directed by this court. Today, the judgment debtor number 4, namely Ajay Chaudhary, is surrendered has voluntarily surrendered before this court against the warrant issued by this court dated 18th of August 2025. Full stop. Counsel for the judgment debtor number 5 submits that 4 submits that he will file the affidavit of assets on the next date fix. In view of the submission made, full stop. Consider the submission made by the counsel for the petitioner, counsel for the judgment debtor number 4, and also taken into consideration that the judgment debtor number 4 has voluntarily surrendered before this court against the warrant of arrest issued against him. Against him. Accordingly, the warrant issued against the judgment debtor number 4 is recalled with the direction to appear before this court on 9th of September 2025 and also to file the affidavit of assets on the date fix. The warrant recall bol diya na. Let the matter appear on 9th September for filing affidavit of asset by the judgment debtor number 4.
Very grateful to you. My lord, Mr. Ray had mentioned the matter. My lord had asked us to come at 1:15. Mr. Ghosh, they are both online, my lord.
It's for the other side.
Mr. Rupak Ghosh is on the other side.
I'm there, my lord.
And I was only
Yes,
this
Mr.
is taken up on Monday. my lord.
Perhaps, what can be
My
done?
lord, although my lord, defendant in a plaint which has not been presented do not have a right of audience, but since Mr. Ray has already intercepted and he wants it on Monday, my lord, I'm not standing in the way. Let it be Monday, my lord, but let some time be fixed.
Yes, yes.
Monday.
I'll be very grateful to your lordship.
Monday,
And also to Mr. Ghosh.
No.
पहले कब है? अब का डेट कब है?
Also, my
It's on
concession
Thursday,
is
3:45.
largely. Also, my concession is largely because there is a full court reference on Thursday.
On
So
4th? Okay,
my
then
lord, on 4th there is a full court reference by Mr. Dastur.
Huh?
So let
कब है? 11 September 11:30. हाँ, unlisted motion है तो ठीक है, उसको नोट कर लो फिर. Then 11 September at 11:30.
my lord.
Mr. Ray,
So deeply.
Great. क्या नाम की?
I am for the caveator, Your Lordship, in this matter.
Yes.
Witness is here, Your Lord.
एक काम करो, पीए है ना, ये मैडम को बोलो आने के.
With Your Lordship's name.
Yes, yes.
कमती हिंदी ज्यादा.
आज आप पहली बार आए थे ना गवाही देने के लिए, ठीक है, मेरे साथ बोलिए। मैं कसम खाता हूँ
मैं कसम खाता हूँ
जो कुछ भी बयान दूंगा
जो कुछ भी बयान दूंगा
वो सच होगा,
वो सच होगा,
मेरे बयान में कुछ झूठ नहीं होगा,
मेरे बयान में कुछ झूठ नहीं होगा,
ईश्वर मेरे सहायता करेंगे, ईश्वर मेरे सहायता करेंगे।
ईश्वर मेरी सहायता करेंगे।
आपका नाम?
रमेश कुमार केजरीवाल।
रमेश कुमार केजरीवाल।
डीडब्ल्यू
पिताजी का नाम?
श्री मुरारी मोहन केजरीवाल।
डीडब्ल्यू
करती है मुरारी मोहन केजरीवाल, लेट मुरारी मोहन केजरीवाल। आपकी उम्र?
5 फरवरी 1960।
आपकी उम्र?
हाँ, 5 फरवरी 1960।
नहीं, आपका उम्र कितना है बताइए?
65।
65 इयर्स। क्या करते हैं आप?
बिजनेस, सेल्फ एम्प्लॉयड।
सेल्फ एम्प्लॉयड, बिजनेस को दो। आपका घर का पूरा पता बताइए।
8/3B
8/3B
अलीपुर पार्क रोड,
अलीपुर पार्क रोड,
कलकत्ता 7,27,000।
आपका क्वेश्चन DW2 राइट?
DW1 डिपेंडेंट DW1
धीरे धीरे से बोलिए।
डिपेंडेंट विटनेस नंबर 1.
May I start, Your Lordship?
Yes.
Mr. Kejriwal, how are you connected with this instant case?
आप इस मुकदमे से कैसे संपर्कित है बताइए।
हमने कैविएट किया था हाई कोर्ट में।
I have filed a caveat in the High Court.
What was the purpose of filing the caveat?
इस caveat को फाइल करने का पर्पस क्या था? किस उद्देश्य से आपने ये caveat फाइल किया था?
माने हम एंटिसिपेट कर रहे थे कि कोई मेरा भाई कोई केस करेगा या कुछ प्रोबेट करेगा या उसी के लिए।
I was anticipating that my brother would file any probate application regarding the will of my father.
Will.
The last will or testament of my father. That's why I filed the caveat.
Are you aware of the facts of this present case?
इस केस के बारे में आपको सब कुछ पता है?
हाँ, नहीं हमको मालूम है।
Yes, I am aware of the facts of this case, instant case. Aware of it.
Can you tell this honorable court what is this case about?
क्या आप इस कोर्ट को बता सकते हैं कि ये केस किस बारे में है?
ये एक महेश ने कोई जमा दिया है विल, उसको वो कंफर्म करना चाहता है।
Mahesh has submitted a will. Mahesh has submitted a will before this honorable court. He
want to confirm the said will from this court.
होता है ना वो पक्का।
He wants to confirm the will.
Are you aware of any persons, namely Murari Mohan Kejriwal and Savitri Kejriwal? हाँ, वो ये
मुरारी मोहन केजरीवाल कौन है?
वो मेरे पिताजी हैं, फादर।
मुरारी मोहन केजरीवाल is my father, but was my father.
और सावित्री देवी केजरीवाल my mother.
And Savitri Devi Kejriwal is my mother.
Is Savitri Devi Kejriwal alive?
क्या सावित्री देवी केजरीवाल अभी जिंदा है?
नहीं, उनका डेथ हो गया।
No, she passed away. She's dead.
How are you related with Mahesh Kumar Kejriwal?
महेश कुमार केजरीवाल से आपका नाता क्या है?
महेश मेरा छोटा भाई है।
Mr. Mahesh Kumar Kejriwal is my younger brother.
How was your relationship with your father and mother?
कि पिताजी और माताजी से आपका संपर्क कैसा था?
मेरा संपर्क बहुत अच्छा था दोनों से।
I had a very cordial relationship with both of my parents.
Mr. Kejriwal, did your family have any family business?
आपका परिवार का कोई पारिवारिक बिजनेस था?
हम लोग का था, बिजनेस
Yes.
था हम लोग का।
Yes, we had a family business.
Are you aware of any company, namely Sri Hanuman Cotton Mills and Sri Hanuman Foundry and Engineering Company?
Hanuman
Cotton Mills
Mills.
Limited and Sri Hanuman Foundry and Engineering Company Limited.
इस
नाम
दो
तो
नाम
लिखे
के कोई कंपनी को आप जानते थे?
हाँ हम जानते हैं दोनों के नाम
Yes,
में।
I know.
और
how is your family related with these companies?
आपकी फैमिली इन दो कंपनी से कैसे संपर्कित थे?
हम लोग 1989 में इस दोनों कंपनी का शेयर खरीद लिए थे।
In the year 1989, we bought the shares of these two companies.
बगड़िया फैमिली से हम लोग ने शेयर खरीदा था। बगड़िया
From the Bagadia family, we bought those shares.
Purchase.
We purchased those shares.
We have purchased the shares from Bagadia company.
और इस कंपनी का कंट्रोल हम लोग के पास आ गया था फिर।
And by purchasing those shares, the control of these two companies, by purchasing those shares of those companies, the control of the company came into our hands.
Are you aware of any immovable property of Hanuman Cotton Mills Limited?
हनुमान कॉटन मिल्स लिमिटेड का क्या कोई खबर संपत्ति के बारे में आपको पता है?
नहीं,
प्रॉपर्टी वगैरह?
Immovable property.
Immovable, हाँ
स्थावर?
हाँ
Yes, I know.
ये हमको मालूम है।
Don't say yes, say yes. Yes, I know.
हाँ यस मालूम है हमको। तो वो
Please indicate.
वो क्या, हाँ वो हनुमान कॉटन का लैंड है। लैंड 24-25 एकड़ करीब लैंड होगा फुलेश्वर में।
That is the land of Hanuman Cotton
Mills
Limited, which measures to 24 or 25 acres. Measuring to 24 or 25 acres.
ये सर हनुमान कॉटन मिल्स कंपनी लिमिटेड, प्राइवेट नहीं।
Hanuman Cotton Mills
कंपनी लिमिटेड। तो 25 एकर्स करीब लैंड है उसमें।
There are 25 acres land. There is almost 25 acres of land.
Are you also aware of any factory shed or building over the plot of land? Factory or shed over the plot of land?
जो प्लॉट लैंड है उसके ऊपर क्या कोई फैक्ट्री शेड या कोई
इस जमीन के ऊपर कोई फैक्ट्री या कोई स्ट्रक्चर है जो जमीन?
हाँ सर, इसके ऊपर में एक फैक्ट्री है श्री हनुमान फाउंड्री इंजीनियरिंग कंपनी लिमिटेड के नाम से।
What is there on the land? What is there on?
Yes, on the said land there is a structure.
फैक्ट्री, उसके ऊपर में शेड है, बिल्डिंग है, फैक्ट्री में जो होता है सभी है सर।
There is a construction which has sheds, factory, etc.
When Kejriwal family purchased the company, what was there in that particular plot of land?
केजरीवाल फैमिली ने जब वो शेयर्स बाय किया, परचेस किया, तब उस प्लॉट ऑफ लैंड में क्या था?
उसमें 1 लाख स्क्वायर फुट का शेड था और उसमें एक ऑफिस बिल्डिंग था।
There was a 1 lakh square feet shed on that plot of land at that point of time when Kejriwal family there was 1 lakh square feet shed at that point of time when Kejriwal family bought those shares. बोलूं?
ऑफिस बिल्डिंग।
There was also an office building.
स्टोर्स।
कांटा
होता है ना लॉरी को वजन करने का कांटा, माने वेव ब्रिज। मंदिर था, मंदिर,
There was also a
टेम्पल
और कुछ
और छोटा मोटा कुछ
and other small
पैटर्न शॉप, ये वो जो फैक्ट्री में होता है सभी था, मतलब रनिंग फैक्ट्री।
It was a running factory.
Was there any joint business of family Kejriwal family?
केजरीवाल फैमिली का कोई जॉइंट बिजनेस था?
हाँ, हम लोग का जॉइंट बिजनेस था सर।
यस, वी हैड अ जॉइंट बिजनेस।
What was the nature of the joint business?
ये जॉइंट बिजनेस किस तरीके का था? कौन सा बिजनेस था?
एक तो यही बिजनेस था जो फैक्ट्री हम लोग लिए 89 में, ये हनुमान कॉटन हनुमान फाउंड्री जो कि फाउंड्री चलता है, मतलब एक तो ये बिजनेस था।
The one business was a foundry business.
फाउंड्री बिजनेस जो 89 में लिया हम लोग।
For which we bought the Hanuman foundry in the year 1989. 1989 बोलिए।
और दूसरा बिजनेस था हम लोग का मशीन का।
And another business was of machines.
उसमें
What do you mean by machine business?
मशीन बिजनेस आपने बोला, उसके द्वारा आप क्या बोलना चाह रहे हैं?
सर मशीन बिजनेस का मतलब है उसमें हेवी अर्थ मूविंग इक्विपमेंट्स, क्रेन, डंपर, डोजर, एक्सकावेटर्स, ये सब था उसमें।
ये सब आप मैन्युफैक्चर करते थे?
नहीं, ये सब मशीन उसमें परचेज किया हुआ था और ये हम लोग भाड़ा में देते थे इसको।
We have purchased heavy earth moving
equipments
like
क्रेन,
cranes,
डंपर,
dumpers,
डोजर, एक्सकावेटर्स,
cranes, dumpers, dodgers,
एक्सकावेटर्स,
etc. We have purchased those machines and we used to provide those machines on rent.
What do you mean by foundry business?
फाउंड्री बिजनेस के द्वारा आप क्या बोलना चाह रहे हैं?
फाउंड्री बिजनेस में मैंने वो लोहा को गला करके कास्टिंग बनाते हैं, तो हम लोग रेलवे स्लीपर बना रहे हैं, रेलवे स्लीपर।
In the foundry business, we used to melt irons and by
melting iron,
we used
आयरन का प्रोडक्ट बनाते हैं। जैसे
we used to produce iron products. Used to iron products like
रेलवे स्लीपर,
railway sleepers.
ये फाउंड्री बिजनेस में ही आता है ये।
This all comes under foundry business. These things.
बोलो।
We used to produce iron products like railway sleepers. These things all comes under the foundry.
Hey, iron melting ওটা লেখুন।
Iron melting.
By melting irons, we used to
produce iron products.
लोहा को गला करके।
These things all comes under foundry business.
Are you aware of any loan obtained by Hanuman Foundry?
क्या हनुमान फाउंड्री ने कोई लोन लिया था? इसके बारे में क्या आपको जानकारी है?
हमको जानकारी है सर।
यस।
डिटेल बताएं।
बोलिए। यस, आई हैव नॉलेज अबाउट द लोन। बोलिए।
ये हनुमान फाउंड्री काम चलाने के लिए आईएनजी वैश्या बैंक से लोन लिया था। वैश्या बैंक।
टू ऑपरेट द कंपनी प्रॉपर्ली वी हैव टेकन अ लोन फ्रॉम आईएनजी वैश्या।
नहीं, उस समय आईएनजी नहीं था, केवल वैश्या बैंक, VYSYA।
वी हैव टेकन अ लोन फ्रॉम वैश्या बैंक।
VYSYA, वैश्या बैंक लिमिटेड।
वैश्या बैंक लिमिटेड।
वर्किंग कैपिटल लोन लिए थे उससे हम लोग।
We have taken a working capital loan. Amount বলতে পারবেন?
ওদের ক্লেম ছিল স্যার 10 কোটি, কিন্তু কত নিয়েছিলাম মনে নেই, কিন্তু ওদের ক্লেম ছিল 10 কোটি।
The exact amount of the loan, but the claim was 10 crore rupees.
10 crore 35 lakhs ऐसा कुछ।
10 crore 35 lakhs approx कर दो।
DRT में केस किया था लोग बाद में।
Were you involved with that particular loan amount obtained from Vaishya Bank?
क्या ये जो वैश्य बैंक से आपने लोन लिया था, इसमें क्या आपका इन्वॉल्वमेंट था ये लोन लेने में?
हाँ, इसमें मेरा भी था और फादर का भी था, ब्रदर का भी था। हम लोग तीनों ही गारंटी दिए थे इसमें।
यस, आई हैव इन्वॉल्वमेंट इन टेकिंग दिस लोन along with my father and my brother. We all were we were the guarantors. We all three were the guarantors.
what were your and Murari Mohan Kejriwal as well as Mahesh Kejriwal's status in connection with the loan?
आपका मुरारी मोहन केजरीवाल का और महेश केजरीवाल का क्या स्टेटस था इस लोन के चलते?
हम लोग तीनों ही इस कंपनी में डायरेक्टर थे उस समय.
All three of us were the directors of the company at that point of time.
और लोन लेने के लिए
बोलिए.
लोन लेने के लिए हम लोग तीनों ने बैंक को अप्रोच किया और अपना गारंटी दिया.
To take the loan, all three of us approached the bank and provided our guarantee.
Was your father always active in running the family business?
क्या आपके पिता
What was your father's role? No, was there any what was your father's role in running the family business?
ये जो फैमिली बिजनेस था इसको चलाने के लिए आपका पिताजी का क्या भूमिका था बताइए.
मेरे पिताजी 1989 तक काम में इन्वॉल्व थे.
Till 1989, my father was actively involved in the business, in the family business.
1990 से 1990 से वो धीरे धीरे बिजनेस से मैंने हटते गए. ऐसे ही कुछ परिस्थिति बन गया घर में तो वो बिजनेस से हटते गए उसको 1990 से.
From the year 1990, he gradually was distancing himself from the family business as there was some
ऐसा सिचुएशन हो गया.
circumstances in the family.
Who look after the foundry business?
ये जो फाउंडरी बिजनेस था इसको कौन देखभाल करता था बताइए.
फाउंडरी बिजनेस को हम देखभाल करते थे.
I used to look after the foundry business.
What about the machine division?
Machine division कौन देखभाल करता था?
मशीन डिवीजन महेश देखता था सर.
The machine division used to be looked after by Mahesh.
How was the foundry division performing?
Foundry division कैसा चल रहा था?
सर फाउंड्री डिवीजन हम लोग लिए थे कि वो रेलवे स्लीपर बनाएंगे.
We took the foundry division to produce railway slippers.
But unfortunately 1990 से
But unfortunately from the year 1990
गवर्नमेंट का पॉलिसी चेंज हो गया.
the policy of the government was changed.
CST 9 स्लीपर लेना बंद कर दिया.
CST
9 स्लीपर ये लोहा का बनता है. CST 9
The CST 9 sleeper used to be made with the irons.
गवर्नमेंट फिर कंक्रीट स्लीपर स्टार्ट कर दिया.
But from 1990 government started to take concrete slippers.
तो इसमें लोहा का स्लीपर नहीं बिकता था.
For which the iron slipper was not sold at that rate.
ये in that place मतलब हमारे कंक्रीट की जगह लोहा तो नहीं चल सकता है.
At that place of concrete plate को दो. Sorry, slipper.
But unfortunately, from 1990, the policy of the government was changed. CST 9 slippers used to be made with iron, but from 1990, the government started to take concrete slippers, for which the iron slippers was not sold at that rate, at the place of concrete slippers.
Government did not require CST 9 स्लीपर.
Right, sir.
और ये हाँ थोड़ा सा और ये कारखाना क्या है कि स्लीपर बनाने के लिए था ये, तो फिर हम लोग का कारखाना ठीक से चल नहीं पाया. फिर
Producing slip.
Run the
factory properly. There was no demand from the database.
How was the machine division performing?
मशीन डिवीजन कैसे चल रहा था?
सर ये मशीन डिवीजन अच्छा चल रहा था उस समय.
The machine division was going well at that point of time.
वो
At that point of time.
कि उस समय वो काफी काम मिल रहा था हम लोग को भाड़ा में चलाने के लिए.
We were having many contracts for the machines. Them on rent.
The translation is coming with us.
Were you aware of the accounts of machine division?
मशीन डिवीजन के अकाउंट्स के बारे में क्या आपको नॉलेज है?
नहीं सर, वो 90 के बाद से तो हमको कुछ मालूम नहीं, क्योंकि वो
No, I do not have any knowledge of the accounts of the machine division after 1990 because
वो
since 1990.
हाँ, वो महेश कुछ अकाउंट्स देता नहीं था.
Because Mahesh did not use the details of the accounts. Did not used to give me the details of the accounts.
Only one thing. Witness is saying hum. Actually, hum in some parts of the country means me, not we.
हम अकेले ही हैं मतलब.
Hum is me. Hum.
Me.
For him, hum is me. Yes, yes.
There are some parts of the country which says hum means we.
No, it can be used both singular and plural. Yes.
In Bihar,
Yeah,
Odisha,
whatever.
we use hum means we. Me.
Yes.
But in Delhi, it's hum means
Hum
we.
log. Hum. Oh, मैं.
We. But in Bihar, yes.
You are all in India.
No.
माने कि we. मतलब बोलो. Mr. Mukherjee referred to Hindi cinema with that same name. Hum.
Whenever we used to go to Delhi, so we were from Jharkhand. So when we say hum, they could not recognize. They use मैं.
এখানে কি প্রবলেম
হাম যদি বলে তো ওটাকে আই করবে না, আমি ভি করলে কিন্তু পুরো জিনিসটা ঘুরে যাবে.
বুঝতে পেরেছি.
मेरी माँ रांची से थी ना, तो बिहार का.
Witness box में
ओ अच्छा.
Did Mahesh ever interfere with the foundry division?
क्या महेश कभी फाउंड्री डिवीजन के काम में दखल अंदाजी करते थे?
हाँ सर, वो
Yes.
90 के बाद में तो कारखाना ठीक से चल नहीं रहा था.
After the year 1990, as the company was not running properly, as the foundry company was not running properly. बोलिए.
तो वो कई तरह से इंटरफेयर करता था, डिस्टर्ब करता था.
So he used to interfere and disturb in the running of the business.
वो उसका था कि ये कारखाना डूब रहा है या डूब जाएगा, साथ में हम भी डूब जाएंगे.
He used to say that if the company fails or sinks, we would sink with that. Say that if the company sinks or fails, we would also sink. Monetarily.
उसका वर्ड यही रहता था, आई एम नॉट विद द सिंकिंग शिप, ऐसे ही बोलता था वो.
He used to say that he don't want to board on a sinking ship. SHIP. Right, sir?
वो एक और था सर, वो बोलता था कि हमारा गारंटी दिया हुआ है इसमें, तो हम भी इसमें खराब हो जाएंगे या जो भी.
He used to say that as he has given a guarantee taken in the name of this company, his name also come. He will face a monetary loss, brother. He will also face a monetary loss if the company fails. He will also face a monetary loss if the company fails. Right?
how was your relationship with Mahesh?
महेश के साथ आपका नाता कैसा था?
सर ये शुरू में तो बहुत ही अच्छा था, फिर बाद में ये
At the beginning, I had a very cordial relationship with Mahesh. But afterwards,
सर ये 89
afterwards, yes sir.
89 के बाद से ही फिर वो
After 1989,
After 1989, the relationship turned sour.
वो क्या है, काफी मतलब वो करते रहता था कि नुकसान कर रहा है, नुकसान कर दिया, एक्यूज करना, मतलब वैसा।
As he used to accuse me of the losses in the business.
Was there any family settlement between you and Mahesh?
क्या आपके और महेश के बीच कोई फैमिली सेटलमेंट हुआ था?
हाँ सर, ये क्या है, 90 के बाद में
Just
कारखाना
change
ठीक
the
से चल नहीं
question.
रहा था। हाँ
No, was there any family settlement? It's a pure leading question. Don't lead the witness. No, kichu bolo. But then you say that's embedded. The answer is there.
So that's the main thing, Lordship. Otherwise,
I know that's the main
I
thing.
understand, but the thing is,
Rephrase this.
No, let the witness say. Let the witness say the story. We'll record it.
Yes. This is a question. No, change করে দিও।
ঠিক আছে, চেঞ্জ করেছি।
এই প্রশ্নটা বাদ দিয়ে
वो क्वेश्चन मत लेना।
सर बोले,
When did the yes sir, was there any dispute between you and Mahesh?
क्या आपके और महेश के बीच में कोई झगड़ा वगैरह था?
हाँ सर, वो 89 से लेकर के 95 तक इसी तरह से चल रहा था। सिंस 1989 से लेकर के 1900
उसी तरह से ऐसे नहीं।
अच्छा, मैंने वही किच को क्या बोलते, किच टाइप चलते रहता था कि ये किया वो किया वो क्या।
Since 1989 till 1995, there was several disputes between me and my brother.
फिर बाद में 96 में 96 या 97 96 ही होना चाहिए, तो फिर घर में डिसाइड हुआ कि डेली तुम
In the year 1996 or 1997, it was decided in the home that
बाबूजी थे, माँ थी, हम थे, महेश था।
in presence of my parents and Mahesh, it was decided that
महेश तो मशीन चला ही रहा है, ठीक चल रहा है उसका काम।
as the machine business which was taken by Mahesh was running
properly.
तो और महेश को डर लग रहा है कि कारखाना में लाइबिलिटी से सब अनसिक्योर्ड क्रेडिटर लोग उसको तकादा कर रहा है, माने
and he had a fear
as all the loans and responsibility will come to him. Then
फिर हुआ कि भाई रमेश तुम ही कारखाना का रिस्पांसिबिलिटी लो।
Then he was given the responsibility of the factory.
और कोई आदमी पैसा मांगने आए तब उसको बोलो कि आई एम रिस्पॉन्सिबल, हम ही कारखाना चला रहे हैं।
And if someone comes for the money, he had to take the responsibility that he was operating the company or factory.
आंसरটা কি গেল পড়ো।
इस तरह से 96 से हम कारखाना देखना चालू कर दिए सर।
In this way, from the year 1996, I started to look after the company independently.
Company no factory.
Factory sir, Hanuman Foundry.
Company or factory.
My lord, he said company.
Well, Hanuman Foundry, Hanuman Cotton sir, factory division. वो हम
That's why
we were looking after the factory.
फैक्ट्री डिवीजन और महेश मशीन डिवीजन। तो हम लोग का एक तो पार्टीशन हुआ, उस समय वर्बल पार्टीशन हुआ।
And it was a verbal partition between me and Mahesh that it was a verbal partition between me and Mahesh that he would look after the machine division and I would look after the factory division,
factory
right?
division, and I will be responsible for all the
And I will be responsible for any loan and any other losses of the factory.
Of the factory division. Sir.
Are you aware of any company, namely Velcast Products Private Limited?
Velcast Products Private Limited, इस नाम का कोई कंपनी को आप जानते हैं?
हाँ सर, हम जानते हैं.
Yes, I know. This company namely Velcast Products Private Limited.
What is your relationship with Velcast Products Private Limited?
Velcast Products Private Limited, इस कंपनी के साथ आपका क्या नाता है?
सर ये इस कंपनी को हमने ही बनाया था 1997 में.
I made this company or I started this company in the year 1997.
और क्योंकि वो हाँ बस यही है सर. अब इसका आंसर तो यही है सर.
Yes.
Are you aware of any company, namely Parijat Vyapar Private Limited?
पारिजात व्यापार प्राइवेट लिमिटेड, इस नाम का कोई कंपनी को आप जानते हैं?
हाँ सर, हम जानते हैं इस कंपनी.
Yes, I know a company namely पारिजात व्यापार प्राइवेट लिमिटेड.
इस कंपनी को सर महेश और उसकी वाइफ अलका ये लोग मिल के बनाए थे 1997 में.
Company was started by Mahesh and his wife namely Alka in the year 1997. Mahesh and his wife namely Alka in the year 1997.
He बोल रहा है एक बार आंसर कर बोलो.
This company is started by Mohesh and his
Was
wife,
started by
Mohesh and his wife, namely Alka.
Alka in the year 1997.
Yeah, 1997.
What was the purpose of incorporation of this company, namely Parijat Vyapar Private Limited?
ये जो पारिजात व्यापार प्राइवेट लिमिटेड इस कंपनी का नाम है, इसका इनकॉर्पोरेशन का वजह क्या था?
सर 96 में हम लोग का तो डिवीजन हो गया था आपस में मशीन और कारखाना का.
In the year 1996 there was a division between
No. When our division have been partition amongst when the factory division and the machine division is partition amongst myself and my brother in the year 1997, then
सर ये महेश ने ये नया कंपनी खोल करके
Mahesh has started new company.
और ये जो हम लोग का पुराना 5 जो पार्टनरशिप कंपनी था जिसमें फैमिली बिजनेस था मशीन का,
The old 5 business of our machine business company
5 पार्टनरशिप कंपनी था,
having partnership company,
उसका सारा मशीन वो पारिजात में अपना ट्रांसफर कर लिया.
he has shifted all the machinery,
all the machinery
in the Parijat
व्यापार
Vyapar Private Limited.
और पारिजात व्यापार के नाम से काम स्टार्ट कर दिया.
And he started the business under the name and style of Parijat Vyapar Private Limited.
Are you aware of any loan in respect of machine division?
मशीन डिवीजन के कुछ लोन के बारे में आपको पता है?
हाँ सर, हमको मालूम है.
Yes, I know.
Can you please explain?
बोल सकते हैं लोन के बारे में, बोलिए.
सर 5 पार्टनरशिप कंपनी था हम लोग का.
We have 5 partnership companies.
उसमें हम लोगों ने लोन लिया था.
On that partnership companies we had taken a loan.
एक न्यू बैंक ऑफ इंडिया से.
One loan was taken from New Bank of India.
और एक इंडियन बैंक.
And another loan was taken from
Indian Bank. ये लोन ये तो जब वो महेश मशीन को ट्रांसफर किया,
when Mahesh transferred all the machineries,
लोन चल ही रहा था.
the loan was ongoing.
और वो
all the machinery to Parijat Vyapar, the loan was ongoing. Yes sir.
वो लोन पेमेंट नहीं किया वो.
He did not paid the loan.
और बाद में हम लोग के ऊपर में उसका वो आया था क्लेम या डीआरटी सब हुआ था बाद में.
After that the claim of the loan come under my head.
हाँ, सब हम लोग सभी के ऊपर में.
Under come upon us.
क्या लिखा है?
आंसर कर दीजिए.
We have 5 partnership companies. On that partnership company, we had taken loan
taken loan, one loan taken from New Bank of India, and another loan was taken from Indian Bank.
Yes.
Thus, Mohesh transferred all the machinery to Parijat paper, and loan was ongoing. He did not pay the loan. After that, the claim of the loan came upon us.
इसी बात पेड एंड रिकवर। आप ना हम मत बोलिए, तो मैं बोलिए या फिर कंपनी का नाम बोलिए।
Yes.
It would be better. आप हम बोलते हैं इसका मतलब वी आ जाता है।
ক্লারিফাই করে দিয়েছেন উনি যে আমাদের সবার উপরে বলেছেন এটা।
Yes, then.
What? How was the position of foundry division in 2001?
2001 साल में फाउंडरी डिवीजन का कंडीशन कैसा था?
2001 में कारखाना बंद था।
In the year 2001, the factory was closed.
बैंक का रिकवरी प्रोसीडिंग चल रहा था।
The recovery process of the bank was ongoing.
और बीएफआर का भी कुछ हो रहा था। बीएफआर में भी प्रोसीडिंग चल रहा था।
There was also a proceeding under BIFR.
अनसिक्योर्ड क्रेडिटर लोग भी माने वो कर रहे थे, तंग कर रहे थे मतलब।
The unsecured creditors persons were also wanting their money back.
Secured creditors, one of the secured creditors also started demanding their amount.
Lot of unsecured creditors. Not one, several.
Several instead of one, ना?
हाँ कई।
अरे पहले क्या लिखा?
In the year 2001, the factory of the recovery process of the bank upon ongoing there was proceeding in the BIFR.
Huh? In the 2001, the factory was closed.
In the year 2001, the factory was closed. The recovery process of the bank was ongoing.
I BIFR proceeding was also initiated. BIFR proceeding was also initiated. Full stop. हाँ उसके बाद क्या हुआ बताइए?
और several unsecured creditors वो लोग भी
Several unsecured creditors also started demanding their amount. Then
पीएफ का भी था। खैर ठीक है, पीएफ का भी प्रॉब्लम चल ही रहा था।
हाँ?
प्रोविडेंट फंड का भी चल
There
रहा
was also problem with regard to the provident fund.
उसमें भी कई अनप्लेजेंट हुआ था, मतलब अनप्लेजेंट सिचुएशन हुआ था सर उसमें भी, प्रोविडेंट फंड में भी।
Okay, present. Yes, next.
Are you aware of any company, namely SK Investments Private Limited?
SK Investment Private Limited, इस नाम का कोई कंपनी को आप जानते हैं?
सर हम जानते हैं इस कंपनी को, एसके इन्वेस्टमेंट।
Yes, I know a company namely SK Investment Private Limited.
प्राइवेट नहीं, एसके इन्वेस्टमेंट्स है।
SK
Investments.
प्राइवेट भी नहीं, लिमिटेड भी नहीं।
Are you aware of any person, namely SK Kejriwal?
SK केजरीवाल, इस नाम से किसी आदमी को आप जानते हैं?
हाँ सर, एसके केजरीवाल उनका पूरा नाम है डॉक्टर श्रवण कुमार केजरीवाल।
Yes, I know a person namely SK Kejriwal. The full name of Mr. SK Kejriwal is Shravan Kumar, Dr.
Shravan Kumar Kejriwal.
उनका वो माने उसको स्टेप अंकल थे हमारे।
He was my step uncle.
माने स्टेप अंकल माने समझिएगा।
From paternal side or maternal side?
मेरे दादाजी का 2 शादी हुआ था।
Paternal.
He was my paternal step uncle, as my grandfather has 2 marriages. Had 2 marriages.
एसके इन्वेस्टमेंट में वो शायद प्रोप्राइटर थे, उन्हीं का ही कंपनी है ये।
The SK Investments is his company.
No, SK. What is the name? SK?
Kejriwal, my lord.
SK Kejriwal.
Shravan Kumar Kejriwal.
No. The company name?
SK Investment.
SK Investment was the company of Dr. Shravan Kumar Agrawal.
Shravan Kumar Kejriwal. Shravan Kumar Kejriwal.
Shravan Kumar Kejriwal. Sorry.
Was there any business connection with Mr. SK Kejriwal?
क्या मिस्टर SK केजरीवाल के साथ कोई बिजनेस कनेक्शन था?
हाँ सर, उनसे बिजनेस कनेक्शन था।
Yes, we had a business connection with.
थोड़ा एक्सप्लेन कर सकते हैं?
SK केजरीवाल।
सर वो 97 में
in the year 1997
हनुमान फाउंड्री ब्लैकलिस्टेड था
as Hanuman Foundry was black. Hanuman
In the
Foundry
year 1997, Hanuman Foundry was blacklisted.
हम लोग एक्सपोर्ट नहीं कर सकते थे
we
मैंने हनुमान फाउंड्री हम लोग मैंने हनुमान फाउंड्री एक्सपोर्ट नहीं कर सकता था
Export.
एक्सपोर्ट सर
Hanuman
Expose.
एक्सपोर्ट
export.
आयात निर्यात
Okay. We were not in a position to export the materials from Hanuman Foundry.
तो महेश के इंटरवेंशन से
Due to the intervention of Mr. Mahesh,
श्रवण केजरीवाल का एक कंपनी था प्रीमियर फिल्म्स
there was a company of Mr. Shravan Kejriwal, namely
प्रीमियर फिल्म्स
Premier Prince.
फिल्म्स फिल्म सर रेडियो एक्टिव वो मैंने डॉक्टर तो फिल्म होता
Yes, yes, films, yes.
मैं
Premier
पिक्चर वाला
Films.
नहीं
फिर क्या हुआ?
हाँ तो प्रीमियर फिल्म्स में उस नाम से एक्सपोर्ट करते थे 97 से लेके 2001 तक
And from 1997 till 2001, we have you all
Hanuman Foundry
Hanuman Foundry started export their materials in the name of Premier Films.
मैंने हनुमान फाउंड्री माल बनाता था प्रीमियर फिल्म्स को देता था मैंने अकाउंटिंग ऐसे
Hanuman Foundry used to produce materials and
was exported by
also supplied to Premier Films, and Premier Films is used to export the materials.
सर ये सिलसिला चला सर 2001 तक
This was continued till 2001.
Had S.K. Kejriwal been given any access to any of the offices of Hanuman Cottons or Hanuman Foundry?
क्या एसके केजरीवाल को हनुमान कॉटन्स और हनुमान फाउंड्री का कोई भी ऑफिस का एक्सेस दिया गया था?
हाँ सर उस समय
यस
हम मैंने मैं आई हम मैंने मैं हम कारखाना में रहते थे फुलेश्वर में प्रोडक्शन करने के लिए
Yes, at that point of time, I used to reside at
फुलेश्वर
Bhuneshwar.
फुलेश्वर हनुमान फाउंड्री हनुमान कॉटन
Bhuneshwar
तो
in Hanuman quarters.
हाँ वहीं रहते थे काफी टाइम
Yes.
और ये श्रवण केजरीवाल हम लोग के ऑफिस आते थे 12 नेताजी सुभाष रोड में
And the Shravan Kejriwal used to
come to our office
come to our office at
12A नेताजी सुभाष रोड
12A Netaji Subhas Road.
और सिंस हम लोग माल हम एक्साइज है हनुमान फाउंड्री के ऊपर में सर एक्साइज है एक्साइज कंप्लाइंट था ना हनुमान फाउंड्री तो रॉ मटेरियल हनुमान फाउंड्री में ही खरीदना पड़ता था
as Hanuman Foundry was the
एक्साइज ड्यूटी था उसके ऊपर में हनुमान फाउंड्री
There was an excise duty in the Hanuman Foundry, due to which we used to purchase raw materials
the name of Sri Hanuman Foundry
in the name of Sri Hanuman Foundry.
तो जो रॉ से ही जाता था
the payments of the raw materials used to be given from
Hanuman Foundry.
और पेमेंट जो आता था वो आता था प्रीमियर फिल्म्स के नाम में
Payment used to come in the name of Premium Films.
प्रीमियर फिल्म्स तो जब पेमेंट आता था प्रीमियर फिल्म्स के नाम में तो वो फंड वो हनुमान फाउंड्री में ट्रांसफर करके
When the fund used to come from Premier Films to Hanuman Foundry, the amounts used to transfer in the name of the Hanuman Foundry.
और फिर वो फंड से हनुमान फाउंड्री परचेज करता था रॉ मटेरियल
Then the Hanuman Foundry used to purchase raw materials
from that money
from open market. From open market. Then
that raw material कारखाना चलता था.
The help of the raw materials, the company used to be operated with the raw materials. बताओ शुरू.
So since हम
आई मुझे चाहिए.
हम वहीं रहते थे हम कारखाना में।
Since I was residing there,
तो हम कई चेक वेक सही करके ऑफिस में छोड़ देते थे।
I used to keep this signed check in the office
हनुमान फाउंड्री
of Hanuman Foundry,
जिससे कि so that काम चलते रहे, मतलब
due
पुलिस पर जाने में बहुत टाइम लगता है, तो काम चलते रहे, so that
for the purpose of running the business smoothly. Then
सर ये तो फिर 2001 में हमने हमने वैश्या बैंक से बात करके एक सेटलमेंट किया हनुमान
in the year
फाउंड्री में।
2001, I had आपने
हम और बाबूजी दोनों थे सर।
myself and my father had a talk with Vashya Bank for settlement.
और वो सेटलमेंट इस तरह था, ठीक है आपको हम लोग सेल लिस्ट से, स्पेसिफिक अप्रूवल लिस्ट से हटा देंगे।
And during this negotiation, it was settled between the bank that
we shall remove the embargo on Hanuman Foundry.
We shall
bank
shall remove the name of Hanuman Foundry,
and the Hanuman Foundry can export.
So that the Hanuman Foundry can export the materials.
And in every export, आप 10% हमको देते जाइए liability के लिए.
The 10% is to be given to the bank for
liability meet करने के लिए.
For reduce the liability.
10% cutback बोलते थे बैंक में, वर्ड बोल लोग यूज करते थे.
It was called a 10% cutback.
Cutback
arrangements.
सर फिर हमने उसको श्रवण केजरीवाल को बोले कि we don't need premier films now.
After that, myself and my father requested Shravan Kejriwal that he has to leave the premier. What?
No, he has. We don't need premier films. हम लोग सीधा
The Kejriwal that we did not need his help
in export.
For export.
And Hanuman Foundry will directly export.
And Hanuman Foundry will directly export.
इसके बाद का भी बोल सकते हैं सर?
बोलिए, जो बोलना है आप बोलिए, आप विटनेस के लिए आए हैं।
अच्छा अच्छा, तो सर वो तो ऑब्वियसली एसके केजरीवाल वाज नॉट हैप्पी.
SK Kejriwal was not happy at this, with this.
तो फिर सम टाइम इन जून जुलाई 2001 या 2002 होगा शायद.
Sometimes in the month of June of July 2021 or 22. 2002. 2001 or 2002.
हम लोग को अचानक एक कोर्ट का चिट्ठी आया, 138B का नोटिस होता है वो.
हमको बोलने से किसके नाम से आया?
सर तीनों, हनुमान फाउंड्री, बाबूजी, हमरे, महेश, तीनों चारों के नाम से.
We have received a notice.
इस बार भी
We have received the notice. Within bracket कर दो, myself, my father, Mahesh Kejriwal, and in the name of the Hanuman Foundry. Bracket close.
कि आपका 3 चेक रिटर्न हो गया है.
With the intimation that our 3 checks have been returned.
40 lakhs.
Of rupees 40 lakhs.
40 lakhs and 24 lakhs.
Of rupees 40 lakhs and 24 lakhs.
40, 24.
40 lakhs and 24 lakhs.
जो कि आपने एसके इन्वेस्टमेंट को इशू किया है.
Which were issued in the name of SK Investment.
तो फर्स्ट टाइम पता चला हमको तो एसके इन्वेस्टमेंट उस समय.
We came to know about the said checks first time after receipt of the said notice.
We माने रिटर्न है ना, आई
We. That's why recorded.
ना फादर बोले.
Yes.
हम लोगों ने फिर इन्वेस्टिगेट किया अपना.
Then we have we बोलने से आप चारों जने.
सर इस बार कल हम अकेले.
Then I investigated the matter.
I investigated. पता चला 8 चेक था वैसा. 8 checks. 8.
Investigated the matter and found that there were 8 checks
missing.
Checks which were missing.
वो तो ऐसा तो नहीं बोलना चाहिए चोरी किया, पर हमने नहीं दिया, वो उनके पास चला गया 8 चेक हमारा. हनुमान फाउंड्री का।
During investigation, I found that 8 checks were missing, and the check said 8 checks of the Hanuman Foundry.
हनुमान फाउंड्री
Was of the Hanuman Foundry.
श्रवण केजरीवाल के पास में चला गया,
Went to Shravan Kejriwal,
उसी में से वो 3 चेक को रिटर्न
out
करवाया।
of which Shravan Kejriwal has deposited the 3 checks,
हाँ,
presented the 3 checks
अपना भर के पूरा एसके इन्वेस्टमेंट 40 लाख से
by
भर लिया।
filling up the name SK Industries
एसके इन्वेस्टमेंट
for
और
encashment.
फिर सर इस बार हम लोग सबको ही हनुमान फाउंड्री, रमेश, बाबूजी, महेश,
This time we, within bracket,
Real-
myself, my brother, myself, my father, Mahesh Kumar,
हम लोग ने फिर श्रवण केजरीवाल पे केस भी हाँ उसके बाद केस किया हम लोगों ने
have filed a case against
हाई कोर्ट में।
Shravan Kejriwal in the High Court.
सर हाँ ऑनरेबल हाई कोर्ट
In the High Court. फिर क्या हुआ?
कैंसिलेशन करने के लिए
For cancellation of the
चेक, ये जो चेक था।
set 3 checks.
और फिर सर वो बंसाल कोर्ट वाला में हम लोग के अगेंस्ट में सबको तीनों के अगेंस्ट में केस चला, तीनों के अगेंस्ट में चेक
किसने किया?
श्रवण केजरीवाल।
Shravan Kejriwal has initiated a case against
against 4
before the Bankshal Court against me, my father, and Mahesh Kumar.
महेश केजरीवाल।
Then
सर वो कई दिन केस चला वो, और उधर घर में भी परिस्थिति ठीक नहीं था क्योंकि बैंक का भी डीआरटी चल रहा था।
ना फिर वो केस का क्या हुआ वो
अच्छा, हाँ,
कंप्लीट
केस को
कीजिए।
पहले खत्म करें।
हाँ, क्या हुआ केस का फिर?
केस में सर क्या हुआ, फिर अपोज करने के बाद में 2-3 साल बाद में 2004, 5 या 6 में कभी अचानक फिर वो बाबूजी बोले कि भाई ये उसका महेश का बात सुनो, नहीं तो ऐसा वैसा करके हुआ कि ठीक है। बाबूजी फिर मैंने महेश बोला कि ये जो 24 लाख का चेक है जो अपोज कर रहे थे हम पेमेंट कर दे रहे हैं। महेश बोला हम पेमेंट कर दे रहे हैं, तो जमा खर्ची करा करके वो पेमेंट करा दिया इसके इन्वेस्टमेंट का चेक।
During the pendency of the case before the Bankshal Court, Mahesh Kumar Agrawal pressurized us for settlement by paying the amount of rupees 24 lakhs. 24 lakhs?
हो सर, वो थोड़ा सा ठीक से बता देते हैं सर, फिर जैसे रिकॉर्ड करना। वो चेक तो सर 2 चेक हमरा सही किया हुआ था, रमेश केजरीवाल का 24 लाख का चेक बाबूजी का सही किया हुआ था। तो हम लोग तो तीनों मिलके केस लड़ रहे थे। फिर अचानक महेश बीच में घुस करके बोला कि हमको वो कुछ नहीं करेगा श्रवण केजरीवाल, और बाबूजी का हम बचा लेंगे बाबूजी को। तो बोले कैसे बचा लेंगे? बोले हम पैसा दे देंगे। तो फिर बाबूजी का वो जमा खर्ची करवाया अपना बैंक से, और वो श्रवण केजरीवाल को
जमा खर्ची
ऐसे घुमाना से
हाँ हाँ
और 24 लाख का वो पेमेंट करा दिया।
ठीक है। और रुकिए, वो जो वो बोला ना बीच में, पहले इससे पहले क्या पैराग्राफ था? हाँ वो अटक काट दीजिए। During the pendency of the case before the Bankshal Court, नहीं get it in. Out of the 3 checks, 2 checks was signed by me, and 1 check is of my father's, of the signature of my father, of rupees 24 lakhs, full stop. During the pendency of the case before the Bankshal Court, Mahesh Kumar Agrawal stated that Kejriwal stated that he is not a party in the said case, nothing will be happen against him, and he pressurized and he said that he will clear the amount of rupees 24 lakhs which was in the name of the father. Accordingly, he has managed to pay rupees 24 lakhs, and the case against the father was dropped.
फिर अब हम रह गए वहां पर में। अब इस बार अकेले हम ही रह गए।
बुक एंट्री में भी मेंशन जमा खर्ची
was paid by Kejriwal by way of book entry.
सर अब क्या है कि वो उसमें पता चला बाद में वो जो चालान बिल सब वो झूठा लगा दिया था, माल तो आया नहीं था कोई, तो सिग्नेचर हमारा भी था, बाबूजी का भी था चालान में, बिल में। तो बाद में वो कोई उसको लगाया था सिग्नेचर एक्सपर्ट वाले को, तो सिग्नेचर एक्सपर्ट वाला ये प्रूफ किया कि चेक तो सही किया हुआ है, सही। वही सिग्नेचर एक्सपर्ट उसी का श्रवण केजरीवाल का बताया कि नहीं चालान बिल में हम लोग का सही नहीं है। तो ये ऐसे करके फिर 2011 में हमको कोर्ट छोड़ दिया कि भाई नहीं
ठीक
ये
है,
आपका।
ठीक है. My case was pending. A case against me was pending. Full stop. During the pendency, Mahesh Kejriwal की नाम SK Kejriwal, on the request of SK Kejriwal, an handwriting expert was appointed and found that the signature appearing in the check belongs to me, but it was found that the bills क्या था?
चालान और बिल सर,
Challan and bills, the signatures appearing in the challan and bills on the basis of which the checks were issued were not tallying with my signature, and finally I have been acquitted from the said case.
अब सर ये इसमें एक चीज और बोलना था सर, बोल सकते हैं?
हाँ हाँ
सर ये 2004 या 2002 से 2011 जो केस चला, तो हम लोग 2007 तक बालीगंज में ही रहते थे। तो मैं फोन में करके ऐसे हल्ला करते रहता था, आज जेल गया कल जेल गया। मैंने पता चला बाद में कि दूसरा साइड में कोई नहीं है, तो वही फोन में से जोर जोर से हल्ला करता था, अभी जेल जाने वाला है, आज ही जेल जाने वाला है। तो उसमें ऐसे मैंने ऐसे कर डराते रहता था हम लोग को। मैंने
witness volunteers
Beyond pleadings.
witness volunteers
We'll argue that.
witness volunteers that at the time of pending of the case I was residing in Baliganj.
बालीगंज
I was
together,
residing
all together, father
we all residing in Baliganj. At that point of time, Mahesh Kejriwal used to call over phone and threaten me that I will be going in jail.
और सर वो जो श्रवण केजरीवाल के पास में कोई पैसा नहीं है, उसका सारा केस को जो पैसा देने का काम है महेश ही करता था। शुरू में चुप चुप के करता था।
As the Sharon Kejriwal was not having any amount, all the expenses were made by Mr. Mahesh Kumar Kejriwal
और सर जब
for the
केस
said cases.
और सर ये जब वो बैंसल कोर्ट में केस होता था 2011 तक, एवरी हियरिंग में महेश आता था सर, एवरी हियरिंग में महेश आके
Till
बैठते।
the end of the case, that is in the 2011, Mahesh Kumar Kejriwal used to appear to be present in the court along with
श्रवण केजरीवाल।
Shravan Kejriwal.
Any other date you'll
How long it will?
Otherwise, all my questions will be finished today.
पूर्व
देखो ठीक है, नेक्स्ट डेट में आइए.
I think this is a testamentary proceeding.
Yes, we are coming. How this will has been prepared.
Defendant witness is present.
Will has to be prepared. Everybody's will is prepared.
Examination chief started, but due to paucity of time, examination chief could not be completed. Accordingly, chief is defer. Let the matter appear on 13th November at 2 p.m.
13, 14, 12.
Now, okay, on note. ठीक है.
Apart 12 হলে হবে আমার অসুবিধা 20th
20 November. 20 November.
20th November at 2 p.m.
Can two date can be given,
Yes, Your Lordship.
or you will complete? One day you will complete? I don't think so.
Another date will be taken. Your Lordship kindly give the date so that Your Lordship will.
2 dates.
20 and
20 and 20.
20 আর 24 ঠিক আছে
20
Perfect.
আর 24 ঠিক আছে. Then complete the chief.
I'm grateful.
How many witnesses you are having?
One.
Yes, next.
Oh. Yes.
Yes.
when I appear for the plaintiff, my witness is present.
Who is for the other side?
Mr. Sinha was here. Anuj, Mr. Sin.
Anuj Singh.
Not
Yes.
Sinha. He was here just now. He must be coming. Oh, it is here. He is here.
My lord, as per your lordship direction on 22nd of January, my learned man was not complied this order, my lord. I have no received, my lord, judge's brief of documents from the plaintiff advocate. In last occasion, your lordship directed to the advocate on record to supply a copy of the judge's brief.
Judge's brief you have prepared.
I prepared.
The same document.
But my lord, lordship directed to the plaintiff to.
Have you filed the judge's brief?
No, I don't need extra document. The same documents.
Okay.
You have prepared. Now I'll put questions to the witness. I have not done the affidavit of evidence. Is it
commercial?
Yes, it's a commercial. It's commercial, whatever. But I think the documents he has to. Yes, sure. Yeah. Document day.
Yes. Repeat after me.
You are not prepared the affidavit. You are losing your.
No, what I.
He is telling that he has not used any judges, but the document they are relying on.
How will I know what? So no judge's brief.
No, you have.
No, you have filed the judge's brief.
I have filed. You don't want to use any judge's brief.
Your judge's brief includes my document also.
Oh, very well. No further documents.
No further document. Yes. No further documents. It includes my document also. Only prepared by you.
Sir, repeat after me. I solemnly affirm.
I solemnly affirm
That whatever I depose.
that whatever I depose
By way of evidence.
by way of evidence,
I shall speak the truth.
I shall speak the truth.
No part of it shall be false.
No part of it shall be false.
And I shall not conceal anything.
And I shall not conceal anything.
What is your name?
Sumit Agarwal.
Spelling.
SUMIT Agarwal. AGARWAL.
Sumit Agarwal. Father's name?
Late Kamal Kumar Agarwal.
Late Kamal Kumar Agarwal. Your age?
28/07/1981.
44 years. 44 years. Your occupation?
Business.
Business. Residential address?
4 Chakraberia Lane.
4 Chakraberia
Chakraberia Lane. Kolkata 70020.
70020. Sir.
Mr. Agarwal, are you aware of any entity by the name Mickey Metals Limited?
Yes.
In which capacity you know this entity?
I am one of the directors of that company.
Directors of that company.
Since when are you a director of this company?
Past 10 to 15 years.
Past 10 to 15 years.
Can you please name who are the other directors of this company?
Narendra Kumar Agarwal, Saket Agarwal,
Saket
Agarwal, myself Sumit Agarwal,
Sumit Agarwal,
and two more independent directors.
And
two independent
directors. Use the microphone, sir.
Yes.
Are you in any way related with these directors that you named in your last answer?
Yes, Narendra Kumar Agarwal is my uncle. Sorry.
Yes, Narendra Kumar Agarwal is my uncle.
Saket Agarwal is my uncle's son.
Is my uncle's son.
Yes. This is the relation between them.
Are you aware of any entity by the name Mrs. Sinha Chips Company?
Yes.
In what capacity you know this entity?
He was our dealer.
He was our dealer.
Dealer of which? What goods?
Deliver of TMT bars.
Dealer of TMT bars.
TMT bars.
Are you aware of what is the business of the plaintiff company?
My company Yeah, we are manufacturer of TMT bars and trading of TMT bars and iron and steel.
Go slow.
Sorry,
The
so sorry.
manufacturers of TMT bars. Manufacturer of TMT bars, then
And trading of TMT bars
and trading of TMT bars
and iron and steel.
and iron and steel. Don't say
Yes, yes.
You just now said that Sina Chips company was your dealer. This dealership was for which area?
For Murshidabad, Behrampur.
for Murshidabad, Baharampur.
Can you please tell the Honorable Court, sorry, can you please tell the Honorable Court what was the mode of business that your company used to do with Sina Chips company?
So we used to take orders from them for TMT bars, and we used to supply them TMT bars, which was all on verbally. And after dispatching the goods from our factory,
From our factory.
they used to give us
Louder.
check and make the payment. This was the procedure.
Since when is the plaintiff company is in business with Sina Chips Limit Company?
It was approx started 2010 approx, or maybe before that also. You need to check.
Are you aware as to the reason why the plaintiff company has filed the instant suit?
Sorry.
Are you aware as to
No.
company filed instance to show?
Why you file this suit, this case?
Sir, to receive my money, because after getting the materials, he gave us the check, and which was dishonored, and we didn't receive our payment.
And we received our payment.
No, that's it. This reading tag what देखे नहीं. Reading नहीं. I'm showing you first bunch. I'm showing you 4 documents, copies whereof are appearing at pages 2, 3, 4 and 5 of the judge's brief of documents, volume 1. Kindly tell the Honorable Court what are these documents? 2, 2, 5.
1 to 5. Yes.
Sir, first page is tax invoice.
The first one is the tax invoice.
Bit louder.
A bit loud.
The second page is challan. The third page is tax invoice cum excise invoice. And the fourth page is test results.
Test results.
I'll also mention the dates. And
yes. What is the date of the tax invoice?
Yes, sir. The date is 22nd April 2016.
16.
And invoice number is 0147.
0147.
The full invoice number is MML/0147 MML/0147/16-17.
You will find that there is a signature appearing on the right hand side Bottom.
Where the original has not been exhibited. The questions are being put.
I'll put questions, Manoj. I'll put
That is
questions.
original.
Aschi, aschi, শেষের দিকে
No,
ছিল
Xerox copy but document identify.
That is the original one.
Yes, sir.
Original.
Oh, I have not seen it yet.
Exhibition দেয়নি?
No, তুমি tender করছো original.
Section not done.
Exhibition
Right.
দাওনি?
I was not aware whether he has tendered the original.
Yes, he is standard.
হ্যাঁ, ঠিক আছে, please go ahead.
অরিজিনাল আছে এগুলো আছে। না এর আগের প্রশ্ন করে নেবো তাহলে তো কি কোশ্চেনটা কি ছিল আমি মিস করে
That there is a signature appearing on the right hand side bottom.
of the first document. Are you in a position to identify the said signature?
Yes.
Kindly tell whose signature is appearing there at.
Shyam Paras Rampuria. Shyam Paras Rampuria.
Shyam Paras Rampuria.
Shyam Paras Rampuria.
Who is this gentleman?
He was our accountant in office.
Kindly see the challan. You will find there is also a signature appearing there at. Are you in a position to identify the said signature?
Yes, sir.
Whose signature is it?
Pitambar Jha.
Pitambar
Jha.
Pitambar Jha. Who is Pitambar Jha?
He is authorized secretary in our plant factory at Sivdi, Birbhum.
Plant factory at Sivdi, Birbhum.
This is subject to objection, Millard, this question with the name, Millard. That's incorrect, Millard. So, Millard, subject to objection.
Pitambar Jha. What কি বললে he is?
Within
Plant factory at
Plant factory.
within bracket. Subject to object.
Subject. Kindly look into the third document, which also bears a signature. Are you in a position to identify this signature?
Yes, this is the same signature of Pitambar Jha, which we call him Jhaji. So
We used to call him Jhaji.
Jhaji.
Used to call him Jhaji.
Subject to.
Is a subject to objection.
Within bracket, subject to objection.
Kindly turn to the last document. You will also find that there is a signature. Are you in a position to identify the said signature?
yes,
Whose signature is it?
Saurav Das.
Who is Saurav Das?
He was a meteorologist,
He was the-
meteorological,
Was a
meteorological person who used to look after our lab.
person who used to look after
Our lab.
our land.
Laboratory, sorry.
Laboratory.
Lab.
Are the documents that I handed over to you original? Is in original?
Yes, sir, it's in original.
What do you say about the contents of these documents?
So I'll say, sir, one by one, or like
whatever you feel.
Sir, these are the documents to dispatch. Last three documents are required to dispatch.
slow, go
Sorry.
What about the contents of the what about the contents of the document?
So this is a
Not asking what is the contents, but
it's written TMT bar 69.
whether the contents are correct or not.
Yes, sir, it's correct.
My lord has the liberty. I don't have that liberty. The answer is that the contents are
Contents
that
of the document
true
are
and
true
correct.
and correct. Yes.
This is subject to objection, Millard. Kindly take.
Why?
প্রশ্ন না জবাবে objection দিচ্ছি।
ও জবাবে objection ঠিক
With objection. Subject to objection.
সাবজেক্ট ইয়েটা প্রশ্ন করছি ভুলে গেলাম বলছি ওটা ভেবে এলাম। Kindly tell the time and or the period when these documents were issued?
So the date is 22nd April 2016.
Yes.
For the tax invoice, for the challan, it's the same date, 22nd April 2016. For the tax invoice come excise invoice, the date is 22nd April 2016 and time is 11.30 hours. And for the fourth document, the
For
date
both document, the date.
is 22nd April 2016.
What? Hold on, answer.
Yes.
What was the mode of transaction? No, sorry, sorry, Mala. Kindly tell the mode of delivery of the goods that the plaintiff and the defendant undertook.
Sir, this was X factory through truck number WB 41C 7/78154.
7854.
WB 41C / 7854. X factory.
What do you mean by X factory?
Sir, in the X factory, the buyer place their trucks to our plant. To the buyers place
their truck
trucks
at the plant.
To take the materials ordered by him.
After loading the materials at the truck, was there any practice of handing over any documents?
Yes, sir. After loading the truck, we used to give them challan, tax invoice, come excise invoice, and test results to dispatch the truck from our plant.
Truck
From our plant.
You mentioned in your last answer that these documents were handed over to them, quote unquote, in the last answer. What do you mean by them?
Sir, we used to hand over the documents in the plant to the driver or their helper. And after that, from office, you used to make tax invoice, the first page, and that was hand over when the party comes to our office. Then he used to take the tax invoices.
Office.
And he used to take the tax invoice from our office.
Yes, sir.
I find, now you will find that there is no stamp of receiving in any of these 4 documents. Can you explain the reason of this?
Sir, these documents we give them from our plant, the last 2, 3, and 4 documents, in which generally truck drivers or their helper receive it to dispatch the materials for a plant. And just because this delivery is X delivery, so we don't need any signature. So we don't need any signature on it, sir.
এখানে 2, 3, 4 ডকুমেন্ট বললো না, মানে পেজ 2, 3 and 4 করে, না তো পরে বোঝা যাবে না। না জেভিডি না, and না।
Yeah.
And what about the first document being the tax invoice?
So the first document is made from our office. So we used to make it, and since this was also ex-factory,
Ex-factory. Yes.
we used to hand over to the dealer itself when he used to come to our office or one of his staffs.
Who, on behalf of your dealer, namely Sinha Chips Company, used to come to your office?
Kartik Sinha, it's
Sinha Chips Company, CEO khali last day. Messrs. Sinha Chips Company, who used to come to your office.
Proprietor Kartik Sinha.
Proprietor Kartik Sinha. বলো আর কি বলবো, বলো তো অনেক দেখি একবার বলে বলে যে সব না, and may this bunch be marked as an exhibit, মানে কি করে সব হয়েছে, ডকুমেন্ট হয়েছে, এই কন্টেন্টস হয়েছে, সব হয়েছে, সব হয়েছে। জানি না বাবা কেন ঝামেলায় যাচ্ছিস, কেন ঝামেলায় যাচ্ছিস তুই?
Exhibit A collectively.
Exhibit A collectively.
Collectively.
Why not?
No.
Well, will it go subject to objection, the documents? Because I had raised objection to the questions where will it subject to
objection.
deeply objection.
Objection karo.
No matter, there are identical sets of documents after this. There's every truck supply, sorry, every supply had these 4 documents. So I do independent individually.
Give the total.
Yes, I did. Yes, I did one exhaustively. Then page 6 now shown documents, shown a bunch of documents, copies whereof are appearing at pages 6 to 45 of the judge's brief of documents. Kindly tell the Honorable Court what are these documents.
These bunch of documents are tax invoice, challans, tax invoice cum excise invoice, test results copy.
Test results copies.
Results copy.
Yes.
What was the mode of delivery of goods covered under these tax invoices and challans? We expect yes.
Sir, all are ex-factory.
Kindly identify the signatures which are appearing on these documents. General করে বলে দিলেই হবে, একই সব মনে হচ্ছে। দেখে নাও, হ্যাঁ, looks to be the same. বলু না।
Sir, all the tax invoices are of our accountant Shyam Parasrampuria, same as before.
All the tax invoices having the signature of our accountant Shyam
Parasrampuria.
Parasrampuria.
And what about the challans? Check it. না কোথায় দেখছিস, আমার হয়ে গেছে, ভালো লাগছে, সব আছে, সব দেখে নিয়েছে।
The challan and invoice is signed by Pitambar Jha.
Pitambar Jha.
So the signs are differently. So I have to
name the date and give the.
Okay.
You identify the challan by the number and then say the.
So I'll tell the invoice number and give. So the invoice number 0199. I'm just mentioning
At page, mention the page number.
Invoice number and date.
Okay,
so the page invoice number.
Only number, not the numerical.
Sir, invoice number is MML/0199. So I'll just
Only 0199.
Okay. 0199. The first page I have told, the second challan. And the third page, tax invoice cum excise invoice, is signed by Pitambar Jha.
Obviously,
In the test results copy is signed by Atutosh Ghosh.
Ashutosh Ghosh.
Ashutosh Ghosh. In invoice number 0212, the challan and tax invoice cum excise challan is signed by same Pitambar Jha.
Pitambar Jha.
And test result by Saurabh Das.
My lord, on all challans, my objections will go.
Invoice number.
Subject to objection, no?
Invoice number 0554. Challan and tax invoice cum excise challan is signed by Srinivas.
Srinivas.
In the test results, Saurabh Ghosh. Invoice number 0555. The challan and tax invoice cum excise invoice is signed by Srinivas. Test results is signed by Saurabh Ghosh. Invoice number 571. 0571. The challan and tax invoice cum excise invoice signed by Srinivas. The test results.
First one. First one.
Yeah, Asutosh. Last one. 0571. Atutosh Ghosh. 0578 invoice number. Challan and tax invoice cum excise invoice signed by Nikhil Agarwal. Test results Asutosh Ghosh. Invoice number 0579. Challan and tax invoice cum excise invoice signed by Nikhil Agarwal. Test results by Asutosh Ghosh. Invoice number 0587. Challan and tax invoice cum excise invoice signed by Srinivas. Test result Asutosh Ghosh signed by. Invoice number 0588. Challan and tax invoice cum excise invoice signed by Srinivas. Test results signed by Asutosh Ghosh. Invoice number 0593. Challan and tax invoice cum excise invoice signed by Srinivas. And 10 test results by Asutosh Ghosh.
How do you know the signatures of the persons that you referred to in your last answer?
So they used to work, the first person tax invoice, he was our accountant at office.
The first person tax invoice, the signature of the person appearing in the tax invoice is the accountant of our office.
Was the accountant of our office. And the challan and the tax invoice cum excise invoice and test results, they were our factory employed staffs. We used to work in our plant. And one person named Nikhil Agarwal, who's also signed, is there.
The person namely Nikhil Agarwal, whose sign is there in one of a document.
He was also used to work in our plant. But we have a blood relation with him also. So
Yes. What do you say about the contents of these documents?
this is all true and correct.
Are the documents I handed over to you are in original?
Yes, sir. They are in
In
original.
original. আর কি বলতে হবে? You will find that no. হ্যাঁ, ওই একই প্রশ্নগুলো করে নি। Kindly tell the modus which the parties adopted for delivery of the goods and the delivery of the documents. So far, these documents are concerned.
Sorry, sir. One second.
हिंदीতে বলে দাও না
Mode of delivery. कैसे माल आपने दिया था,
Ex-
कैसे
yeah.
ये documents hand over किया गया?
Okay, sir. The mode of delivery was X factory. And after loading of the materials, TMT bars, we used to hand over challan, tax invoice cum excise invoice, and test results handed over to the driver or the helper of the party.
Part of the party.
And after getting these documents, they used to take their vehicle out of the plant.
After getting this document, they used to take their vehicle out of the plant.
Out of the plant.
And what about the delivery of the tax invoice?
After the road papers like challan and tax invoice come excise invoice and test results, we used to prepare one tax invoice from our office and used to hand over to the party when he used to visit our office
He used to visit our
or either his staff.
either their stuff.
So far, these tax invoices are concerned, do you recall as to whom these tax invoices were handed over?
So maximum all the tax invoices should hand over to Kartik Sinha. Sorry, Kartik.
Probably all the tax invoices were handed over to Mr. Kartik Sinha,
Proprietor of Sinha Chips Company.
proprietor of Sinha Chips Company.
You will find that there is no stamp or signature showing receipt of these documents. Can you please tell why is the same? Why is the same?
Sir, this all delivery are ex delivery. So in this practice, we don't get or need the sign and signature of the stamp. Because when the delivery is ex factory, it means the party will place the mode of transport in which he has to take the materials, and they used to place in our plant to get the materials loaded, and we have to dispatch after loading the vehicles.
Yes.
May these bunch of documents we must have a Joshua
Be collectively with subject to objection. Be collectively.
এটা পেজটা কত হলো রে?
6 to
45.
43.
45. A minute. 45.
Yes, 45.
Page 6 to 45. With objection.
Yes.
May I stop today? I think see, any event has a matter because
Yes,
then
please.
shift to a different set of documents. Any other team.
Plaintiff witness is present. During this examination, documents were marked as Exhibit A and Exhibit B with objection. Due to paucity of time, examination in chief could not be completed. Accordingly, chief is defer. Let the matter appear on 13 November 2 p.m.
Obliged. Very well. Deeply obliged.
Yes, call the matter.
Number 16.
No, see, I'm for the respond number 2 and 3, my lord.
Yes.
Wait, please, my lord. My lord, we are in reply. This is that matter, my lord, where we have submitted that Our contention is the same as has been submitted by my learned friends. I'll not repeat my submissions very briefly, my lord.
Power of attorney.
My lord, no, this is the matter where, my lord, there was a partnership firm.
Yes, partnership.
Partnership firm, my lord. Where, my lord, we had given a notice of dissolution under section 43. You know, the disputes, I'll quickly give a 5-minute recap, my lord, of the matter.
5 minutes. You have only 3 minutes. If you conclude your argument,
But I
345 other matters.
I understand that.
Tomorrow?
We'll come tomorrow. And I apologize, my lord. The previous 2 occasions I'm instructed when the matter was called, my lord, I was in the middle of submissions on some other court. I really apologize, my lord. I couldn't. Tomorrow, my lord.
Not today.
Will not take more than 10 minutes, my lord. Very deeply obliged.
Next. हाँ कर दो है पार्टीज है कॉल फिक्स मैटर कॉल करो
Lordship has passed an order in item number 16, Your Lordship.
Yes.
Yeah.
You're there.
I'm for the defendant numbers 2 and 3. I'm led by Mr. D.N. Sharma.
Except not
Lordship.
today.
Not today.
Lordship, I'm for the defendant 2 and 3, madam.
Matter. No.
Madam, it is the plaintiff's application. Madam. They were seeking for
Not today.
urgency for
Not
hearing.
today.
Lordship.
Yes. Fixed matter. 345.
I'm being led by Mr. Ghosh. He's appearing online.
My lord, I'm here online. I'm sorry.
Yes.
That I also have a leader who was supposed, I am led by Mr. Mukherjee, my lord. He would have otherwise, my lord, argued this, but
Achha, that one.
some urgent matter, my lord, is right.
Yes.
My lord, before I deal with the contentions which have been advanced by Mr. Ghosh, my lord, kindly for a moment, my lord, take section 88 of the Trust Act, because, my lord, that will be, my lord, germane for the purpose of dealing with the first submission. Lordship would recall, my lord, one of the, in fact, I just place the Trust Act and I'll come straight away to that. Advantage gained by fiduciary.
Yes.
Where a trustee, executor, partner, my lord, kindly marks the expression agent. Agent, director of a company, legal advisor or other person bound in a fiduciary character to protect the interest of another person. Then, my lord, kindly also marks this expression by availing himself of his character, gains for himself any pecuniary advantage, or where any person so bound enters into any dealings under circumstances in which his own interests are or may be adverse to those of such other person, and thereby gains for himself a pecuniary advantage, he must hold for the benefit of such other person, to such other person, the advantage so gained. Now, my lord, Lordship has already, my lord, seen what is the plaint case. Before I answer what Mr. Ghosh's submissions are, kindly have a look at my lord's order. When the application was first moved, and then, my lord, I will deal with the because, my lord, the facts will come back to your lordship, my lord. No, no. The lordship will straight away come to page 3 of my lord's order. Lord, in all, as in all section 88 cases, my lord, there is a concept called, my lord, tracing, where you trace the funds, my lord, this was done. And then, my lord, kindly see the last two lines of page 3. This court finds that the deceased was working with the plaintiff as accounts manager and has earned confidence and trust of the plaintiff to the extent plaintiff relied upon the said deceased for looking after the personal finances of the plaintiff. After the death of the deceased, the plaintiff verified the accounts maintained in ICICI Bank, and the plaintiff came to know that the deceased during the lifetime fraudulently transferred the amount of 8 crore 95 lakh 50,000 in several accounts. The plaintiff has also enclosed several accounts which prima facie satisfied that portions of aggregated amount of 9 crore 50,000 lying in the hands of the deceased and subsequently in the hands of defendant numbers 1, 2 and 3 with the defendant numbers 4, 5 and 6 have already been alienated by the defendant numbers 1, 2 and 3. And then, my lord, considering the above prima facie case, and my lord, this order was passed. And my lord, they had preferred an appeal. We have already shown, my lord, that there was an amount which was, my lord, from the wife's own fund. We had, my lord, conceded to that, my lord. The appellate's court order is of 3rd October 2024. 24 lakhs they were permitted to draw.
Yes.
That was in October 24. Because, my lord, this was her own insurance policy. And this was taken, my lord, prior to the marriage. So, my lord, we did not object. So, this was the only modification. Now, my lord, the first argument which has been advanced is that, look, the plaintiff is alleging fraud and unauthorized operation of accounts. But on the same breath, it's an admitted position by the plaintiff that he had authorized the deceased to operate the bank account.
Yes.
Therefore, once you say that I have authorized somebody else to operate the accounts, that is, the OTP would come to him and he would operate it. Whether it is fraud or not, you cannot have a prima facie finding. It has to go to trial. Well, this is in essence, my lord, the argument that has been advanced. That it is not a case that his password was hacked or his ID was hacked and therefore unauthorized. And, my lord, a consequent limb of this argument which has been advanced is that for several years, this amount, 3-4 years, this amount has been taken out and it is there in the bank statements. Any prudent person will check his accounts and will find these things. Therefore, he should have known. Now, the fact that he has chosen to remain silent, therefore, it is a suspicion on the prima facie case. Well, this is the sum and substance. Well, my first submission in answer to this is, in all cases of a fiduciary, well, we call a person fiduciary because, my lord, the fiduciary has the authority, which is, my lord, that's why I started with section 88. My lord, lordship will see it like trustees, executors, partners, agents, directors, legal advisors.
Fiduciary relations.
So, my lord, here, my lord, it's a case of agency in the sense, my lord, I'll show the pleadings also once. Lord, he was, and lordship has recorded it, he was my accounts manager in the firm and I trusted him so much that, my lord, my personal finances were also handled by him. And that is why, my lord, and it is also the plaint case, the degree of trust was this much that, my lord, I had allowed him to operate the internet banking account and I had also, my lord, he had his own mobile as, my lord, that account there. Now, my lord, what was not told to your lordship when this argument was advanced, my lord, lordship will kindly see the petition once. When does this happen? My lord, all this is happening during COVID. Because, my lord, COVID, lordship knows, my lord, and because of the age of the plaintiff also, my lord, there was, my lord, restrictions on physical banking and all that. So, my lord, the pleaded case is, and I shall show your lordship, the pleaded case is that at this ICICI bank account branch, the deceased had its own account. So he said it will be easier for me to operate if you also open your account in that bank. And it is on this basis I opened the account there. And my lord, I made him that because by that time he had earned my trust. So, my lord, my first submission is that in all cases of a fiduciary, of a relationship which has a fiduciary character, my lord, an authority is implied. Just as, my lord, in every cases of agency, my lord, the agent has an authority to do the acts of the principal. But now then, my lord, the question will come that which are the acts which are within the scope of his authority and which is outside. My lord, we come to the principles of agency, my lord, in the Contract Act. I will trouble your lordship later, not now. So, my lord, my first submission is that the very fact that I had authorized himself does not in any manner, my lord, mitigate or lessen the circumstances of the fraud.
Okay.
Because, my lord, every cases of a fiduciary character, my lord, has an element of authority, and that is why, my lord, we call him that he is discharging obligations fiduciary in nature. Where, my lord, and the next expression is, if lordship has seen section 88, by availing himself of his character. That is, my lord, the agent or the person discharging the fiduciary obligations is availing himself of his character. That is the character of the principal. So here, my lord, when the deceased was authorized to operate the bank account, the deceased was availing himself the character of Mr. Mehrotra, the plaintiff, and he was discharging his obligation. That is why, my lord, his role as a fiduciary and, my lord, this section 88 is there.
Correct.
So, if this is so, the question is whether he acted within his scope or outside his scope. Now, moment this question is asked, my lord, the next line of argument which was advanced was that, look, in our affidavit in opposition, I'll show the pleading, my lord, in section 19. Look, in our affidavit in opposition, we had said that the plaintiff has picked and chosen some of the transactions. There are transactions, particularly 2 instances or 25 lakhs and odd, these have been mentioned, which is not falling under the fraudulent transaction. And it is only when we make out in our affidavit in opposition, in the reply, affidavit in reply, a case has been made out that no, these are genuine transactions for share commission and all that. Therefore, the plaintiff and the deceased had earlier transactions. Now that the deceased has died and is no more, they are raising all this. So, to know the real nature of transaction, and we being the wife and the minor daughter, we do not know the real nature of transaction, and it is unfair to say that fraud has been perpetrated. This was, my lord, a corollary or an offshoot of the first line of argument. Now, my lord, the answer to this is, before I go back to para 19 of the petition, my lord, when I plead fraud, and especially in case of a fiduciary character, and, my lord, we talk of agency or principal agent relationship is there, element of trust is there. But if there are 10 transactions and I question 4 or I question 8, but I don't have to show transactions which are positive in nature where there is no dispute. I will only show the transactions which I am saying is beyond the scope of authority. Now, once I say it is beyond the scope of your authority, and I point out, my lord, the defense can't come up and say that, well, there are 3 or more transactions which you have not challenged. So, if they were within the scope, the rest are also assumed to be within the scope. My lord, this cannot be an argument. So, my lord, and my lord, when I say that these are the 6 or 8 transactions which are beyond the scope of authority, and I point it out, my lord, the onus shifts on them to show that no, this is similar to the earlier transactions, or you can say I had these transactions. If you can't explain them, you can't say that there were other transactions where money was routed. Yes, money, but I am not denying that I had authorized him to operate my account and there were transactions over there, because my pleaded case is that I had authorized him.
So your question, your answer is that with regard to the transaction which is illegal,
which is beyond the scope of authority. Correct. Now, my lord, apropos this, my lord, kindly see paragraph 19, my lord, the entire paragraph 19 of the petition.
Yes.
As would appear from the statements made herein before, the petitioner reposed trust and confidence on the said deceased, who was bound in a fiduciary character to protect the interest of the petitioner. The said deceased was availing himself of the character of the petitioner by being authorized to operate the said ICICI bank account of the petitioner, as well as the said KMB account. My lord, KMB is the Kotak Mahindra bank account of the petitioner. The said deceased, by unauthorizedly operating the said bank account of the petitioner in collusion with the respondent number 1. My lord, why I say collusion with respondent number 1? Because even when he was alive, my lord, there were direct remittance in the account of the wife, which we discovered later.
Yes.
And by removing a sum of 9 crore 50,000, that is, my lord, 8 crore 95 lakhs 50,000 in one and 5 lakhs separately,
Yes.
has gained himself and his family members and associates, including the respondent numbers 1 to 3, of a pecuniary advantage. The transfer of the entire sum of 9 crore 50,000 by the said deceased, as stated in the paragraphs herein above, by unauthorizedly debiting the said ICICI account of the petitioner and the said KMB account of the petitioner, was not only to cause unjust enrichment to the said deceased by perpetrating fraud upon the petitioner as stated herein before, but also to gain a pecuniary advantage for himself and or his family members and associates, including the respondent numbers 1 to 3. By reason of the fact the deceased was and or in any event would be otherwise deemed in law to be holding the advantage so gained, namely the sum of 9 crore 50,000 for the benefit of the petitioner. So, my lord, the clear plain case and the petition case is that the deceased was availing the character of the plaintiff.
Yes.
Once I say that he was availing my character, my lord, the authority is, my lord, squarely under section 88.
Correct.
And thereafter, my lord, after availing my character, he is operating my accounts as if I am operating it. So this authority will not imply that anything and everything done is within its scope. My lord, para 20 is also, my lord, a similar pleading of section 88. I'll come back. My lord, may I just go slightly back to show, my lord, page 9, part of para 9A, my lord, sub para A. Because, my lord, one issue has been raised, why after 4 years or after he has expired? Lord, kindly see when this account started. My lord, COVID, my lord, lot of people were having problem, my lord, and that is why he had earned so much of confidence. My lord, internet banking operations, my lord, everybody were not comfortable, and this is the specific case. A, after the onset of pandemic, in or about June 2020, the petitioner opened a savings bank account with respondent 4 bearing number so and so at the Bada Bazar branch of respondent number 4 at Calcutta Street at the address mentioned in the cost title, my lord, which has been referred to as the ICICI bank account. The said deceased at the material point of time already had an account with the Bada Bazar branch of respondent number 4. The mobile number and email of the said deceased were registered as official mobile number and email in respect of the said ICICI bank account of the petitioner. The said deceased was authorized by the petitioner to operate the said ICICI bank account of the petitioner by way of its net banking operations, and the said deceased was privy to the password and other confidential information required for the purpose of accessing and operating the said ICICI bank account of the petitioner. So, my lord, everything is happening post-COVID when physical, my lord, proximity was restricted. And, my lord, this is in the teeth of the deceased having a Kalakar branch account, prior account. So, he says that you open it here, it will be easier for me to operate. So, this is the background. And, my lord, from 2020, at least till 2022, there is judicial recognition that the COVID scenario continued. My lord, we have the Supreme Court orders and all that. And, my lord, already I have said that he was my accounts manager who was doing it. Now, Lordship will come back to paragraph 20. Lord, in fact, before I go to paragraph 20, kindly have a look once at paragraph 14. Lordship saw, my lord, there was a breakup of 8 crore 95 lakh and 50,000 and odd and 5 lakh. That what I was telling your Lordship will find that at para 14.
Yes, 4th April 2020.
Petitioner being further suspicious discovered that an amount of 5 lakh had been unauthorizedly debited from KMB account of the petitioner and transferred to the account of the respondent 1. My lord, on one hand, she is saying, I don't have any privity. She can't explain why. How can money come directly from my account to hers? And this is happening in COVID. This is in June.
Yes.
Sorry, April.
No, April 2020.
April. Well, COVID, my lord, lockdown and everything with March 2020. And then, my lord, we have given, my lord, the breakup is elaborate, the particulars are elaborate. Kindly make a note that there is no explanation as to why so much of money was transferred to the account of the deceased or whatever was transferred directly to the account of the wife. There is no explanation. But the defense is admission and avoidance. My husband has died, I do not know anything. My income tax returns may not show so much of income, but this is my one.
Yes.
And Millard, in this background, kindly see one paragraph of their opposition, page 7.
Page
7.
Yes.
At page 7, subparagraph B. In fact, Millard, I place A also. Millard, there is tacit admission that Millard, he was discharging fiduciary obligation. Admission 1 in subpara A, second sentence. That apart, deceased also used to provide professional, financial, management and investment services to the petitioner. Deceased was an extremely knowledgeable person in the field of finance, stock market and investment. Then B, I state that the deceased was an honest person who used to earn his livelihood out of sheer hard work and purported himself along with his family, including me and my daughter. The deceased had various sources of income, which included the salary from partnership firm. Well, Lord, this is nobody's case that it's his salary, because, well, Lord, it's my partnership firm, that's a separate aspect. Now, let us assume the second can be correct. Payments from petitioner number 1 towards financial management and investment service, including commission from shares mutual fund transaction and independent income from share market transaction and other investment, among other things. Now, let us take the second aspect at face value. So, if they have received money to the extent of 9 crores towards commission, then, my lord, he would have to show that I have transacted or he has transacted for me, my lord, at least a huge percentage of somewhere around 90 crores or something to earn a commission, whatever percentage he may claim. And those transactions, my lord, it has to be either in mutual fund or shares. There has to be, he has taken this money, he has invested in shares, shares have given return, or and he has done this. And on one breath, he is saying, I am the financial manager. And my lord, the onus is being shifted on me to say that I have suppressed everything. But I am saying it's fraud. I do not know how you have taken it out. And my lord, the entirety has been now being said, my lord, this is where, my lord, with greatest of respect, my lord, in a case of fraud and in a case of an agency, once I say these acts are beyond the scope of authorization, my lord, the owner shifts and the burden is on them to show that no, you had authorized me for the act. And my lord, this burden is not discharged merely by saying that, look, you have admitted that I had the OTP and that. And particularly when you are saying that I am an experienced financial management or whatever, I have made towards commission from shares and mutual fund, you have to give the particulars.
Yes.
And my lord, it cannot be that this will be gone into in trial, but you vacate the interim order and I'll run away with the money. Because, my lord, there are two things. Either, my lord, she says it is my money. That's a different aspect altogether. I have an independent source of income. The affidavit admits she had nothing of her own. All her income was rooted at the cost of her husband. And the second, it is an admitted position that husband used to do others, and if they are saying these are valid money, well, they would have to show that, well, these so much of to earn commission worth 9 crores, whether in 4 years, well, there has to be transactions, whether that much of transaction at all took place.
Yes.
My lord, in fact, my lord, he has annexed his. I'm sorry, we have annexed, my lord, at page 572 to 586. My lord, that from his own, my lord, documents, my lord, showing that he used to get 12 lakh rupees, my lord, by way of commission, so far as the work that he used to do. And my lord, in spite, and his personal loss for his personal tradings, my lord, is 1 crore 69 lakh 57,344. So, my lord, if he had other source of income, my lord, this would have been in a positive figure. You can say I had other source of income. My own personal trading, I have earned a profit of 9 crores. I can understand that. But, my lord, we have shown money has come from Mehrotra's account to, my lord, plaintiff's account to his. And, my lord, let us assume for a moment, my lord, he is giving me financial consultancy. My lord, then, my lord, there are two ways of operating it. He will take money from my account, invest it directly in the market, and, my lord, it will, the whatever returns that profit I make, my lord, he will take a commission. So, my lord, the other way of establishing it is, look, I have engaged transactions on your behalf.
What he has done for the benefit of the company, that is to be shown then.
Yes, or for me, that I have earned you 100 rupees, I have taken 10 rupees legitimately.
That is okay.
His source of income is from knowledge. There is no record of all this then.
Well, my learned junior rightly points out this page 7 subparagraph B. Well, this has been affirmed as true to knowledge, but my lordship will not find any record of this.
Yes.
And, my lord, what, my lord, this leads us to what was, my lord, tried to be, my lord, now, my lord, trend has come, my lord, where as if, my lord, any document in affidavit in reply, submissions are made, court cannot look into it because a new case is being made out in the affidavit in reply. My lord, with respect, no. My lord, this affidavit in reply is only to deal with what you are bringing out in the opposition. My lord, I independently, I am not required to, my lord, rely on any of these documents, my lord, so far as my case is concerned. Now, in the affidavit in reply, we had relied on an email at page 592. When the deceased, and this is an email of, my lord, 9th April 2024. April 24, he passed away on 12th June 2024. Enclosed, please find final profit loss report of share trading 23-24. Well, this we are showing it to show, yes, the genuine transaction, this is what he has given. And it is parameteria to what they are saying. Year-to-year profit overall and accrued commission statement of myself. Hope you find the same in order. I will withdraw only in November, December, as I will need funds at that time. And he annexes the profit and loss statement where his commission till 24 is 12 lakhs and not 593.
No, 12 lakhs 98,248. Receiver, yes.
Yes. And by this time he has siphoned off crores of rupees. And when we disclose this, because they make out the case, it comes that no, the court will not look into this. These are all new documents which have come in. We do not know anything. And it is a new case that is being made out. Plaintiff has suppressed. This brings me to the next point which they have argued. That we have suppressed that there were actual transactions between the plaintiff and the deceased. Because what has come out in the affidavit in reply ought to have been there in the petition. And in affidavit in reply, what has come out, majority of it, or in fact all of it, is to deal with what you have contended in the opposition. Now, Lordship knows suppression has to be of material facts. Now, apropos the cause of action which has been pleaded in the plaint, vis-a-vis section 88, fiduciary character, and utilizing the character of the plaintiff. The only thing that is required to be pleaded is that which are the unauthorized acts. I don't have to plead the authorized acts.
Yes.
It is only by way of your defense. You say that assume these acts also to be authorized because there are some other transactions which are authorized. This is, my lord, the purport of the opposition. Now, to counter that, I said that, look, even if you look into those authorized transactions, the deceased 2 months ago forwarded the, yes, he used to do share transfers for me. His commission statement is there from his own mail.
Yes.
So therefore, my lord, these documents, my lord, will negate what the case they are trying to make out. It is not a new case at all. Then comes, my lord, the next aspect. My lord, vis-a-vis the question of, my lord, application of section 60 of the Code of Civil Procedure. Now, my lord, an argument has been advanced that by virtue of section 61 KB, insurance policies on which restraint order has been passed, they are exempted from attachment. And therefore, the injunction, at least on that, has to be vacated. Now, my lord, they have also relied upon Sarvati Devi, and they don't dispute the proposition that, my lord, in Sarvati Devi, Lordship has seen, my lord, a distinction has been made, my lord, when the money comes from the insurance company and comes into the till of the account of the estate. My lord, legally, there is what they call blending of the money. That is, it acquires the character of the estate itself. Now, Lordship will find in section 60, subsection 1, my lord, if I may read the proviso, section 60 of the Civil Procedure Code, provided that the following properties shall not be liable to such attachment or sale, namely, and then, my lord, if Lordship straight away comes to KB, all monies payable under a policy of insurance on the life of the judgment debtor. My lord, kindly marks the expression payable.
Correct.
This is so far as KB is concerned. There are other categories mentioned.
Yes.
I am not troubling your lordship. Now, my lord, kindly see explanation 1 or explanation I. the monies payable in relation to matters mentioned in clauses G, H, I, IA, J, L, and O are exempt from attachment or sale. Then, my lord, very important, whether before or after they are actually payable. And in case of salary, the attachable portion thereof is liable to be attachment, whether before or after it is actually payable. So, my lord, in all these cases, the law is being clarified that you cannot attach it either before or after.
Yes.
But, my lord, in case of KB, in line with the judgment, due to the doctrine of blending, my lord, once the money comes in, my lord, it is liable to attachment. And that is what, my lord, the law is, my lord. I am in reply, but since they have cited, my lord, all that has to be done is, so far as the money which has not yet been disbursed from the insurance company, my lord, it will come into the account of a receiver or separate account, my lord, and it will be attached. That is the only difference.
Yes.
Because, my lord, the section itself is making an exception so far as KB is concerned. I read KB once again. All monies payable under a policy of insurance. But, my lord, once it is paid, so, my lord, the modification has to be, and to that extent we concede that you can't say that the insurance company will not pay. If it is payable, it will be paid. But once it comes into the till, my lord, it is liable to attachment.
Then it is a normal money.
It is the estate of the deceased. And that is why, my lord, there are 6 categories of cases which are said that you cannot do any attachment either before or after. Correct. Other than these 6, my lord, all, my lord, and that is how, my lord, KB has been also defined. We'll come to that later. Now, my lord, kindly come back to the petition once. My lord, page 7. My lord, I showed your lordship, my lord, A and B. Kindly see, my lord, let us see the defense, my lord, of what was argued, whether these arguments can stand scrutiny. My lord, now kindly see C. I state that salary received by the deceased from the partnership firm was only a fraction of the total income of the deceased. For instance, in the year 2021, the total income of the deceased was 50 lakh 13,000, out of which only 11 lakh 62 was on account of salary received from partnership firm. Similarly, high income levels were maintained by the deceased throughout the later part of his life. A copy of the income tax return for the financial year 2021 is annexed. Now, my lordship will see annexure A once. Huh?
Yes.
Opposition. I know. I'm looking into the opposition. So 2 admissions are here. Salary is only 11 lakhs.
Yes.
Income is, my lord, 50 lakhs. And, my lord, I already showed, my lord, we had given the breakup. My lord, share loss is to the tune of 1 crore and 572 of the petition. We have already given it.
Yes. That you have shown.
Yes. And the entire, that part is not reflected in the income tax return at all, either of this year or any other year. And, my lord, the total income, if lordship even analyzes this, my lord, it will be actually 31 lakh 70,260. My lord, lordship will see, my lord, page 69.
69 of plaint.
Well, yes. Same.
$31 lakh 70,260. Yes.
So salary income is 11 lakhs, total income is 31 lakhs and odd. And, my lord, the entire money that we are, quantum of money that we are talking about, my lord, in a span of 3 years or 3.5 years is 9 crores and odd. So even if I take the maximum figures also which they have said, my lord, under no stretch of imagination, that there is even a possibility, let alone a probability. Then, my lord, kindly come back to page 7. My lord, D. I state during the lifetime of the deceased, I was a housewife. Nonetheless, the deceased used to enable me to have independent income in my name. My lord, what source, by what method, by what means, nothing has been stated. The deceased used to maintain my books of account and file my income tax return. I am still in the process of ascertaining and accumulating data and crave leave to refer to it. So, my lord, let us look at it this way. The deponent herself says she was a housewife. The deceased used to do it. The deponent is still in the process of ascertaining the data, but the deponent says these are my money, court cannot injunct it. How can that be? On one breath, I say I have nothing. I am in the process of finding out. I am in the dark. And on the other breath, I say, no, my husband had done everything. These are my husband's money, therefore my money. Then, my lord, I state. I state that the deceased in his wisdom had invested in life insurance policy with respondent 6 to 9. Such investments made from hard-earned income of the deceased. Upon demise of the deceased, Amalat, kindly see the admission. I have received a sum of 4 crore 50 lakh from these insurance companies where the deceased held policies. Summaries have been given. So, my lord, if we take KB, my lord, it has already come in the estate 4 crore 50
Already.
and, my lord, part of it has been removed.
Yes.
Lord, we have made an analysis. I'll come to the insurance policy analysis later. My lord, may I just quickly show what is the main purport of the defense? Main purport of kindly come to, my lord. This is E talks of, my lord, the summary of policies and bank accounts that, my lord, these money had come in. Then, my lord, F. I state during the lifetime of the deceased, my daughter and I were fully dependent for our financial equipment since the requirements. Since the demise of the deceased, my daughter and I have been financially dependent upon the money received in respect of the said endowment and insurance policies which have come to our aid. Such policies were protecting us financially to ensure our well-being and day-to-day survival after the demise of the deceased. Such insurance money is immune from being injuncted or attached and cannot be taken away from us under any circumstances. Now, this is a legal defense in line with KB, but with respect, my lord, once the money comes in, and, my lord, it is shown that it is, and, my lord, the admission is, it is not neither the money of the deponent nor of the minor daughter. The admission is the money is of the deceased. And once the deceased, and I have shown the route, I have traced the money, how it has come, my lord. They cannot, my lord, when he is discharging a fiduciary obligation, my lord, they simply cannot, my lord, have any case so far as these are concerned.
Yes.
And, my lord, this was the main thrust of their argument, page 9G. I state that petitioner has narrated a false case which is so unreasonable that no prudent person would ever believe the same to be true. The petitioner has contended that from 2020 to 2024, while the deceased allegedly operated the petitioner's bank account doing transaction worth crores of rupees, did not even once learn about any such transaction. It is impossible that an educated person who is well-to-do business and millionaire would not know his bank account status. My lord, all this can be said because the petitioner was foolish enough to allow and disclose his bank account, operate him to bank account. And, my lord, in every case of fiduciary, whether as an agent, a banker, as a trustee, my lord, this element is there. And, my lord, 20 to 2022 was COVID. And that time, my lord, internet banking operations, my lord, they were not comfortable. He was doing it. So there is no answer to any of these questions. My lord, the routing, lordship will find that my lord, tracing back has been made, my lord, to the extent it is possible. 9 crores and odd, we were able to trace that it is from my money. You have done that.
Correct.
Now thereby, my lord, there are now it is coming out other monies which we are unable to trace. We shall look at it later. But as of now, I am restricting myself to 9 crores and odd, which is the plaint case over here. Then, my lord, one more paragraph. Page 10. My lord, fourth line from the top of para J. The transactions prima facie appears to be dues which my husband was entitled to. My husband, by use of his skill, provided finance management service to the petitioner, for which was awarded handsome returns as commission in respect of the same. Well, let us assume that this is correct. Then, my lord, the income tax return of the deceased would have showed income of crores.
Yes.
I have been able to retrieve some WhatsApp chat history of the deceased with the petitioner. Copy is there, wherefrom the deceased was enabling the petitioner to make profit of crores of rupees through equity business, for which the deceased was entitled to handsome commission. Well, the handsome commission has been disclosed and admitted in the mail of the deceased was 12 lakhs and odd. That is why we have disclosed it. And will kindly see the annexure D. These are WhatsApp messages of August 2021. Kindly see that. Page ta bolo, annexure. But it is at page 98. Annexure D.
Yes.
Well, Lordship will find the date.
21st of August.
Yes.
Second.
Sorry, this is 18th of February 2021. It's an American format.
Yes, 18 February 2021.
18 February 2021. I read it wrong. We have touched profit of, well, kindly see, profit is of what? 2 crores. 206 lakhs is 2 crores till now in equity business. Net of interest is 190 or 1 crore 1.9 crore. Target by 31st March is to reach 2.25. Even after my commission, your net retainage should be approximately 1.9. Keep fingers crossed. And Millard, he gives. That is why the mail was given. And Millard, if I make, Millard, 1.9, Millard, profit 12 lakhs, 13 lakhs, Millard, I will willingly give, and that is what we had given. So that is the background why I don't have to disclose this to establish my case. My lord, it's 4:30, my lord. Lordship gives me 15 minutes, my lord, any other day. And I must be candid, my lord, why I am asking this time also, my lord. There are not many matters, my lord, where now I have the luxury of having a senior. In this matter, my lord, I have Mr. Mukherjee leading me. My lord, I would really like him to, my lord, wind up. So any day, my lord, if Lordship gives. And Interim is till 10th. If Lordship gives it prior to 10th, it's all right. Otherwise, my lord, Lordship will tell.
But I would also pray before the holidays, because I will make one small prayer that before the holidays, a certain amount be released. If my learned friends finish, because out of humanitarian reasons, also the division bench release some. And prima facie, of course, I'll have something to say. But in case he doesn't finish before the pujas, then your lordship will keep it as to be mentioned.
But just one more, the decisions which they have cited, Mr. Mukherjee will distinguish that, my lord, it should not take more than half an hour. My lord. If it is on the 10th, any time, my lord, Mr. Mukherjee can.
Yes.
20 yes, are good in reply, but due to paucity of time, hearing could not be completed. Let the matter appear on. कुछ है डेट है 10 कितना बजे 18 September at 12:30.
18 September. Then lordship increase just extends the interim order till 19th.
Interim order is
or 20th.
extended. Interim order is extended till
24th of September 2025
Lord,
or until
my lord, 18/12/30. I am deeply obliged.
Great.
My lord, before your lordship rises, my lord, may I have my lord's kind leave to mention a matter, my lord. The interim order is expiring today. There is that Duvarthim matter.
not in the list.
No, it is not in the list. You're
Notice.
mentioning upon notice. The last order does not mention the interim order, where your lordship fixed for my lord, defend number 6 is my lord, judgment, and for the others hearing would be fixed.
That one.
But my lord, the interim order, if your lordship kindly sees the 20th August date, it is
2nd
still the
September.
2nd of September.
After vacation.
So my lord, if a date could be fixed, my lord, maybe after the vacations, whenever, my lord.
Counsel for the plaintiff mention the matter. Have you issued the notice?
Yes. Notice mention. Yes, my lord, I'm mentioning about
Notice to the defendants and submit that interim order is still today and paid for extension of interim order. In view of the above, interim order is extended. When the matter is fixed.
But it has not been fixed, my lord.
Interim order is extended till 24th of September 2025 or until further order, whichever is
My lord, your lordship will keep it after the vacations, my lord. Your lordship will keep it after the vacations.
before 25th September.
But could it be after the vacations, my lord? I may not be there, my lord, due to some medical reason.
But other side is not there. If I give the long date, other mention that we'll see to that.
Fair.
24 September. No?
Great.